confidence
Yes, Mr.
make a
Mitra.
breach of protocol under exceptional circumstances. Otherwise, I wouldn't have come because I've seen the note. The Lordship may well ask me, Mr. Mitra, have you forgotten to read English? To which I will say, no, I have not forgotten to read English, but exceptional. If it's not exceptional, just penalize me with cause the senior counsel to take up your Lordship's time. Thing is, my lord, the NCLT is a statutory tribunal, has to work within the 4 parameters of the law. I had filed a writ petition challenging the very jurisdiction to hear a particular matter. Jurisdiction, not merits. Jurisdiction to hear a particular matter. They adjourned it on the first day when they knew the writ petition was filed. Thereafter, on Tuesday, my lord, they pass an order. When the writ is pending, they are appearing. The parties are appearing during the pendency. My lord, this is judicial overreach, if I may say so. Lord Hewitt would call this a new despotism. What is this, my lord? When the matter is pending in the High Court, you render my writ infructuous by passing an order.
Matters are pending for so long, Mr. Mitra.
No, that doesn't mean that the NCLT will pass an order. Kindly, I made an application to bring the order on record. The writ is pending. It was by Justice Moshmi Bhattacharya. She passed an order saying that, Mr. Mitra, you ask for adjournment, they will grant adjournment if they know that I'm hearing the matter. Why should I presume otherwise? I mentioned before NCLT, they passed an order saying that no, because writ is pending, we will not hear. Suddenly, what is the urgency to pass an order?
They passed a final order.
Final order.
Mr. Mitra, let us wait for some.
No, just one thing, my lord, because the money will be transferred. Once the money is transferred, my writ goes, the whole thing goes. Just let my application, my lord, I have stamp punch affirmed and approved on Monday, has to be mentioned.
No, Mr. Mitra.
When this is on Monday to be mentioned, my lord, I'm not asking for anything today.
You've already mentioned it, Mr. Mitra.
Just on Monday, my lord, just this thing. Otherwise, my lord, what will happen?
No, Mr. Mitra, I'm sorry.
On Monday, my lord, let it appear to be mentioned. And in the meantime, my lord, let it be taken for granted that no one will aggravate matters any further.
No,
Neither.
I'm sorry. Yes.
Well, the writ should come on Monday then. The affidavits are complete.
No.
At least this application, well, this 2-page application, bringing on record, because I will just ask for stay. I will just ask for stay, and then after your lordship relegates me anywhere, I will go. Just for stay, because if that is not granted,
You have filed that application.
I'm going to file it today,
After
right
filing
now.
After filing it, Mr. Mitra, get it mentioned on Monday. Applications I may take up also.
Well, let it come on Monday, then I'll serve.
So first, file it before in court.
Kindly give it, if they, I'll file it.
No, Mr. Mitra, in normal course, please. No.
Sir, I will not.
Wait.
Mention on Monday. All the mention is nothing doing. You mentioned it on Monday. Hand over. Ashani, can you
Your lordship will permit mentioning on Monday, my lord.
Yes, yes.
One, my lord, very small, my lord, request, my lord. I know, my lord, I know again, my lord, I am breaching protocol. I don't call it despotism, but my lord, the urgency is all the same. My lord, the state government has, my lord, served me a notice, my lord, threatening to vest my land and my lord, impose other, my lord, penal measures, which is going to stop, my lord, the construction over the Uttarpara factory of Hindustan Motors, where more than 5,000, my lord, flats have been, my lord,
Testing will take a long time, is it?
No, they have threatened to, my lord, do it in 15 days time, which expires tomorrow. We had been trying to reach out to them, my lord, to find it.
So why didn't you
Final
mention
order.
it on Monday? No, Mr. Please come back on Monday.
My lord, Wednesday.
Well, let's come back on Monday.
Subject to lordship's pleasure, may be permitted to mention one matter, my lord. My lord, I have filed the writ, my lord, day before yesterday. My lord, the emergent situation which is there, I must be very candid with your lordship. That we are, my lord, we have deployed, say, my lord, security personnel at WBSPL. My lord, our dues is about 58 lakhs. When we have demanded our dues, my lord, what they have done, they have unilaterally, my lord, given the notice of.
A minute lost here in mentioning is a minute lost in hearing matters, which are already on the list. They're already on the list. They have no fault. So let me hear those matters first, please. No.
My lord, 79 security personnel.
No. I cannot spend so much time on mentioning. No, I'm
Lord,
sorry.
with your lordships, kindly, my lord.
There are 2 matters which are on the list. In the unlikely event it is not called, will your lordship kindly, my lord, take it up, my lord, in the second half. My lord, leave was obtained on Wednesday by Mr. Shuddhaswata Banerjee. Considering the urgency, lordship had, my lord, granted us the leave, and my lord, the matter is appearing. It's 32 and
2 PM
33.
fix such a.
In the unlikely event, it's not called, my lord.
If it is not called on, what is the item number?
32 and 33, my lord.
233.
My lord, I expect it to be called just in case, my lord, it is not called, my
No,
lord.
may not be. May not be called also. So, mention it 2 then.
I'm grateful.
My lord, item number 20 is a matter, my lord, which relates to.
Rest of the matters, please wait.
My lord, police overaction, my lord. It's.
No, item 20 is not so urgent. Yes.
My lord, may I have your lordship's kind leave to?
No, you may not. May not.
Matter, my
Call
lord,
on the list, please.
for non-prosecution.
Matters, but requisitions have been said, my lord. I have been.
Item 1 dekhecho?
Jalpaiguri item number 1.
Kindly, my lord, takes up the matter, my lord, 2 PM, my lord.
আর 10টা একটা ফিক্স আছে তো। আচ্ছা জলপাইগুড়িটা কেন ঠিক আছে। WPA 1 এটা কোনটা রাখছো? জলপাইগুড়ি matter who is appearing? Yes, what is that?
As you have obtained a leave, dear lordship, you have served, dear lordship, the government pleader's office has been served, dear
Urgency,
lordship.
yes.
Lordship, the urgency is that, your lordship, it is all with regard to a plant which is operating at Fulbari, Jalpaiguri. Now, this plant is designated a particular area within the domain of 75-kilometer radius as per the biomedical rules 2000 by Biomedical Act 2016. Now, pursuant to that, when it is operating, it has to access to all the hospitals and health institution within a radius of 75 kilometer to be extended up to 150-kilometer radius. Now, what has happened, your lordship, there are the respondent number, the respondent number 10, your lordship. Now, this particular company is being allowed to have an authorization, your lordship. Without the authorization, none of the plants can operate. Now, this plant is being allowed an authorization to set up its own plant, which will be within a radius of 16.60 radius, which is not permissible under the Act, your lordship. I have taken one plea in this and this writ petition, your lordship. This respondent number 10, your lordship, it is in hand with the involvement of the respondent number 5, your lordship. Kindly takes.
Who are you?
Lordship, I am the.
You are a competitor.
It's not my competitor, your lordship. The
You're also on the same business.
Lordship,
Then-
the rules provide, your lordship, that within a zone of 75-kilometer radius, Rule 7.3 specifically provides that I am setting up a plant.
Yes.
Lordship, the plant requires substantial investment, and thereafter, when the plant is set up, then zone-wise there are the government notifications which comes up, and zone-wise the areas are distributed.
Yes.
Now, for the
You are already operating there.
I am already operating, and I am an authorized operator under the definition of
What
section
is the relevant communication or whatever decision they have taken,
Lordship.
which you have impugned here?
Lordship, then the last annexure P13, page 174.
174, yes.
Lordship, this is the authorization which is being tried to be granted. Lordship, this is the minutes which shows for environment clearance and the proposed plant project proponent MSSNG.
Yes.
And thereafter, your lordship, at the top, proposed common biomedical waste treatment facility at plot number Moza, such and such, jail number Rajganj. Lordship, this, if it is allowed to come, it will come much closer to the plant which is existing. And that cannot take place under any circumstances in the existing of the relevant provisions of the Act, your lordship.
Show me the provision, please,
Lordship.
of the Act.
Lordship, the Act is starts from page 59.
Yes.
Lordship, may kindly takes
What
page 59. It is
Which
the
section?
Biomedical Waste Management Rules 2016. I'm sorry, your lordship, it is the Act rules.
Yes.
And Rule 7. Lordship, page 65.
I've got it. Yes.
Lordship,
Which
the
subclause?
treatment and disposal. Rule 7.3, page 65.
3.
No occupier shall establish on-site treatment and disposal facility.
All the you are available there
But-
within 75
Lordship,
kilometers, they're doing
I
this.
am available. I am giving service.
What is your interim prayer?
Lordship, lordship, this 75 kilometer. This is the
Yes,
lordship.
it's in there.
Lordship, my prayers, my interim prayer is at page 55.
Page?
Page 55. Page 55, your lordship. My interim prayer. এটা দিতে বলো না, affidavit of service এর এটা originalটা।
Acha, only show me something from that that
Lordship.
it is being set up on-site for on-site treatment and disposal. Oh, acha,
No,
it's,
Lordship, the
it's by
same
definition.
thing. Lordship, just a page ahead, 173. The map shows the distance.
This is respondent number 10.
Lordship, this is
This is
respondent
SMG.
number 10, and this has been already granted the recommendation. And with regard to the other two respondents, 11 and 12, their authorization is in process. That cannot happen.
They are also within the same zone.
Same zone, same zone.
Learned counsel for the petitioner contends that the petitioner is already operating as an unit for bio-waste disposal. Full stop, next para. However, comma, contrary to rule 7 within bracket 3
Of the Lordship, page 50.
of the biomedical waste management rules, comma 2016, comma 3 other facilities, comma being respondent numbers 10, 11, and 12 are on the process of getting recommendation to set up facilities within the distance of 75 kilometer. Full stop, next
Radius.
para, it is submitted that respondent number 10 has already been granted such recommendation, whereas the recommendations proposed for respondent numbers 11 and 12 are in the process. Full stop, next para. Since the petitioner has made out a strong prima facie case regarding apparent contravention of rule 7 within bracket 3 of the 2016 rules, comma, the writ petition is required to be heard on merits. Full stop, the petitioners shall serve copies of the writ petition. No, you have already served.
Lordship, already served.
Shall serve a notice on the respondents indicating that the matter shall next be listed in the monthly list of August 2023. Full stop. The respondents shall file their affidavits within 3 weeks from date. Full stop. Reply, if any, within 1 week thereafter. Full stop. There shall be stay of operation of the recommendation granted to respondent number 10 from setting up a biomedical waste management unit.
It's a common biomedical waste treatment facility
Acha, treatment facility
at
in terms of the recommendation annexed to the present writ petition.
page
Full stop.
174, Your Lordship.
Very well. To the present writ petition, bracketed page 174 of the same. Bracket closed. Full stop. The respondent authorities shall further remain restrained from granting any similar permission to respondent numbers 11 and 12. Full stop. The interim orders shall operate till August 31, 2023 or until further order, whichever is earlier. Thank you.
Grateful to Your Lordship. Lordship, may I be granted leave to file the affidavit of service, Your Lordship? It has to be affirmed, Your Lordship.
Affidavit of service shall be filed during the course of the day.
Grateful to Your Lordship.
You have checked up good service has been effected.
Lordship, the Lordship.
If not, then I'll recall my order.
Lordship, all the Lordship kindly takes
You
up.
check up first. You and your junior, please check up.
Lordship, the
I depend
items
on the
have been,
council for
the
this.
items have been received. All the state respondents have received, the Pollution Control Board has received. Only 10, 11, 12, Your Lordship, items received, they show not delivered.
I can't pass my order. I'm restraining them, their recommendation. How can I? How can I?
Lordship kindly takes up item received, it is shown, Your Lordship. Lordship kindly takes
Regarding
up the.
state respondent, 11, 10, 11, and 12, I should
Lordship,
have asked you at least.
state I have served here, Your Lordship.
Not state, I'm on the 10, 11, and 12.
10, 11 and 12, Your Lordship.
If they have not been properly served, I'm sorry, Ms. Ghosh. I have to.
Lordship, they have been served, Your Lordship. They have been served, Your Lordship. Lordship, in the affidavit of service, they have been served.
Take your time, check up the track report and tell me. 10, 11, and 12. You just now said that they have
It
not
is
been
showing
served.
item received. Lordship, it is not showing item delivered, but they have all been served. Have affected
Now.
service.
Received not by them, not by the addressee. Ms. Ghosh, I'm sorry. Sarkas Avenue ESO, Sage Bhavan ESO. I'll record your submission on that then. যা বললাম সেই পর্যন্ত থাকবে it may be recorded here that the order has been passed on trust, since learned counsel for the petitioner submits that the items, the copies of the writ petitions sent to the respondents have been duly received by them. এই order, এটাও part of order থাকবে, বাকিটা যা আছে থাকবে।
Receipt লেখা আছে।
অগাস্টের মান্থলি লিস্ট বলুন।
August.
বলেছি তো। আচ্ছা, তাহলে ওটা বিফোর দি circuit bench, if sitting. It will be returnable before the circuit bench if sitting.
Lordship has granted it till August. Lordship has
31st August,
directed
it will appear in the monthly list of August, but monthly list does not have any meaning then.
Lordship.
So whatever.
Lordship, I'll mention.
Right.
God, I'll mention. Lordship. Grateful to Lordship.
Monthly list na in the first week of August.
Lordship. Grateful.
Judgment টা ডাকো, তারপর 10:30 ডাকবে। বলো এতদিন বাদে এগুলো।
For judgment, appellate side for judgment, item number 1 and 2.
I'm sorry, dismissed both. WPA 13979 of 2023 and WPA 13667 of 2023. Both are dismissed. It's a longish order, but it will be on the website as soon as possible.
Grateful, madam.
Thank you. Grateful. No. পাঠিয়ে দিও, সার্ভার করে দিও। পাঠিয়ে দাও। 10:30.
10:30 matter, item number 6.
Yes, my lord. I wish to appear on behalf of the respondent number 2 to 4. My lord, on the last occasions, my lord.
Yes.
On the last occasions, my lord, my lord, almost concluded my argument, my lord, because only 3 judgments I could not place, my lord, because the paucity of time, my lord. So, so during the course of argument, my lord.
Torodar, can you file very short notes of arguments on?
Yes.
Can you do that on Monday? I mean, you'll get the weekend days or Tuesday or Wednesday.
Monday.
When
Yes,
tell me?
Yes.
So because this has been substantially heard, I
Make
don't
it-
want to repeat the entire hearing.
Make it,
Is that I was not heard.
No, I'll hear you, but I'll make it summary. Yes.
my lord, on the last occasions, my lord, I cited, my lord, 3 judgments.
Yes, you
my lord.
have. Those
Yes,
are
my lord.
already
And
there.
my lord, the Minas was cited, my lords, in support of the enforceability of the policy guideline framed
No,
by the
that-
government, my
I
lord.
have my points recorded, Mr.
Yes, my
Todd.
lord,
I'm
but
being
now,
very
my lord,
frank that since the hearing is spilling over several days,
yes.
so it will be better if you just in a nutshell,
Yes,
in half a page, you can give the points also.
Yes.
I have my points, so just to tally with your points.
Yes, my lord. Today I'm citing
Not
just
today.
3.
Yes,
Yes.
cite your judgments.
Yes, my lord.
I'll hear you.
Yes,
Don't worry. Take your seat.
don't.
But be
My-
short, please.
My lord, friend will get that. I will also not take much time.
No, don't. Please don't. Please.
My lord, I'm
Take
relying.
much time usually.
Yes, my lord, I'm relying a judgment, my lord, reported in 1998, volume 4, SCC 117, my lord. My lord, your lordships raised a questions on that day, my lord, that the Minas dealt with the bylaws, my lord. And my lords, here, my lord, I, my lord, argued, my lord, on the basis of the policy guidelines framed. The touchstones was the policy guideline, my lord.
Yes.
So, my lord, that the scope of interference of the honorable court, my lord, so, my lord, on the
Policy decision?
Yes, my lord, policy decisions.
No, that
Lord-
is very limited.
Yes, my lord, that is, my lord, paragraph 25, my lord. Paragraph 25. Just up, make it short, just after 5 line. So far as questioning the validity of government policy is concerned, in our view, it is not normally within the domain of any court to weigh the pros and cons of the policy or to scrutinize it and test the degree of its beneficial or equitable dispositions for the purpose of varying, modifying, or annulling it based on howsoever sound and good reasoning, except where it is arbitrary or violative of any constitutional, statutory, or any other provisions of law.
Mr. Torodar,
Yes,
this is very well
It is a
said.
well settled.
I'm
my
not
lord.
questioning the policy of the government.
Yes, my lord.
Here, what is being questioned is whether the guidelines which you're saying,
Yes.
they tantamount to have a binding effect on this,
Yes.
on the concerns.
Yes.
Because if they don't have a binding effect,
Yes.
there is no question of reopening the policy at all.
Yes.
If
my lord.
it's binding, then it's a different
Yes.
question altogether.
Yes.
Whether those are binding at all.
Yes.
Everything is not a policy decision.
Yes.
So you have to show me that also.
Yes, my lord. That
This undoubtedly you are
Not
right on
this-
this. It is well settled.
because
We
if it
can
is well, my lord, if it is
policy
lord,
decision generally
my lord,
not
because
interfere.
because there was a distinction, my lord, your lordships raised a questions as regard to the ratio laid down in Minas case, my lord, because Minas dealt with the bylaws, my lord. And here it was my argument before your lordship, my lord,
Yes.
that the policy, my lord, is, my lord, placed in a much higher degree than that of a bylaws. Bylaws confined to a single, it is a very microscopic body and area, my lord. But the policy, my lord, is binding somewhat
So
throughout
for
the
that
country.
precise reason, Mr. Tarokdar, we can reopen bylaws also in some cases.
Yes.
So, but even then,
Yes.
this is a different question I'm putting to you.
No,
Whether
but
this
for-
is binding on
No,
them. Policy decision.
No, yes, my lord. No. My respectful submissions before your lordship, my lord. Why I am citing these decisions, my lord? My lord, the policy decisions framed by the government. How the fixations of price is to be made, how the auctions is to be held, how the manner of determinations of bid premium is to be made. Everything has been laid down in
So
the
this is a
policy.
policy decision.
He said not. So my respectful submissions, that policy decision should be acted upon. It cannot be interfered with unless, my lord, any violations, if there are any violations of fundamental right. That's the ratio in all this judgment, my lord. So that's my respectful submission, that since a policy has been laid down by the government, they has to follow, my lord. They have to follow, my lord. So this is bindings on them at least. And that is why, my lord, I relied Minas, my lord. Minas says that any profit standard, my lord, if it is laid down, my lord, that authorities, my lords, have to, my lord, have to, my lord, comply with that obligations, my lord. They cannot deviate it. If any deviation, the interactions will render invalid, my lord. So that's the ratio of the judgment that, my lord, I submitted. And regarding the policy decisions, my respectful submissions, that since there was no questions of violations of any fundamental right, so the policy decisions is valid and bindings upon the authorities, my lord, because the controlling authority, my lord, has made this guideline, and this guideline was framed, my lord, my lord, with the approval of the cabinet committee of the.
They have not challenged the guidelines. They have not challenged the guidelines at all here. So there is no question of opening that.
No, we have challenged the action of the executive
You have not
authorities
challenged. You're
in
relying on
deviations
that.
of the policy. So
Very
I'm relying on this.
Yes,
That-
obviously.
it is
You're
our
relying on
interest.
that policy.
Yes, Lord, that's
Right.
our
Right. Thank you so much. Yes.
And Lord,
Yes.
to judgment on the same line,
No,
Lord,
then
so
you can
that my
cite it.
learned friend could distinguish. So therefore, I'm just mentioning.
Yes, please cite it. Yes.
Yes, my
Why not? You have
Uh,
come ready. Your junior has prepared the judgment.
Yes, my lord.
Please cite.
2007, volume 4, SCC,
Send them.
page 737,
Have you got
paragraph
copies?
60. Yes, my lord.
Okay. Then I'll just take this one.
Paragraph 16. দাঁড়ান, আমি বলে দিচ্ছি, সব বলে দেবো। That's it. The scope of judicial review of governmental policy is now well defined. Courts do not and cannot act as appellate authority examining the correctness, suitability, and appropriate of a policy, nor the court's advisors to the executive on matters of policy, which the executive is entitled to formulate.
Mr.
This scope
Saratha,
of-
you can give me the paragraphs.
Yes,
Because
but
government
paragraph
is
16,
elected,
yes,
we are
yes.
not elected. Basically,
Yes.
the principle is that
Yes,
they
yes.
reflect the
Paragraph
public's
3, my lord.
opinion.
And my lord,
Yes.
a case, my lord, another case, my lord, is reported in 2005, volume 3, SCC, page 495, paragraph 7, my lord.
Same principle.
Yes, so on the same ground, my lord. That even it could not be varied and annulled, my lord, whatever, my lord, good grounds and good reasonings are there, my lord. Court cannot interfere. That's my respectful submission.
Right. Thank you. Sir. Yes, you know.
Could I answer on the merit regarding bindingness of the policy and otherwise of the policy and non-following the policy of the court?
Take the microphone. Yes, policy. Yes.
Before I may not come to answer the policy that is be sought to be implemented on behalf of the coal India, my lord, I have, my lord, three preliminary objection with regard to, my lord, entertainability and maintainability of this writ petition. My lord, first objection is whether a society can sue by its own name or not. Second, if the writ petition has suppressed material facts which is relevant for adjudication of the dispute, whether your lordship can, my lord, entertain this writ petition in a equitable jurisdiction. Third, when they have participated in the auction, they have participated in the tender. After participation, whether they can challenge the condition, and for which, my lord, I will rely on your lordship's judgment.
There are better judgments. You can cite Supreme Court also. There are several
Yes,
judgments.
Yes, my lord.
Yes.
Now, my lord, kindly.
Why suppression of material facts?
Yes, my lord. My lord, I am very sorry, my lord, so far as this Chhattisgarh Society Registration Act is concerned, I could not, my lord, get a English version of the copy. So, my lord,
This Bengali or Hindi?
it's Hindi, my lord. And
You will have to read it out.
yes, my lord, my
No, you will have to read
yes,
it
my
out.
lord, but I will take assistance of my.
No,
my
you
junior.
cannot. That is the click.
Kindly, my lord, permission. My,
So, Societies Registration Act is there. এটা দেখো না, West Bengal-
my lord, that is
প্রথম-
Chhattisgarh,
প্রথমটাই।
my lord. It is Chhattisgarh Society Registration Act.
Oh,
That is the, my lord.
then very well. You can read out the
And my lord, it is also parameteria with
Give
all
me the
the
relevant sections.
section 22, my lord. Lord, I am also handing it over. For your lordship's convenience.
You've got an extra copy.
Yes, my lord. Give me, report, report.
The paragraph numbers are also in Hindi. No. Thank
22.
God. Yes.
Yes.
Which para?
Section 22.
Section 22.
Right.
My lord, it reads that सोसाइटी द्वारा तथा उसके विरुद्ध वाद प्रत्येक सोसाइटी उसके अध्यक्ष या सभापति या प्रधान सचिव या न्यायाधीशों के नाम से जैसा कि सोसाइटी के विनियमित द्वारा अवधारित किया जाए और इस प्रकार अवधारित ना किए जाने की दशा में उस व्यक्ति के जो कि शासी निकाय द्वारा इस निमित्त नियुक्त
Shashi
किया
Nikaya.
जाए
What is the meaning of Shashi Nikaya?
governing body. My lord, I can give the
You have an English version?
no. I can translate if you.
No, need not. I'll ask you wherever I
Okay,
get
okay.
stuck.
या उसके शासी निकाय द्वारा इस निमित्त नियुक्त किया जाए नाम से वाद चला सकेगी या उसी नाम के विरुद्ध वाद चलाया जा सकेगा.
Dwelling on this?
निर्देशित ना किए जाए तो सोसाइटी के विरुद्ध दावा या मांग करने वाला कोई भी
Here the first clause applies. Society is making the very well.
Now, my lord, so far as this writ petition is concerned,
Yes.
from the cost title, it appears it is Chhattisgarh Sponge Iron Manufacture Association. My lord,
So bound by this rather.
yes. Now, my lord, in this regard, I will also rely on a Supreme Court judgment.
Yes.
But here, right. Is delivered in, my lord, Ilaichi Devi by LRS versus Jain Society Protection of Orphans India and others.
Give your learned friend the citation. This is AIA 2003 SC 3397.
Yes, my lord. Yes, my lord.
Right.
I'm grateful, my lord.
Please continue.
Now, my lord, kindly come to
Not a
Page-
body corporate like company.
yes. My lord, kindly come to page 7.
Yes.
Here, my lord, three of the Societies Registration Act have been picked up to compare what does it contain. So, my lord, we may, my lord, refer to this AP in para 28. Lordship has got that?
Chhattisgarh is not here.
No, Chhattisgarh, but parameter. Parameter.
So the parameteria, these provisions we have, the court has considered. Then
Or-
where is the ratio?
32. Para 32, my lord, in the same page. A bare perusal thereof,
Yes, yes.
a bare perusal thereof would show that a society registered under the Societies Registration Act as contradistinguished from a company registered under the Companies Act cannot sue in its own name. It is to be sued in the name of president, chairman, or principal secretary or trustees as shall be determined by the rules and regulation of the society, or in the name of such person as shall be appointed by the governing body for the occasion in default of such determination. It is therefore not correct to contend that it is capable of suing or being sued its own name. So, my lord, in absence of rule, they must have indicated this is the bylaw and this is the person authorized to sue in its name. So, this is, my lord, my first point with regard to the institution of this particular writ petition. Now, my lord, so far as suppression of material fact is concerned, it appears, Lord, kindly sees the timeline. So far as
You got a short list of dates.
not list of date, my lord, it is, my lord, the timeline.
Acha, fine.
Timeline, my lord, published by Coal India.
Give a copy to them also.
My lord, kindly see
This timeline. All right. Yes.
this. It is, my lord, admitted position. This scheme was
Bring 2 copies at least. One for the court, one for the other side.
definite. My lord, I'll give mine, my lord.
And for one for the little boy who lives there. Right.
So, my lord,
Publication of timeline. Yes.
it is on 1st of February, my lord. This has been published. this auction, and the auction started from 9th of February 2023.
Hmm.
And my lord, it ended, that date does not appear here, but my lord, it is, they will also not dispute that on 30th May 2023, 30th March 2023, it, my lord, ended. Auction ended. My lord, petitioner has participated in the auction process.
When was the writ petition filed?
Writ petition, my lord, side, kindly come to my lord, the affidavit posted, that is page 56. It has been affirmed on 7th.
No.
It is affirmed in the month of May. So it was 19th May. 19th May. 19th May, it was affirmed. Just after the vacation. My lord, in the four corners of the writ petition, they have never whispered that I have participated in the tender. Pursuant to participation, they have been emerged as successful bidder. They have been issued LOI. They have been issued LOI. If your lordship, my lord, permission is, I can, my lord, produce two of the LOIs that has been subsequently issued to them.
All copies you have to give to them also.
Yes, my lord, I'll give you that copies I have had. My lord, all 32 petitioners. For my lord example, I have, my lord, brought.
All have been issued LOIs.
Not only, my lord, all of them have been issued LOI. Pursuant to issuance of LOI, as per terms of the tender document, they have also given their document as sought to be given in terms of the tender condition. None of these facts have been presented in this, my lord, writ petition. In this behalf, my lord, I may, my lord, permitted to judgment which your lordship is, my lord, well aware.
Mr. Taradar, are you disputing these facts? If you dispute, then I'll direct short affidavits.
Yes, my lord, because my lord, all this facts is not correct, my lord, because I have challenged, my lord, that the implementations of the fuel supply agreement that always takes place after holding of the auction.
Yes, Mr. Taradar, on law you may argue.
Yes.
I mean, the facts whether you are denying, because they are saying that you were successful, LOI was issued, and documents had been submitted by you.
No, my lord, this is my lord. Factually, these are correct. I am not disputing.
Then I won't direct affidavits.
Yes.
So you'll argue on this,
Yes,
why
yes.
these are not.
And my lord, only, my lord, there is, my lord, no scope for interim order. On the ground, my lord, they have, my lord, basically challenged that fixation of.
If they don't dispute these facts, I'll take these on record. I won't direct you to file affidavits.
And so far as only interim order is concerned, my lord, there is no scope.
Interim order, I'll reserve my judgment. I'll try to render the judgment very soon. So apart from this, please continue with
And so my
documents were submitted by them.
yes, my lord. And my lord, so far as suppression of material fact is concerned, with regard to that, my lord, this Supreme Court judgment, my lord, kindly come to, my lord, para 12.
Yes.
It is well settled that the jurisdiction exercised by the High Court under Article 226 of the Constitution of India is extraordinary, equitable, and discretionary. And it is imperative that a petitioner approaching the writ court must come with clean hands and put forward all facts before the court without concealing or suppressing anything. A litigant is bound to state all facts which are relevant to the litigation. If he withholds some vital or relevant material,
Not need in detail. These are settled. Yes. Obviously, you are correct. Yes. If it is vital for the adjudication, then yes, suppression is bad.
so paragraph number, I may, my lord, revert only 12, 13, 15, 36, 38. Within 15, 36, 38.
Unreported. Unreported. Report. I was report the draft. Must come clean hand. When it comes to the voice that No side, no side, please.
Now, now, with regard to the point that whether a participants in the tender or auction process, they can, my lord, challenge it or not. My lord, I will, my lord, rely on your lordship's judgment. That is,
There are other contrary judgments also. I mean, it has been held.
but your lordship, my lord, has discussed all the judgments which is against us, which was in favor of them, and thereafter, my lord, your lordship has come to this conclusion.
Right.
Your lord, kindly come to paragraph 33. There, my lord, the situation was reversed. State has objected that since they have not participated in the tender, they cannot challenge the tender condition. And your lordships, after considering all the Supreme Court judgment, has come to the conclusion, yes, if they have participated, they cannot, but if they have not participated, they can challenge. So in that case, it was they have not participated, and therefore your lordships, my lord, held that.
Yet the laws, the judgments on participation were also probably discussed.
Yes, my lord. Your lordship has considered everything.
Very well.
Citation.
2021 SCC online L 3031.
Online L.
No, SCC online Cal 3031.
3031.
3031. Now, thereafter, my lord, Honorable Supreme Court also, my lord, affirmed your lordship's view. That is 2022 6 SCC 401. My lord, paragraph number is 28.6, 27, 41, 44.
28.6, 27.
27, 41, 44.
Yes.
And here, my lord, court has also interpreted the jurisdiction of the writ court in respect of a commercial matter. That is also, my lord, discussed. In addition to the fact that if you have participated in the tender, it is not open for you to challenge the terms and conditions of the tender or auction.
Show me the commercial matter portion, Mr.
That is not 28.6. 2022 6 SCC 401. And my lord, so far as scope of passing of interim order is concerned, that is also not present. My lord, kindly come to page 169 of this writ application. At any event. My lord, point number 11. Their principal grievance is that in the policy or the guidelines as framed by the Ministry of Coal shows that premium price shall remain fixed during the period for which the contract is valid. Now, so far as this scheme document is concerned, it has taken that it is the premium percentage which will remain as fixed instead of premium price. So this is their principal grievance. If the premium percentage is, if you take that premium percentage as fixed, then at the time of indexation, in every year, the price will rise. In this regard, my lord, if under clause 11, the second point, if I may place it, it says wholesale price index will be used for indexing of the basic price of NRS linkage auction by applying the prevailing modulated price on 31st March of the year for the first year of indexing, that is 1st April 2023. WPI will be applicable on the notified price to arrive modulated price. Indexation of the basic price may be done to the extent of 25%, 1/4 of the movement of WPI. So my lord, if they are aggrieved, they will be aggrieved in the next year.
What is this? I can't understand. Indexation of basic price may be done to the extent of 25% of the movement of the WPI. Movement of the WPI as in?
My lord, so far as
Because it's-
wholesale price index is concerned,
Because the prevailing modulated price is applied.
yes, my lord,
That
because
modulation
my
is
lord,
there.
policy permits me to
Right.
do the indexation.
Yes.
Policy permits me to do the indexation, and that is subject to my lord change every year.
Yes.
So my lord, so far as this year is concerned,
Hmm.
in this year, my lord,
Hmm.
whatever premium is fixed,
Hmm.
that on that basis they will my lord get the coal supply.
Hmm.
So if they are at all to be aggrieved,
Hmm.
that will be my lord applicable from the next year.
Hmm.
Even if your lordship holds that it has to be
Hmm.
in terms, but premium price will be fixed, that will be my lord applicable from the next year, not from this year.
Hmm.
So my lord, really, there is no scope for my lord passing interim order. Now my lord, so far as guideline is concerned, the guideline as framed by the Ministry of Coal and the judgment which have been cited by my learned senior friend, I may my lord point out this specific paragraph to show none of the judgments apply in respect of this case. On the ground, in respect of those judgments, the specific bylaws of the particular organization has been violated. Secondly, my lord, if the Ministry of Coal thought that I am going beyond the guidelines, it is the Ministry of Coal who would have come and stopped me from auctioning it. This since 2016, my lord, this process has been going on in entire country. This is the number 6 tranche. We have never faced any kind of such challenge. So in any event, it is the Ministry of Coal, let them my lord take a decision alternatively whether we are in violation of the guideline or not.
Suppose the Ministry of Coal sits right over the matter. Then don't they have a locus standi to point it out?
My lord, let them,
Arguably.
my lord, but first it is the ministry that has to take the call. If they have, whether they have not approached the
Suppose
ministry.
you are hand in glove with the ministry. Let us suppose the worst against you. So there can be situations where the ministry is doing nothing, but you are in violation of their own guidelines,
Yes, ma'am.
which are binding. They are also themselves bound. So in that case, they may make this allegation.
My lord, so far as this guideline is concerned, I will submit that
That can be one of
guidelines,
your components, definitely.
guidelines are only merely to assist as to how it has to be gone about. But discretion has been, my lord, left to Coal India as to how they will, my lord, give the coal, what would be the market price, what would be the market rate.
Show me that scope of discussion. Yes.
Now kindly come to page 60. The guideline starts at 60A, my lord.
Yes. You are Mr. Poddar?
Yes, my lord.
Yes. Mr. Poddar, please show me that relevant portion.
It is, my lord, it starts from, my lord, 60A.
Yes.
The proposal of competing bidding for auction of coal linkage LOS to non-regulated sector has been under examination in the ministry with the approval of Cabinet Committee on Economic Affairs. The following policy guidelines for auction linkages of regulated sectors have been decided.
So why did you please read it?
Have been decided now, my lord.
Which page?
60A, my lord. Annexure P3 60A.
I'm sorry, yes, yes, right. Yes. Policy guidelines, it stated also policy guidelines.
Policy guidelines, my lord. Then, my lord, 62A.
Yes.
ROM price to be paid shall be suitably indexed by CIL, SCCL for subsequent years.
What is
The
the scope
success-
of discussion in this?
My lord,
What is the scope of discussion in this?
my lord, discussion in the sense, since it is a guideline. Since it is a guideline,
Policy guideline,
it is a guideline, my lord.
can you deviate
And
from
my lord,
that?
and my lord, Coal India,
Yes.
being a my lord company, it has got, my lord, some independent status.
But can it be in violation of the government guidelines? Because
lord-
this is the Ministry of Coal which is issuing the guidelines.
Yes, my lord,
You
definitely.
are
my
under
lord.
that.
Definitely, my lord, but guidelines, my lord, we are following.
Let us
We are-
see that, yes.
We are following the
Deviation from
guideline,
the
my lord.
guidelines, that is a very dicey argument for you.
Yes, my lord.
That you can deviate from the guidelines to a moderate extent, that is a risky argument for you.
My lord, so far as my submission is concerned, when the discussion has been vested with the Coal India,
Show me that it has been wasted. Where?
this ROM price to be paid shall be suitably indexed. It is our, my lord. It is our discussion, my lord.
Very good. Very good.
Now, my lord, I may refer to a judgment which relied by my learned senior friend, that is 2023 to SCC 703.
Yes.
MP Power Management Company Limited, Jabalpur
yes,
versus
yes.
Sky Power Southeast, my lord. My lord, may we kindly come to para 56
Hmm.
of the, my lord, judgment.
Yes.
In Ramana Dabban Shetty versus International Airports Authority of India, this court inter alia held as follows. Now, therefore, there can be no doubt that what para 1 of the notice prescribed was the condition of eligibility which was required to be satisfied by every person submitting a tender. The condition of eligibility was that person submitting a tender must be least 5 years experience as such, and if he did not satisfy the condition of eligibility, his tender would not be eligible for consideration. This was the standard of norm eligibility laid down by the respondent number 1, and since the respondent number 4 did not satisfy this.
Mr. Poddar, Mr. Torokdar is on the norms laid down. It is a well-settled rule of administrative law, then it goes on. So you have to be, the executive authority must be rigorously held to the standards by which it professes its actions. So he's not on the facts of this case. Maybe the facts were different there were gross violations there. He's not on the fact. He's on the rule of administrative law, which is cited also.
But in the
next sentence.
So far as that case is concerned, it is the particular tender condition which they could not satisfy.
Achha. So you distinguish there.
Yes, my lord. And none of the, my lord, judgments referred by my learned senior friend, my lord, talks about guideline of the ministry. One is on bylaws, another on the specific tender condition. It is not the case of the petitioner that I am violating my own tender condition or own condition of the auction linkage. But they should not have participated. They had, my lord, ample scope. Why, my lord, after participation, after receiving LOI? And, my lord, from in annexure P4, they have got other industries as association body. They are not contesting this writ petition. There are another 54 members. It is, my lord, my respectful submission. This writ petition is not maintainable, especially at this stage. It, my lord, deserves to be dismissed, and it is a policy decision or guideline, whatever it is. If we are in violation, let the ministry take a decision.
Thank you.
That's all, my lord.
Thank you.
That's all.
Thank you for being brief. Yes. Yes, Mr. Tarode, any short reply?
Yeah.
Need not file written notes in this actually.
Yes, my lord. So for the defect which my learned friend has pointed out is, first, it is curable, and secondly, if in unregistered associations, my lord, the writ is maintainable, I'll rely on the judgment, my lord, so I'll give it in my notes of argument.
So you are saying that this is, you are unregistered?
Yes, no, it's a registered, my lord.
Yes.
Even, my lord, even any association, even unregistered associations can maintain a writ, my lord. That's the judgments are there, my lord. And even, my lord, any associations, my lord, whose right, my lords, will be below influence, my lord, and the fundamental right has been affected, my lords, come before the court, my lord, in Ram Bharosa Singh's, my lords, in 1955 Patna, my lord. I will rely on that judgment, my lord. So that is the and what my learned friend has says that, because that the Ministry of Law, my lord, the only they can my lord, amend this, my
What
lord.
about the discretion being given?
No, my lord,
That's
my lord,
suitable.
my lord, the
Suitable expression is-
suitability. I have not raised any grievance as regard to the suitability indexations on the ROM price. My grievance, my lord, is on the introductions of modulated price, my lord. This modulated price is, what is modulated price, my lord? My lord, notified first, my lord, that the Coal India will fix the notified price, my lord. This notified price is much higher than run of mine's price, my lord. And on and above the notified price, my lord, that the indexations, again it will be, my lord, further it will be indexed, my lord, to the notified price, my lord. So, my lord, stage by stage, my lord, that the price will grow higher up, my lord. And on the other hand, my lord, that the petitioners were exposed, my lords, to a completely economic unviable positions. And on the other hand, my lord, strangulating clause, my lord, there is no exit. There will not be any exit clause. So therefore, what my learned friend, that it will not affect today, but it will affect tomorrow. But I will have no remedy, because 5 years I am bound to, my lord, by this particular agreement. There is no exit clause. So therefore, that's my respectful submissions, that either, my lord, you keep it an existing clause, my lord, and secondly, my lord, these fixations, my lords, is completely contrary to the guideline, my lord. And my lord, I invite your once again your lordship's attention at page 62A. Look at the table, my lord, that is on per ton basis, my lord. But it was made on percentage basis. If it's made on percentage basis, my lord, definitely it will have an implications, my lords, in the indexations price also. 62 capital A of the writ petition.
Table at the top.
At the table. Bids received for 2.5 metric ton, bidding round 3, premium over CIL ROM price rupees 200 metric ton per ton. This is per ton, stroke per ton. So what is, why, my lord, this example was given, my lord, to make it more transparent, my lord. If it is percentage, my lord, then on the last occasions, I cited, my lord, I argued, my lord, and I cited a few paragraphs your lordships have taken note of, that what is the difference between fixations on percentage basis and fixations on ton basis. Fixations of percentages is also have an implications to the indexations also. Not only, my lord, premium, but also indexations also. This is, my lord, not permissible under the guideline, my lord. And that, my lord, year after year, my lord, it will grow up, my lord. And it will push the, my lord, all the manufacturers, my lords, to absolutely economic unviable circumstances. And on the other hand, I will have no, my lord, escape route, my lord, from the contract, my lord. So I have to absorb, my lord.
Mr. Tardo, what about your participating?
My lord, that I will also cite judgment, my lord. Even, my lord, I participated.
Yes, either way there is judgment.
Yes, my lord, yes, my lord. But, my lord, if there is any irregularities, my lord, then these are all the technical,
So
my
you
lord.
participated and took a chance. Mr.
No, my lord. Why, my lord?
That
Because,
you're
since,
challenging
no,
the
my lord,
guidelines.
since they are means they are the monopolistic in nature, my lord, that 90% market they are holding by the Coal India, my lord. I don't have any option, my lord.
What prevented you from coming before?
My lord, suppose, my lord,
Took a chance.
yes, my lord,
If
no,
you
my
were
lord,
successful.
my lord, before executions of the agreement, because that right will affect, my lord, as soon as, well, I'll sign the agreement, my lord. So that is first stage, my lord. Some right has been infringed, my lord. That, my lord, even if it is not amenable, but, my lord, before execution of the agreement, my lord, I come up before the lordship, my lord. And before executions, my lord, I wrote several letters, my lord, asking for amendment of those clauses, my lord, that strangulating or the arbitrary clauses, my lord. That was not paid any heed, my lord, to those representations. Ultimately, I compelled to come up before this lordship. And that too, my lord, even long before the executions of the agreement. So, my lord, this is a, suppose, my lord, it could be comparable to a common carriers, my lord, railways case, my lord. So I have no option. I have to avail. So because if I'm not participating in the coal, my lord, I don't get any coal, my lord. But today, if I not succeed, my lord, then I'll be absolutely lose, my lord, the scope, my lord, and even to participate in the tender and to run the industry. So that is why, and taking advantage of this monopolistic nature, this strangulating and arbitrary clauses has been set by the Coal India, my lord. And in order to prevent such arbitrary exercise, this guideline was framed, my lord. So that my respectful submissions, that is why, my lord, that the guideline, my lord, because they themselves has, my lord, accepted and admitted the positions that the only Coal India can do this. They will exercise arbitrarily, and that will be amenable by the Coal India, be the controlling authority, not the court. That's the submission.
Mr. Tarabda, since you have hinted that you will be citing one or two more judgments on certain points,
yes.
So please give an advance copy of that written
Yes,
arguments to them,
yes,
so that if they have to reply in particular on those judgments only, then please just do that and file your written notes on the next. So when should you come back with your written notes? Tell me, give me a date, both of you, which suits you.
It is better if it is 1 week, my lord, or by Wednesday.
By Wednesday, then you will have to give a copy to him at least 2 days before that.
2 days before, then make it one week, my lord.
1 week, I'll make it one.
Including the judgment cited today, my lord.
Yes. That is more important.
I'll give it.
Because if you want to reply on those, you'll have to.
And my lord, may I submit my lord, 2 short reply in response to what he has submitted, my lord?
Yes.
My lord, only reason.
No, reply to reply. This will go on.
I'll give it.
What is your stand in the matter?
As per instruction, my lord, as the direction shows, my lord, the 60A, that is our instruction that it is pending before the cabinet committee, my lord.
What is pending here?
My lord, the LOA, the question decided, my lord, kindly comes on the question.
The policy decision itself, that has been passed.
And that has been passed, my lord.
So what is pending? I don't understand.
My lord, kindly, my lord, comes on.
Which page, tell me?
Page 68.
$68, yes.
60A, my lord, 60A.
60A, I'm sorry. Yes, 60A. Thank you. 60A.
This is, my lord, pending, my lord, before, my lord, if any action against the, my lord, the Coal India or anything, my lord, I have to, my lord, take.
Please take the microphone. I can. Pending before cabinet committee. What is pending?
My lord, the further action they have taken, my lord, further in, my lord, the notification after that, my lord, that is in pending, my lord, before the cabinet committee. The instruction that till not.
Cabinet committee has an option to set it aside.
No, my lord.
So
No,
why it is pending for what then?
my lord, they have, no,
Academic interest. Then why is it pending before the cabinet committee? If it does not have the, what can it do on it after consideration?
my lord, then nothing, my lord, but they have stating,
Why is it pending consideration for what?
only when instruction most of for pending.
That's very good. Very.
If further instruction, madam, came, my lord, then I will submit before the court, my lord.
We'll submit that on the next day, only one sentence submission. What happened to that consideration? Why is it pending for consideration also? Heard learned counsel for the parties. First of oral arguments are concluded. First up, the parties are requested to file the written notes of argument on the next returnable date. First up, the matter shall next be listed on July 7, 2023, under the heading to be mentioned for filing of written notes of arguments. To be mentioned so that it comes up in the list.
And in the meantime, my lord, status quo is to be maintained, my lord. Otherwise, today is the last date, my lord, signing of the agreement.
But there are
Any action taken in the meantime shall abide by the result of the writ petition.
My lord, if it is,
I cannot, because this ongoing process cannot be stalled like this, Mr. Short.
no, there is no process, my lord, because only, my lord, because everything is going on, my lord, only, my lord, the
That is why
incorporation of
I
such
cannot
process.
pass this order. I cannot pass an order either in your, because if the tender process is cancelled, you win either way. And if it is not cancelled, then Mr. Tarafdar, whatever happens will abide by the result. It cannot be anything else actually.
No, the signing of the efficient date may be.
Despite whatever
The
is
signing of the date may be extended.
there are, my lord,
That will, I not only for 4 weeks.
No, that may be considered the final hearing also. If you win,
Yes.
then that may be considered, because if you supposing if you win in the sense that if you don't win rather, so make that you can renew that prayer.
Then in the meantime, we have to sign, but
my
that
lord,
abide by
only,
the
my lord,
result.
they have
Then
come
that
to
should
your
be
lordship.
recorded. Otherwise, we not.
আরেকটা জিনিস
Otherwise.
any action taken in the meantime, যেটা বললাম ওটাই, any action taken in the meantime shall abide by the result of the writ petition and shall be without prejudice to the rights and contentions of the parties in the writ petition. Even if you sign, that will be without prejudice to your
Yes.
rights.
My lord, in that event, my lord, so far as condition of the auction is concerned, it, my lord, says after winning, after they have become a successful
Yes,
bidder,
after that what?
after that, if they do not sign, there are, my lord, consequences. So this writ petition has been, my lord, filed only to evade from that.
No, they will sign. They will sign, but that will abide by the result. Ultimately, whatever will happen in the writ petition, they are signing. I'm not extending that time. If they lose, they have the option to go on with it.
Sign করলাম কিন্তু যদি
My lord, today is the last date, my lord, that the petition will not get any time, my lord. At least 2-3 days, one week at least may be extended. My lord, only 1 week.
No, Mr. Tarun, I can't
My lord, by within a day, my lord,
extend the time. No,
my lord, within 1 day, my lord,
Lord,
it
they
will be
have
possible,
submitted
my lord, by
documents, my
signing all that 90
no, Mr. Tarun.
90 manufacturers, my lord. My lord, only 1 day.
Only
My lord, only
32.
7 days may be given.
No, no.
There are, my lord, 171 participants, only 32 they have not, and but there are other associations they have, my lord. Not
Extension of interim order, item number 3.
Expiring when, Mr. Bhattacharya?
On the 30th, today.
Today.
And it was last extended on the 17th of May 2023 by the
You have
other
served
bench.
notice on the other side.
Yes, yes.
Mr. Basu is for the other side.
And my senior. And we are led by Mr. Mukherjee,
Which Mr.
Mr. Shaktinath.
Oh.
Now he is in air always, so that's why.
So I'll extend till till
Till
when?
disposal of the petition.
Disposal can.
Who is for the respondents?
No, why not?
No, you are not.
The petitioner who was the original
The original
petitioner in
complainant
the
was not appearing.
complainant is not appearing.
Despite 3-4 notices, Justice Bhattacharya recorded.
I'll extend it for a limited period. That will be a
Yes.
quite a long period. The interim order granted earlier is extended till September 15, 2023, or until further order, whichever is earlier. The matter shall be listed for hearing in the monthly list of August 2023.
Item 4, extension of interim order.
Your Lordship, I am for the petitioner in this matter.
Lordship, Mr. Vipul Kundalia is appearing for the income tax authorities. He's on legs in court number 2.
Same order as in the previous matter. What was the interim order granted in this?
Your Lordship, the present writ petition has been filed by the petitioner challenging the proceedings initiated under the Benami Prohibition Act And on August 1, by an order dated August 1, 22.
What is your best ground of challenge?
Your Lordship, Your Lordship, the show cause notices were issued upon the petitioner on 28th and 29th of March in relation to 37 properties. However, they were supposed to give us time to reply to their notices. However, they passed the provisional attachment order on the very same day. The Honorable Court was pleased to grant us interim stay in this matter on August 1, 2020.
There was a reasoned order also passed on that date.
Yes, Your Lordship.
Well, the interim order granted earlier is extended till September 15, 2023 or until further order, whichever is earlier. Matter to be listed for hearing on in the monthly list of August. August.
Grateful, Your Lordship.
Thank you.
Item 5.
My lord, I appear
Extension.
for the petitioner, my lord, for extension of interim order.
Yes.
My lord, the interim order was last extended on 17th of May. Up
You're
to
for the other side. So same order, I'll pass the same order. Same order. It will be extended till the September 15th or until further order. They appear for hearing in the monthly list of August.
Very good.
Affidavits were directed in the
Affidavits complete, my lord. Short point, my lord, whether, my lord, a deed of assignment of copyright is required to be stamped. I am challenging on the ground of jurisdiction apart from other, my lord, grounds.
We are already July monthly list is already there. No, has to be August.
August,
not
very
before that. Yes.
New motion, item 7.
Yes, Your Lordship, I am appearing for the private respondent number 7. Now, my lord,
I am appearing for the statement.
allegation is leveled, my lord, against my client that I am obstructing electricity so far the petitioner is concerned. Now, if Your Lordship kindly take the trouble, my lord, to come to page 5, paragraph 5. He has stated that your petitioner is living in his room without any electric since long period and suffering from mental agony and extreme heat, which is creating or making suffer to the petitioner's hearing. Now, thereafter, Your Lordship kindly take the trouble to come to annexure P1, though it is not paginated in my copy. That is the notice of disconnection. He has very cleverly, I must restrict myself, annexed. My lord, this is the meter of his father and my father-in-law, which he is continuing. It is not disconnected. I am producing an original copy.
Anyway, I cannot dismiss his matter on merit.
No. If Your Lordship kindly fix any date after 10, my lord, I will be out
After?
of 10th. Any date, my lord, I will be out of station. That is the reason.
Very well. Let the matter stand adjourned till July 17, 2023, since none appears for the petition at the time of call. First up, the report filed on behalf of the state respondent today be kept on
A
record.
copy may be.
Item number 7.
Move the matter. Where were you?
Sorry, I was in Lakes before.
After the order is being passed, you are coming. Keep somebody. Yes, what is the matter? The order ticket is in it. Yes.
The grievances is that we have made an application before the appropriate authorities, my lord, for installing a sub-meter. On 7th, we have a hearing, my lord. That
Who are you?
I'm for the petitioner, my lord.
You are the owner of the premises?
No.
I'm not the owner, but I'm the brother who has filed this case, my lord.
Brother of whom? The owner?
Yes.
Yes.
So what is your locus standi? You are occupying that premises. You are there.
Yes, my lord, I'm there. As well as my brother is also there. Now the difficulty is that on 7th on July, we have a hearing before the CSC authorities that whether we should install the sub-meter or not.
What is this?
My lord, father has gifted.
No, this later on.
I'm sorry. I'm sorry.
Please continue. Yes.
Yes.
And if such hearing is fruitful, my lord, we can apprise your lordship. And
No. You have asked for a hearing on your sub-meter.
on sub-meter,
So
we
what
have
is the
given.
cause of action for the writ petition?
My lord, I'm coming, my lord. My lord could come to annexure, page 25, my lord, at first.
You have asked for a new electricity connection.
Sub-meter as well as.
Now, where my lord,
Hearing, why, what is the question of giving you that?
sorry, my lord.
Before that hearing is held, it has already been fixed for hearing.
It was fixed for hearing. After that, the CSC authority, we have given a notice to a CSC authority that they have asked that they will come before us. They will install the meter, but there was hindrances by these private respondents.
Oh.
Yes, my lord. We have mentioned this to the officer in charge also.
Which page?
Yes, my lord, I'm coming. My lord could also take up page 32, annexure P7 and page 35, annexure P9, which could be evident. And page P4, page 8, annexure P4, page 18. I'm sorry, my lord.
You have not served the CSC.
Yes, we have served. But the affidavit of service is ready, but not yet affirmed, my lord.
My lord, may I-
My lord, if your lordship keeps on Monday, then we can.
If you put this date on the computer form, then why aren't you ready with your affidavit of service?
My lord, it is not. My lord, it is served, my lord, it is, but I will be fair to your lordship, my lord, it is served, but not yet affirmed.
Thank you for the fairness, but you have to file it. How soon can you file it then?
My lord, then I could file within the course of the day, if your lordship permits.
my lord,
Yes, please carry on.
Now, my lord,
18.
Page 18, my lord, could see we have addressed our grievances. We have addressed to the Deputy Commissioner of Police, and page 25. Sorry, my lord, page 32 onwards, there was an inquiry where we have, which we have got from the side of the CSC, my lord, where it has been completely written that on which date that the meter will be.
What is this direction by the executive magistrate? Page 35.
Page 35.
An order of the executive magistrate has been referred to. In what connection was that passed?
Page 35. No, page 35 is annexure P9, my lord. It is
Please come to the first sentence of that.
in the code of the years. এটা কিসের ছিল? There was a matter which was filed before the executive magistrate for getting the electricity connection, my lord.
Under
was-
which provision?
Only
my
the-
lord, subject to correction, my lord.
No, no, please don't argue in the midst of their
Very
argument. Yes.
only the করেছিল। only the করেছিল, বল। My lord, this was filed by the respondent, private respondent, which I could see,
No,
my lord.
nothing of your matter.
Page number 26, my lord.
None appears for the CSC Limited, nor is the learned counsel for the petitioner fully ready with his matter. Full stop. The affidavit of service has not been affirmed as yet. Full stop. Let the matter stand adjourned till adjourned for the day. Full stop. The report filed by the state respondent be kept on record.
My lord, I will be out of station. That is the reason, my lord. If your lordship kindly.
So adjourned till you will be out till July 10th.
Yes, my lord.
Adjourned till for the day na kore, adjourned till July 11, 2023.
Deeply obliged. Deeply obliged.
Next matter.
Item 8.
Second appellate authority, I am appearing for the
Petitioner
petitioner.
is not there.
No, lordship.
None appears for the petitioner. Next monthly list. Okay. ওনাদের নামগুলো রেকর্ড করুন।
Item 9.
Here for the petitioner. Mr. Manager, can't hear you. Please use the microphone.
Yeah, this is innocuous pair, my lord. Your lordship highly consider, my lord. I have already served notice, my lord. I am the wife, my lord, of the respondent number 4, my
What
lord.
is the affidavit of service, Mr. Banerjee? You have already filed.
My lord, what happened, my lord?
Yes.
My husband, my lord, paying man.
No, you have checked up good service on all.
Yes,
You have checked up.
yes.
Yes or no or very good.
Delivery confirmed.
Mhm.
Item delivered.
They have not even checked up.
Yeah, checked up. My lord.
Yes, you are the wife.
Yes, my lord, husband is paying, my lord, 10,000 rupees per month, my lord.
Microphone.
Husband is paying my lord 10,000 per month, one off and on, my lord.
Yes.
My prayer is, my lord, he is working, my lord, in Calcutta Telephone Exchange, my lord. I made an application before the authority concerned, my lord, to consider my representation in accordance with law, my lord. Only this point.
Show me the representation.
That representation is, my lord, page 15. My lord, enhancement of the, my lord. Only, my lord, prayer is, my lord, consider my representation, my lord. I met the Calcutta general manager, my lord. He told me, but I know, my lord, very bad case for me, my lord.
This is a malafide application.
Very bad case, my lord. But my prayer is, my lord, you also kindly direct the general manager, my lord, to consider his representation in accordance with law.
The malafide representation even. The petitioner.
My lord, you also kindly consider, my lord. Otherwise, my lord.
No. Affidavit of
My lord,
service filed
file
today be
fresh application, my lord. Liberty is given a fresh application.
not fresh. If you withdraw it outright without any liberty, I can dismiss. Or I'll pass an order. Better to pass an order. Learned counsel for the petitioners.
Otherwise, my lord, I file a.
Mr. Banerjee, make up your mind. Either you withdraw it, I'm not compelling you to withdraw. I'm going to pass my order. Please don't disturb me every time.
Withdraw this application, file fresh application. my lord.
Definitely not. Then let me pass my order. Affidavit of service filed today be kept on record. Full stop. The petitioner is the wife of the private respondent number 4. Full stop. In the writ petition, comma, the petitioner has sought for the respondent authorities, comma, the employer of the husband, comma, to consider the representation of the petitioner and a direction to that effect from the court. Full stop. Next para. A perusal of the representation indicates that by the said representation, comma, certain allegations have been made against the husband. Full stop. Not only that, comma, the petitioner has sought for transfer / remittance of 50% of gross salary of the respondent number 4 / husband to the savings account of the petitioner. Full stop. Next para. Such representation is palpably malafide. Full stop. The remedy of the petitioner lies before a court of law and or any appropriate forum, comma, in accordance with the several statutes which are available to the wife to claim maintenance, comma, and in default of payment of the same, comma, to seek execution by due process of law. Full stop. However, comma, the shortcut remedy sought to be adopted by the petitioner cannot be given a sanction by the court of law. Accordingly, WPA 14092 of 2023 is dismissed without any orders to cost. Full stop. Nothing in these orders shall preclude the petitioner wife from approaching any court of law and or other legal forum to assert her right to get maintenance and to have such order implemented. Thank you.
Item 10.
Praying for not to them a lot.
Petitioner, not today means next month list. You are for the petitioner.
No, my lord, I have been instructed by his clerk.
Who is appearing for the petitioner?
Anwar Ali, my lord. Due to
An adjournment is sought on behalf of the petitioner. Let the matter stand adjourned till the next monthly list.
Eleven,
my lord, I am for the respondent.
I'm for the
Respondent
petitioner, my lord.
227, Steel Authority of India. My lord, today I am, my lord, bit handicapped, my lord. I have not received the petition, my lord. Although I have
You are for the respondent.
My client
I have
received.
served, my lord. This is the affidavit serving. Only one has been returned, my lord.
Returned with endorsement.
Insufficient address. The others, he is appearing for 226, right?
27.
Who has not been served?
Respondent number 5, my lord. They have already got the information, but the copy has not been served to respondent number
5 is sailing on the same boat as the others.
Same.
Yes.
Substantial service has been effected. Affidavit of service filed today be kept on record. You are for which respondent?
For 227, my lord.
Learned counsel for the respondent, comma, however, comma, 6 and adjournment appearing for the respondent numbers 2 to 7, 6 and adjournment, full stop. Accordingly, let the matter stand adjourned for the day and shall next be listed on July 4, 2023.
I'm grateful.
My lord, may I pray one deal? I have to correct the cost title, my lord.
Liberty is on the prayer of the learned counsel for the petitioner, comma, liberty is given to the learned advocate for the petitioner to carry out amendments to the cause title of the writ petition
I'm grateful.
during the course of the day.
I'm grateful.
এখনই করে নিন।
12.
Well, I beg your lordship. I
appear
appear
on
on behalf of the WBS.
Lordship, I have filed this writ petition stating the fact that I have applied for electric connection in the year 2011, Your Lordship. There are-
2011.
Yes, Your Lordship.
Then
I've been residing there since 2010, and for the past 13 years, Your Lordship, I've been staying there without electricity. Lordship, after my application was filed in the year 2011, kindly come to page 4, Your Lordship. Page 4, and the reference is page number 15, Your Lordship. I've got this reply that it cannot be with the above reference. I'm sorry to inform you that you have applied to this office for a new connection or via application number such and such, but at present we are unable to effect your service connection due to unavailability of PCC pole and other light materials needed for the service for connecting. Thereafter, Your Lordship, several years passed, and in the
this
year
was in which year? 12.
this was in 2012, yes, sir.
Right. Then
And this was a reply to the 2011 application, Your Lordship.
yes.
Thereafter, my lord, kindly come to page number 22. So, with reference to that said application of 2011, Your Lordship, after 5 years, they came up with this reply stating that there are legal obligation lying over the premises. Lordship, in the year 2016, there was no legal obligation over that premises. The premises was free and I was entitled to get that electricity. Thereafter, my lord, we have again applied in the year 2017. And that representation was also not considered. Thereafter, my lord, in the year 2012, I served a representation. And my lord, kindly see paragraph D, Your Lordship, and the reply at page number 36. In the paragraph D, I'm saying thereafter, no action was taken by the said West Bengal State Electricity Distribution Company Limited for almost 1 year from receiving such
Yes,
application.
I quoted that previously.
Yes, but and kindly see page 36. They are accepting my allegation, my lord. Whatever I've stated in paragraph D, they're accepting that they were it was their fault. That is why they couldn't provide me the service. There was no latches from our part. Kindly come to page 33, paragraph I, Your Lordship. I have stated the same thing. Issue another letter. My client stating a vague reason for not providing the electricity connection to my client, and that fact also been admitted, Your Lordship, in page 36, paragraph I. Whatever I stated, everything has been admitted, and no connection has been given. Thereafter, Your Lordship, a fact has to be mentioned here that in 2020 there was a civil suit filed.
By whom?
By a third party.
Regarding the same property.
Yes. Regarding a access portion, access to my property, there was an alternative access. Regarding that access portion, there was a order of injunction. Lordship, I am accessing another road because I had to access to my house anyhow. There was another road which I am accessing, and I made that representation stating that kindly provide me electricity through that road, which I am accessing. That has also not been considered, my lord. That is why I am
You
fine.
implead the other person who obtained an injunction. You should have implemented that person. So I could have directed an inspection to be held in his presence. So once and for all, they could have given a feasibility report. whether that alternative passage is already.
Last-
Yes, Mr. Mukherjee, what do you say to this?
My lord, subsequent to the application made in 2011, my lord, since there was unavailability of the poles, my lord, we could not, my lord, cater the meter, my lord.
What
And thereafter, after availability, we have tried 2-3 times. We have been obstructed by the private, the one 40 PAL and 5 others who are not being implemented. And thereafter, there has been some objection letters which has been written to us. That's why we have written to them. There are some legal issues. Subsequently, after the second application, we again went for the connection, my lord, the objection letter along with an order of injunction which has come out not to energize those to draw electricity line over those poles, my lord. But in that way, my lord, until and unless, my lord, in respect of the injunction order and my lord, if we doesn't get a waiver, my lord, it is becoming very difficult for us to.
No, then I'll direct affidavit. Say you have to disclose all the documents. And
Yes.
why don't you implement these persons?
Lordship, in that case,
The letter which my learned
In that
friend was
case,
showing,
may I ask for an
that is of
amendment? Your Lordship?
2022.
I'm praying for amendment to add.
Do you know the names? One has obtained injunction.
Yes, Your Lordship, I'll get the names
They
from
have
the suit
contested,
itself.
my lord,
I'm
the injunction.
contesting that suit.
The other objectors, they say they have written to you.
My lord,
There are-
kindly see the letter that.
Mr. Mukherjee, are there any other objectors than
Yes,
the-
according to my instruction, there are 40 PAL and 5 others. The names are not there, 5 others.
At the outset, learned counsel for the petitioner submits that the petitioner had applied for electricity connection in the year 2011, which was initially refused on the ground of non-availability of PCC poles at the end of the distribution licensee. For subsequently, such request has been reiterated, but to no effect. Next para, learned counsel for the distribution licensee submits that initially the reason for non-supply of electricity was lack of PCC poles. However, subsequently the petitioner obtained resistance from third parties. It was also informed.
WBSCD.
I'm sorry, the WBSCDCL faced resistance from third parties. It was also informed to the WBSCDCL that an injunction order has been passed with regard to the electricity connection being given to the petitioner. In such view of the matter, the learned advocate for the WBSCDCL shall, in writing, communicate the names of the objectors and the photocopy of the objections given to his counterpart appearing for the petitioner by July 5, 2023. The petitioner shall implead the said objectors by effecting the necessary amendment to the cause title of the writ petition by July 7, 2023. Thereafter, the petitioner shall serve fresh copies of the writ petition on the added respondents, indicating that the matter shall next be listed on July 24, 2023, when the petitioner shall file a fresh affidavit of service.
Lordship, I'm so grateful to you.
Thank you.
Lordship,
Are you
affidavit
filing
of
your
ser-
affidavit of service?
Yes, Your Lordship.
Yes. Affidavit of service filed today be kept on record.
Grateful to you.
I'm grateful.
I'll come back in 10 minutes.
This is a tender matter, but in Panchayat, my lord. I filed wrongly. I think.
Panchayat, yes.
Yes.
In view of lack of determination, let the matter stand released from my list with liberty to the parties to mention for inclusion before the appropriate bench having determination. Thank you.
14.
My lord, 14, my lord. I beg to appear for the petitioner, my lord. I have
Service?
served, my lord. They are not appearing, my lord.
Good service.
Yes,
What
good
is the
service,
matter?
but my lord, it's yet to be affirmed, my lord.
Come back on Monday.
Not today, my lord.
Not today, just not.
Great. Not today.
15.
I am for the WBC.
I know 15, my lord.
Appearing on behalf of the private.
My lord.
Who? Yes, what do you say?
My lord, there is some urgency in the matter, my lord. My lord, kindly here's the matter.
What is the matter?
My lord.
He is not governed by the resolution of the bar. He cannot be late for Eid. So let us hear what is the urgency. Yes.
My lord, in this matter, my lord.
What is the urgency first? Tell me.
Well, the urgency is that I am not being provided access to my common meter board, my lord. I am not being provided access to my common meter board. My electricity is
For the private response, you are asking for time for the private.
And first of all, and my lord.
Back on Monday, why? Wednesday, why?
My lord.
My lord, my client is a senior citizen, my lord, 86 years age. And my client's wife is a 76 years age and suffering from cancer, my lord. And they are forcefully by criminal trespass. They have entered, they have heckled, they have bitten my client. And my lord, in connivance with the local PS, my lord, they are restraining my free movement. Even they have put their padlock in the main entrance. And they have also put padlock in the electric meter room, my lord. This is it's a serious offense committed by them. And that's why, Honorable, this court was passed order and the appeal is pending before the Honorable Division Bench. And Honorable Division Bench also passed an order, my lord. There is extreme urgency. And that's why I am praying your intervention to save and to dignity of a senior citizen who is suffering a lot in the hands of all the accused.
Since it is opposite, I'll have to take up the matter.
My lord.
Yes, what is the matter?
Yes, my lord. My lord, main grievance of the petitioner, my lord, পেজটা বলুন আমার ব্রিফটা কোথায়
একটা order প্রথমে করে নাও যে although time is although adjournment is sought till July 5, 2023 by Learned Counsel for the on behalf of Learned Counsel for the private respondent, Learned Counsel for the petitioner vociferously opposes the same on the ground of urgency and seeks to move the matter. Full stop. In view of such urgency, the matter is taken up for hearing. Yes.
Yes, my lord. My lord, kindly come to the page 51, my lord. The main complaint which was lodged to the local PS, my lord. Para 5, my lord.
Yes. This is your complaint?
Yes, my lord. And that was taken in cognizance by the police, my lord. Kindly see the FIR lodge, but the necessary.
Your wife lodged the FIR?
Yes, my lord, because my client is 86 years and suffering from cancer. He is unable to move even. And he was bedridden. He was thrown out from his entire.
Who is the private respondent regarding the property?
Yes, my lord.
I mean,
they are the.
Who are they?
8 to 12, my lord.
No, who are they? You are the tenant.
No. I am the original owner, my lord. I am the owner.
Don't get shocked.
Yes, my lord. I am making apology, my lord. I am excited because I am.
It's obviously because of the reasons.
Yes, my lord. That is my lord.
Who are they in respect of the property? What are they?
They have, by a fraud, my lord, they have obtained a entire property and the entire building by a registered deed. With a plea that they are going to construct a school.
That purported deed has been executed by you according to them?
Yes, my lord. Yes, my lord. But what happened, my lord?
Yes.
This entire land and the entire building was taken away. And I was thrown away because by virtue of that deed, which was I have challenged before the court. and by Honorable Mr. Justice Shampa Sarkar, my lord, come to the page,
Are these people related to you?
my lord.
Are these people your relations?
No, my lord. My name is Ashim Ghoshal. I am from Brahmin community. My lord, I am no way connected with them. They are all related, my lord.
No,
They
my
are-
relatives are not of Brahmin community. I am from the Brahmin community.
Oh, my lord, my lord.
There are
No,
several relatives of mine who are not at all from the Brahmin
Oh,
community.
yes, my lord. I am begging apology, my
So
lord.
that,
to
that
to
itself
Mr.
does not.
Yes. My lord, what's happened, my lord?
Yes.
Kindly came to page 64, my lord.
64 years.
Yes, my lord. That petition was filed by my lord. And that was,
By not by me, by you, yes.
that is by my client, my
Yes.
Atindonath Mondol.
Hmm.
That is 8/8/2022, my lord. Kindly come to the,
Practicing fraud, yes. You have
yes,
made that
my lord.
allegation. Have you registered any criminal complaint?
Yes, my lord. That was also reflected.
Criminal case is going on?
Yes, my lord. Yes, my lord.
Acha, any civil suit? No.
No, my lord, civil suit was filed and that way, but not for in the light of the what happened. That's why we preferred an application for withdraw and to leave to file afresh. And in the meantime, we have challenged this order, my lord, Justice Shampa Sarkar's order, my lord. The division bench was, directions was passed by the division bench. That is page 63, my lord. 63, my lord. And it's
Yes,
P7,
yes.
my lord.
63, right?
3, my lord. This was pending before the Honorable Mr. Chief Justice, my lord.
This
And
is
it-
only a direction to file affidavit.
Yes, they have not filed till late, though,
Yes.
although they are here. And subsequently, my lord, they are.
What is your present grievance in this writ petition?
Grievance is, my lord, I am not getting access to the meter room and their theft, that is para 15 of the page 10, my lord. 10 para 15, my lord.
Yes.
Yes, my lord. Your petitioner states that the wife of your petitioner lodged a complaint to the officer in charge Sonarpur Police Station on Act 6 2023 regarding theft of electricity, but the respondent number 7 did not incorporate the section 379 of IPC in Sonarpur Police Station case number 547/23 corresponding to GR case number 3082/23 under section 341, 323, 354, 506, 34 IPC, but that 370 was not incorporated. So, my lord, we complain to the authority concerned that you are the authority, you should lodge a complaint. That's why we made a representation to the state authority, my lord. That is electric. देखिए पेजটা আমার দিকটা কোথায় representation
Page 54.
Respondent number 7 is the officer in charge of the Sonarpur police station. You are asking for time on his behalf. Sir, you are asking for time on behalf of respondent number 7. Acha, 8 to 12. What 8 to 12 over there, respondent number 7.
they are the private respondent.
Yes, then please
Then,
continue
my
from here.
lord,
Yes,
this
yes.
representation was made.
They are running a school from that property.
Yes, my lord.
That you say that is
Illegal,
illegal.
my-
Illegal. You
illegal,
say that
my
is illegal,
lord.
right?
They are trespassing in my property. They have tried to create a tenancy therein, and they are running a commercial, and that commercial electric line was used from my meter, my lord. They have not obtained any meter on their name. They have pilferage my electricity. They are using my electricity, my lord. And I am
A
paying.
provisional assessment has been raised against you.
Yes, my lord. The bill was raised by page. No. Yes, bill was raised, my lord. Inflated bill was raised, my lord. And I am.
What about paragraph 20 of yours, of your writ petition? Page 12, para 20.
Your petition submits that according to the provision of section 112B, 1, 2, and 3 of the Electricity Act.
This has not been done.
No, my lord.
No provisional assessment has
No,
been made.
No, my lord.
You say the inflated bills are coming.
Yes, my
And you
lord.
came to know
That is
they are.
amounting to be 15,000, 10,000, 8,000.
You challenged that before any forum.
Yes, but no, before this, we have raised the objection to the station manager Champahati.
That was also annexed to have.
So what happened to that?
Nothing was done. They are sitting over the matter and they are in connivance with each other, my lord.
Let us see what relief you have sought in this.
Yes. Prayer.
Page number 17.
Page 17, my lord.
Yes, 17.
Yes, my lord.
Accessing meter room, I mean, how can the police enforce it?
have
They have to
put
remain
padlock.
inside your premises
No,
then.
they have, yes, my lord, they entered in my premises, my lord. I am the legal owner of that.
They're running a school, you have said.
Yes, my lord.
They're running a school.
Yes, my lord.
Illegally or unlawfully or whatever.
Yes,
which
my lord,
decide
they
that
have
later.
also entered my premises and they have trespassed in my property, my lord.
You have already
Without
lodged a complaint that will take its course.
My lord, I am not getting access to my meter board, my lord.
That's a private dispute. What can the writ court do in that?
It is not a private dispute, my lord.
Inside your premises, if a particular private party resists you from accessing a particular portion of the property,
They are the trespassers. They are criminally trespassing my property. And
get
that's
that
why,
canvassed before a civil court and get them evicted.
no, that's a different thing, my lord. I am not on that point, my lord. I am on the, before your honor on electricity. This is the thing which is happening and the complaint which was lodged to the authority, they should consider my
See,
representation.
regarding the complaint, you have already taken out a writ petition. Justice Sarkar was pleased to observe, good, bad, indifferent, that it is already they have taken steps. So that is sufficient. Against which you have challenged in an appeal.
Yes.
Appeal is now pending. Affidavits have been directed.
Yes, my lord.
Up to that, so as on today, Justice Sarkar's order stands.
Yes, my
On the self-same cause of action, I cannot pass another order.
My lord, this thing was happened subsequently, my lord. This is the cause of action, fresh cause of action.
So you
which
made a
was
fresh
on my-
complaint. Fresh
Yes,
complaint.
Yes, my
Where
lord.
is that fresh complaint?
That is page 51, my lord. That is page 51, my lord.
51 is after Justice Sarkar's order.
Yes, my lord. This is the order, this is the complaint which was lodged on Act the 1st June 2023, my lord. Kindly come to the page 49, my lord. Which was received by the local PS, my lord. And a case was started. That is 547 of 2023. See subsequent events, my lord. And this was not
So then this is police in action.
Yes, but not police in action, my lord. This is not, my lord, police in action because, my lord, this thing was happened. They have not acted in accordance with the provision laid down in the Electricity Act.
Because
And
your other complaint is that they are committing pilferage of electricity.
yes, and that was reported to the state.
Yes, Dr.
authority.
Shah, why don't you take
Yes,
steps
my
on that report?
I think that this matter has been, facts has been distorted with deepest respect.
No, they have made a complaint to you that there is pilferage.
But there is no pilferage in that sense. Your lordship kindly appreciate that
What
there was
sense? Bona fide pilferage.
There is no bona fide pilferage either also. Lordship kindly see there is a title deed. There is a transfer of property, good, bad, whatever it is there. We are not going into that. And according to them that the less amount has been paid, on that basis a writ petition has been filed and the complaint has been lodged. And against that, your lordship, this writ court was pleased to direct the investigation is going on. So there is no case of interference and they prefer an appeal. The matter is pending. But so far the instant writ petition is concerned, they have said that they have lodged a complaint that is at page 54 to 55 before us, that there is an existence of a meter. No dispute on that in the name of the petitioner. Now, this meter is in the premises where the private respondent at present is residing or conducting business or school. Now, in this meter, your lordship knows where there is an existence of a meter, any beneficiary or whoever is there can utilize this meter until and unless till date, they haven't taken any steps for surrendering of that meter. There can be two avenues on this issue. Number one, either they can make an formal application for surrendering of that meter so that we can take an appropriate steps on that regard. And the private respondent can apply for a fresh meter. We can give, your lordship knows even whether they are a trespasser or a occupier, It is not the concern of the electricity authority. Now the concern is that the existence of a meter is there, and in the said
They have not asked for surrender.
till date, no application has been made. Let them make that application, we'll take
So
steps.
you say their allegation is that from their meter, the other person is
They're
using,
taking in the same premise.
but in the same premises, so
Premises.
you have nothing to do with that.
Nothing to do with that. If a lordship direct, then the
Why don't you surrender your
So why should I, my lord? Because this is my meter and their
meter is lying, it's in your name, but
Yes.
it's now situated in situated
No,
somewhere
they
else.
trespass, my lord. They criminally trespass.
Then I'll give you liberty to apply before the civil court for that, because otherwise your
My
meter,
lord,
yours, this is not a pilferage under the statute. Pilferage is when there is unauthorized use of electricity.
It is a theft, my lord. It is a clear
No.
case of theft, my lord.
Why do you say theft?
Because they are forcefully, they criminally.
Let us come to the
trespass is my
Electricity Act once.
Le-
Let us come to Electricity Act. Please come to page section 135 or 126. Where is the theft here?
135.
135 is
1A
theft.
And B, the
Yes.
Electricity Act.
Right.
Such your petitioner is highly prejudiced, my lord. My lord, let them file a.
You show me from this that as per your allegations, any of these clauses are satisfied.
Yes,
Show
my
me.
lord. Yes, my lord, because.
Which clause? 135 1A or B or C?
1A and B, both are my lord.
No,
Both are mine.
they are saying that there is no tapping or
My lord, kindly give me some time, my lord, and ask them, my lord.
no, there is no tampering or theft of meter.
Yes,
As per
my
your
lord, there is tampering, my lord.
What do you mean by tampering?
My lord, from the main switch which belongs to me, my lord, they are.
No.
Yes.
You don't have a right.
My lord, kindly give them a directions to file affidavit in this regard,
No,
and my lord.
Why should I keep this matter
My
pending?
lord, kindly allow me.
I'll
to-
give you liberty to apply for a fresh meter in your connection or shifting of your meter to your own portion.
No, my lord, that is not my, that is not, the entire building is mine, my lord. The entire building, my lord, kindly see.
File a civil suit, get your remedy.
No, my lord, that is a different thing, my lord.
And in
My
a
lord,
school
I am
there-
paying, my
no.
lord. I am paying it time, my lord. I am paying time. I would like to file a supplementary.
Not at
affidavit.
this stage.
My lord, kindly allow me to file there. Kindly allow me. Let
What
there
will you
be a-
file?
There will be a deductions, my lord. I will submit, my lord, certain documents.
What
which will
document?
be-
Tell me.
That is electricity bill, my lord.
In whose
That
name?
is, by my name, my lord.
Who disputes?
Till date, I am paying.
Nobody is disputing.
No, my
that.
lord, they are, yes, my lord, there is a inflated bill, my lord, which was not considered, my lord.
entertain
My lord,
this.
kindly allow me to,
No.
my lord, let there be a, my lord, kindly,
You are paying for time for them.
my lord, kindly let them,
Bill is in their name. That is tampering. How can you? You have made out a case, very good case for filing affidavits then.
yes, my lord, yes.
I would
Yes.
have dismissed this writ petition.
Yes.
This was not maintained, but thank you very
My-
much for that.
My lord.
Learned counsel for the petitioner contends that the private respondents are tampering the electricity meter of the petitioner by unauthorized use of electricity from the same. Full stop. It is further alleged that the private respondents are in unlawful occupation of the premises. Full stop. It is submitted that the private respondents are trespassers in respect of the premises. Full stop. Next para. Accordingly, the petitioner has already lodged complaints with the police authorities regarding which a preliminary inquiry was made. Full stop. Upon approaching a coordinate bench of this court by a writ petition against the investigating authorities, comma, an order was passed by a coordinate bench indicating that the investigation is taking its course and charge sheet has already been filed. Full stop. Accordingly, the writ petition was disposed of, comma, against which an appeal has been preferred by the petitioner, comma, which is still pending before the appropriate division bench. Full stop. Next para. Learned counsel for the petitioner places reliance on complaints made by the petitioners with the police authorities as well as the distribution licensee to the effect that the private respondents have offended the petitioners in several ways as well as committed a criminal trespass and are using electricity in an unauthorized manner from the petitioner's meter. Full stop. Learned counsel for the petitioner further argues that the petitioner is paying all the electricity bills, but the electricity therefrom is being tampered by the private respondents. Full stop. Next para. Learned counsel appearing for the distribution licensee submits that the petitioners have not made out a case of tampering coming within the purview of section 135 of the Electricity Act 2003. Full stop. Next para. It is submitted that in the event the petitioner has a dispute against the private respondents, the petitioner may very well ventilate the same before the appropriate authorities. Full stop. However, as yet the petitioner has not applied for surrender of his existing meter or taking a new metered connection from the portion of the premises occupied by the petitioner. Full stop. Next para. Although an adjournment had initially been sought by the on behalf of the private respondents, learned counsel appearing for the private respondent submits that the private respondents are also paying bills in respect of the electricity meter in question. Full stop. Next para. As far as the question of police inaction is concerned, the same was already canvassed before the appropriate authorities and by way of a writ petition, which has been decided by a court of by a coordinate bench and is now sub judice before the division bench. Full stop. Next para. In the event the subsequent complaints of the petitioner are not dealt with appropriately, it is always open for the petitioner to approach the appropriate forum. Full stop. However, insofar as the present dispute is concerned, from a prima facie perusal of the documents, it does not appear that any case has been made out regarding theft of electricity by tapping, tampering, damaging any electricity meter or apparatus or usage of electricity through a tampered meter. Full stop. However, insofar as section 135 within bracket 1 within bracket small e is concerned, the same contemplates usage of electricity for purpose other than for which the usage of the electricity was authorized. Full stop. In the present case, the question is required to be gone into as to whether the private respondents are using the electricity for running a school, which is for a different usage than that for which the petitioner took the electricity, without permission of the petitioner. Full stop. Next para. That apart, in view of the private respondents having sought to argue that they have been paying electricity bills, it has become doubtful as to whether the electricity meter, which stands in the name of the petitioner, can be operated by virtue of payment of bills by the private respondents, third parties. Full stop. Next para. Be that as it may, since learned counsel for the petitioner seeks further time to produce certain other documents which are relevant for adjudication of the case, according to the petitioner, leave is granted to the petitioner to file a supplementary affidavit on the next returnable date, with advance copies thereof to the learned advocates for the respondents. Full stop. The matter shall such advance copies shall be handed over to learned counsel to learned advocates for the respondents within a week from date. Full stop. A composite affidavit in opposition shall be filed by the private respondents to the writ petition as well as the supplementary affidavit within a fortnight from now, within 3 weeks from date. Full stop. Reply, if any, shall be filed within 1 week thereafter. Stop. The matter shall be listed for hearing on August 2, 2023. Full stop. Next para. Nothing in this order shall preclude the police authorities from proceeding with the complaint lodged by the petitioner before such authorities, and or from the distribution licensee from undertaking steps for the purpose of considering the representation which has been filed by the petitioner before such authorities in the meantime. First.
Your Lordship was pleased to make this returnable on August 2, subject to.
2nd August, right? Yes.
Deeply obliged.
Thank
Deeply obliged.
you.
16,
Yes. None appears for the parties. Next monthly list.
$17,
We are for the private respondent number.
Give me half a
79.
minute. আগেরটা একটু দেখে নাও তো অ্যাডভোকেট অন রেকর্ডের নামটা। হ্যাঁ এই রে আচ্ছা previous matter not this week না not today. None appears for the parties, adjourned for the day. Yes. Your matter.
I appear on behalf of the petitioner. Here's
My lord,
my
before it starts, my lord, I have instruction from the council, learned council appearing for
You have instruction?
from the learned council appearing for the WBSCDCL, my lord. He is on his legs in another court, my lord. He has prayed for a day's adjournment. If it
Who is
becomes-
appearing?
My lord, Mr. Konok Kumar Bandyopadhyay, my lord.
Yes, what is your matter? Can you wait for a day? And what is your matter? Not getting electricity?
My lord, may it be taken up on Tuesday instead of
Tuesday. Tuesday will be helpful for you also because if it's Monday, then it will be on the combined list. On the prayer of learned council for the distribution licensee, the matter is adjourned till July 4, 2023, when it will be listed fairly at the top of the list.
May I hand over the affidavit of service?
Affidavit of service filed today be kept on. What is your name, please?
My name is HON'BLE.
You move on the next day when it is taken up.
18,
Yes.
I am for the petitioner, my lord, in item number 18.
Good service affected on all.
Well, let me, government pleader is served.
Yes.
Lordship, there
Government is the main
private
party.
Lordship, government is the main party. However, this private respondent's presence is necessary. Because
You are appearing for the private
the
respondents.
state.
now this is an order passed by HIRA, earlier that Housing Industrial Regulatory Authority.
Yes.
Now, Lordship, this order was passed by that tribunal in 2019.
Is there any scope of interim order in this?
Lordship, the scope, it has to be reviewed by this court. Lordship, I'm challenging the judgment passed by this.
If there is no
authority.
scope of
So there
interim
is-
order because they're not appearing, I can direct affidavits also.
Affidavits has to be directed.
What is the scope of the dispute?
Lordship, kindly
If
come
I
to
hold
the-
it not to be maintainable, then it goes.
Now, kindly come to this order. It
Yes.
starts from Lordship, page 48 onwards. It was 2020, this order was
Your
passed,
ground of challenge is jurisdiction.
not jurisdiction. Round of challenge is
Yes.
that it was observed that there was deficiency in service.
Hmm.
There was fault on their part to provide me the proper informations about the flats. And particularly regarding a scheme floated by the government.
You have served properly on the private respondents.
Because you serve properly, then whether it is served there. Let me.
Item delivered, just check up that. No, that is sending. See your track reports.
Yes, ma'am. Lordship, it shows item received,
By them also, private respondents.
private respondent, item received.
Very good. Please continue. Yes.
Now, kindly come to, so after this detection, they said that there was fault, but no compensation is given. Even the money which is taken by them is not returned to me. Now I am in a position which I don't want the flat to be given. I don't want to buy. Now, Lordship, kindly come to paragraph number 32 onwards. Page 88. We have already discussed above that till before 30th June 2019, the appellant did never assert that being attracted by the information of the PMAY scheme, he had booked his desired flat. However, let us assume and accept for the present that the appellant since after June 30, 2019 had started to ventilate his grievances, that because of the incorrect information
under reference, they had started to ventilate their grievances and to criticize the act of and activities of the respondent company by email up to the end of July 2019. But while we took note of the relevant text again of Annexure G quoted above, we found that the appellant became docile, rather submissive, to point out that they did not miss the scheduled dates, and so they claimed that the sale agreement could not be said to have not been executed due to their fault, and that is why on receipt of the communication dated 22nd August 2019 of the threatening nature from the respondent company and appellant by such reply through mail dated 30th August 2019 earnestly requested the respondent company not to cancel the booking to make said agreement executed as early as possible, since according to him all payments had been made within stipulated time. So the matter might have remained only upon negotiation between the parties as to whether, as per the terms and conditions, even mutually for the book flat, whether the respondent had received the claimed amount, or else they could be ready and willing to execute the said agreement in favor of the appellant or not. It is needless to mention that if the claim of the appellant in such complaint case would be likewise, that despite payments of their required money in terms of GTC, sale agreement was not executed, not being executed, then of course the remedy would be under this act under some other provision. But in view of the nature of the grievance raised in the complaint, and as it has been extended up to the stage of the appeal, restricting to the alleged relief only under section 12 of the act, the complaint case or its appeal cannot be stretched to the different angle for adjudicating in this third case.
After preferring the appeal, you have asked for the refund.
Lordship, that was the appeal, because appeal against the order of the first adjudicating authority.
First adjudicating authority, before that authority also wanted refund.
Because there was an attempt to make the negotiation.
What was the initial complaint?
Initial complaint was that I want the flat and I wanted the flat to be given to me. I paid the money. It was the initial complaint. Lordship, there was the allegation that this company was making the disparagement regarding the information. They said that there is this particular project is falling within this PMAY scheme. However, that area cannot have the application of PMAY scheme, because PMAY scheme is basically for the panchayat area. That area, there was a difference on that particular point. Now, there they pointed out this at the time from their side, this was argued. Now, Lordship, your Lordship may kindly come to paragraph number 33. Another important aspect should not be ignored to criticize the comment about the conduct of the appellant. Now, the same judge is making this comment. The appellant filed the complaint case before the learned designated authority on 3rd August 2019. Nonetheless, for lodging of such complaint case seeking relief from the learned authority, as already mentioned, the appellant utilizing email ID of his wife had sent the mail to the officer of the respondent company via Annexure G, the text of which has also been quoted above. So, in one hand, by lodging complaint, an appellant had sought for relief of refund without any deduction by cancelling their booking. And on other hand, by above mail, they were pursuing to execute the sale agreement, claiming that they had fulfilled all the criteria and did not book the cancel the same. Really, we are in a dilemma as to what actually the appellant would want in the proceeding. Before any legal system, double standard game is not entertained. Before any legal system, double standard game is not entertained. If on record, it is understood that either of the parties has been playing such double standard game, then it is only discouraging, but it is highly condemnable, especially because one who seeks equity must do equity, failing which the standard of rendering natural justice will be frustrated. However, as because during pendency of this complaint case, the respondent had received the mail dated 30th August 2019, the respondent company, instead of cancelling the booking, rather keeping aspirations of the appellant in having his desired flat in Solaris Joka still alive, had given opportunity to fulfill the condition or else the notice dated 18/9/2019 would have to be treated as cancellation of booking, and sums deposited by the appellant would be returned in terms of GTC. From the record maintained before the learned designated authority, we found that the learned authority took statements of the appellant and his wife respectively on 23rd September 2019, and on the second, the last date of proceeding, that is 21st October 2019, the text of which were mounted over the information of alleged availability of the loan under PMAY scheme in Solaris Joka, on which we have discussed more than enough. Section 12 can be invoked only when the parameters are fulfilled.
Apparently, Mr. Chatterjee, it has been observed in the next sentence that there is no doubt about it that respondent has published misleading information.
Yes, that is the reason I am
the prospectus. Yes, but the forum proceeds to say that you have shown nothing to show that by being misled by that. What was the nature of the wrong information? Was it German?
It was German.
Was it unimportant and you was laying too much stress on that?
The
what was the nature of the misinformation?
Misinformation is that this project is covered by PMAY scheme, which was not. Because of the situation of this particular construction, proposed construction, this cannot be covered within that area.
Show me something from the records to indicate that that was that representation was given by them.
Yes.
PMAY. Any page of their prospectus or advertisement
Yes,
or
my
whatever.
lord. Lordship, kindly come to page. Let me check Lordship once.
Oh yes, page 34.
Yes, my lord.
Page 34, that is specifically there.
Yes, yes, my lord. The credit link subsidy scheme. Now, this was made there that the flats at Solaris Joka conform to the norms prescribed for benefit under the credit link subsidy scheme of the government of India's Pradhan Mantri Awas Yojana.
What about your double standard? I've seen this. What about the double standards you were asking in one breath for refund and in other for
Right now, Lordship, I am not seeking the flat. Kindly, if your Lordship directs the refund, I'll be very happy. I'm very happy with my small house.
Yes, what do you say to this? I mean, you cannot have anything to say.
We cannot. We
Achha, file your affidavit of service.
That has
I'll
been-
direct affidavits in this. I have to. Learned counsel, affidavit of service filed to be kept on record. None appears for the private respondents. Although the petitioners and the state are represented through counsel, full stop. Sorry, petitioner hobe, singular. Learned counsel for the petitioner contends that it was clearly given out by the private respondent stroke realtor, comma, in its advertisements and prospectus, comma, that the housing scheme for which the petitioners had paid due amounts, comma, would conform to the norms prescribed for benefits under CAPSE, credit linked subsidy scheme, within bracket CLSS, bracket closed, of Government of India apostrophe Pradhan Mantri Awas Yojana, within bracket PMAY, bracket closed, gap, space, দিয়ে তারপর hyphen, housing for all. Full stop. However, comma, the respondent, the private respondent number, which is the respondent number? In reality?
Respondent number 4.
Yes. However, subsequently, the respondent number 4 resigned from such position, and it transpired to the petitioner that the housing project was not governed by the said scheme, comma, thereby putting to the petitioner to extreme difficulty. Full stop. Next para. Although initially the petitioner had paid all the amounts and was interested in taking delivery of the flats, comma, upon coming to know of the said misrepresentation by the Respondent number 4, comma, the petitioner now seeks refund of the money paid by the petitioner without any deduction being made therefrom. Full stop, next para. Although the appellate forum below, comma, upon the complaint lodged by the petitioner, comma, observed that the respondent number 4 had given out misrepresentations and that there is no doubt that the respondent number 4 had published misleading information in the prospectus and also in the website, comma, the appellate forum proceeded on the premise that the petitioner was maintaining double standards in asking for reliefs, comma, insofar as the petitioner was not sure as to whether he wants a specific performance of the agreement or a refund of the money. Full stop, next para. However, comma, prima facie, comma, the said prayers can be made in the alternative, comma, particularly in view of the changed scenario. Full stop, that apart, comma, a strong prima facie case has been made out by the petitioner as to whether the order of the appellate forum suffers from perversity insofar as the same is contrary to the findings and the materials on record. Full stop, hence, comma, the writ petition deserves to be heard on merits. The respondents shall file their affidavits in opposition within 3 weeks from date. Reply, if any, shall be filed within 1 week thereafter. The matter shall be listed for hearing in the monthly list of August 2023. Full stop, the petitioner shall intimate the gist of this order coupled with a server copy of the same to the absentee private respondent within a week from date. Grateful.
19.
In this matter, Mr. Abhimanyu Banerjee was not appearing for petitioner. He has not come court because he got swelling on his left jaw. And I'm praying for
On the prayer
1
of
week
the-
accommodation.
On the prayer of the petitioner, the matter is adjourned for a week and shall next be listed on July 7, 2023.
Oh, that's right.
20.
My lord, unfortunately, it was filed before your lordship. My lord, this relates.
Can't hear, yes?
My lord, this relates to police overaction in action. My lord, we are
Oh.
carrying the proceeding.
In view of lack of determination, the matter is released from my list with liberty to the parties to mention for inclusion before the appropriate bench having determination to hear the same. This is that matter.
Yes, my lord.
Thank God.
I was trying to mention in the morning. my
But
lord.
only 7 volumes, my lord.
Only 7 volumes.
All the best to Justice Sengupta now.
Yes.
Yes.
1 volume, just 200 pages. Other than that.
Huh? Other-
I wish all the best to Justice Sengupta who is taking up this.
Yes, my lord. My lord.
21.
Yes, Mr. Theori, what is the matter?
Hey, sir, I think, sir.
My lord, I am for the petitioner. Service is not completed yet. I am praying for not today.
On the prayer of the petitioner, comma, since service has not yet been completed satisfactorily, let the matter stand adjourned for the day. Thank you. এগুলো কিন্তু কমান্ডেড গেলে তলায় যায় না। মানে মোশনের তলায়, হ্যাঁ নতুন নতুন, হ্যাঁ হ্যাঁ এক্স্যাক্টলি।
22.
Well, I appeal for the petition.
You are for the petition. All right. You are for the respondent. Lordship. Yes.
The petitioner.
You are for the bank.
Lordship.
Sorry. Yes. The other respondents have been served.
Lordship, only bank is the
Only bank is the
respond. All the rest.
all the rest.
Oh, all right. Yes. Please continue.
My lord, that the petitioner taking loan from the bank for purchase-
Surface
Surface
action.
Surface action, my lord.
Up to what stage? Section 14.
Without proceeding the section 14, they are taking the possession without serving any notice. One side, the bank issued notice for settlement. Another side, bank issued the notice for e-auction.
Please show me that notice of settlement.
My lord, lordship, kindly page 2. Page 17, Annex P1.
This was in December 2021.
Lordship, yes, Lordship, that was continued, and Lordship further.
Show me the last one.
Lordship P3, Annex
P3,
page 19.
Page 19, yes.
Yes.
So that was in October 2022.
Yes.
Which is
Lordship, this
about
scheme valid for
9 months.
31st March 2023. That at that time, Lordship, the petitioner wrote a letter to the respondent bank that the Lordship kindly see the annexure P4, page 22. Wrote a letter that how much amount they have settled.
21 actually, yes. 21 is P4.
Yes, Lordship. Thereafter, bank sit tight over the matter without any
But
information.
if there was no OTS, then you are gone.
Lordship, that
You are the borrower, admitted.
yes, Lordship. It was that
go before the debt recovery tribunal.
Already section 17 application is pending.
Pending before that that application, there is a no regular bench. Lordship, the auction was auction on
Regular,
27.
no regular bench means there is a bench.
There is a bench, but
It's not sitting regularly.
Sitting regular.
I am also not a regular bench.
Siliguri is in ceasing about the matter. And
what about this regular bench not functioning?
no. Even today also put up matters are being taken up by the presiding officer in charge of DRT to Kolkata.
The auction was
I'll not go into the merits at all.
7.
Because your last chance actually expired in October, about 9 months back. That last offer of OTS.
But,
You have not availed. I'll not go into this.
That's it. Bank not any information that how much they actually settled the amount. That my client ready to settle the loan account. On that regard, his
There was a specific scheme. This was a specific scheme.
He mentioned the scheme, but how much amount was settled or not? They have how much amount will be paid. They have not any information.
You did not reply to this OTS
Did
scheme.
not reply, Lordship. Perhaps.
Page 22, there's a letter written by them pursuant to the scheme.
Lordship, they had
21.
What is the stage? You are taking possession.
Lordship, position has been taken.
Then what can I do? I'm sorry.
But they are without taking any service, any notice under section 32.
Your better forum will be the debts recovery tribunal. Better forum, not in the sense that, I mean, not in any other sense. You will be able to take the questions of fact there also. In 226, my hands are very tight. In view of availability.
Only direction to the bank can, as per settlement, or if the bank can proceed as per settlement.
At this stage, after taking possession, then
Yes,
if the
Lordship.
no.
Lordship can.
In view of availability of
Lordship,
an
they are
alternative remedy, equally efficacious alternative remedy in the form of an application under section 17 of the SARFAESI Act, which has already been availed of by the petitioner and is pending before the appropriate tribunal, this court chooses not to entertain the present writ petition, full stop. WPA 15001 of 2023 is dismissed as not maintainable. However, with liberty to the petitioner to take all the points taken in the present writ petition before the tribunal where the petitioner's application is already pending. Full stop. Nothing in this order shall prejudice the petitioner, prejudice the parties in any manner whatsoever before the tribunal. No arrest to cost. I'm sorry. None appears. Next monthly list. Yes.
I'm for the-
24.
This is my affidavit of
I
service.
appear on behalf of CA.
You're for private respondent.
I'm for private respondent number 4.
Mukta.
Private respondent number 5 has refused. Private respondent number 5 has.
You're
refused.
for whom?
I am for 4.
Who is for?
4 and
Two-
5 are.
two
the-
private
respondents are there, Lordship.
The main object.
The other, what is the endorsement?
Refused.
Oh, yeah, what is the matter?
Lordship, petitioner is the owner of the premises and Lordship and consumer of electricity. Now, Lordship, due to some problems, petitioner has applied for shifting of the meter from the existing position to a common place. Now, Lordship, the respondent number 5, who is
Occupier means you are the owner.
owner.
Yes.
So respondent number 5, who has refused, he is the tenant of the said premises and running a factory. The factory is now closed and the main common service position is located in the factory room of the private respondent. And what happened, Lordship, it is under lock and key. And for that,
By this fashion, you cannot take possession of that.
no, Lordship, I'm shifting of service.
Oh, from there to outside.
Outside, and the CSC authority cannot read meters every month, and due to that, I have applied for shifting of the service, Lordship, to a common position.
What do you say?
Well, we have to inspect, madam. You kindly come to paragraph 7 at page 3.
What is the objection? No, if they want shifting, you have to shift.
We have to inspect first, madam.
For what purpose?
Whether it is feasible to shift.
Whether there is any alternative location suitable.
May I submit
Well,
one
we were
thing?
not been.
No, I'll
able
come to
to
you soon.
We were not been
Yes.
able to inspect, madam.
Lordship,
Yes.
we could not make inspection due to that.
Yes, that you have.
The room has been locked. The room
Let
has
us hear Mr. Mandavade. Yes.
My lord,
Who are you actually in respect of the premises?
I am the adjacent owner. When the owner, there's a my lord, the position, my lord, I show my lord, generally I do not oppose this kind of.
Everybody says that before. Generally, now nobody opposes, but everybody opposes.
My lord, I should draw your lordship's attention to the pleadings of the petitioner, my lord.
Yes.
At paragraph 13, my lord, he says, my lord, the resident respondent number 4, third line, who is
Yes.
a resident of a separate portion of the said premises, and respondent number 5, who is a tenant of the said premises. That it implies that respondent 5 is my tenant, my lord. But at paragraph 10, my lord, your petitioner states that your petitioner filed the title.
No, not that. 5 is a tenant. You are a resident.
No, I am also owner. It is admitted fact that my client and the petitioner.
This does not imply that he is your tenant. No.
It is said that the tenant of the premises, of the said premises. That means that
objection raised by, let us see, read the sentence as a whole. The objection raised by your petitioner submits that petitioner is suffering due to non-shifting of the meters, and the objection raised by respondent number 4, who is the resident of a separate portion of the said premises, and respondent number 5, who is the tenant of the said premises.
That
as
means
such. Acha, very well. What else?
This
is nothing. I mean.
My lord, at page 10, my lord, paragraph 10, my lord. Your petitioner states that your petitioner filed a title suit being 5/30 of 2021 for eviction of respondent number 5. So if respondent number 5 resides in a different premises, irrespective of instead of his premises, then he should not have filed this writ petition according to his averment. Now, what, my lord, in
No, I don't get this point. He has already filed a suit for eviction of that tenant.
But according to him, the tenant resides in a separate premises.
Keeping that under lock and key.
Keeping that under lock.
That does not mean automatically the tenancy is seized. If the tenant resides elsewhere, keeping the tenanted portion under lock and key, the tenancy still remains. He cannot oust just like that. He has to move court and get an eviction degree.
My lord, but
there is no
he is not. But he is not a. According
what
to
is your difficulty in this?
My difficulty is that in the name of shifting, my lord, he is trying to encroach the common passage. Without encroaching the common passage or without violating the provisions of the partition deed, he may shift, my lord. I shall not have to object, my lord.
But first we have to inspect.
Where are you wanting to get it shifted on their on the common passage?
No, not on their passage, lordship.
Let it
In the
counsel for the
19/7.
Let it counsel for the petition inspection.
With that undertaking, my lord,
Let counsel for the petitioner submits that the petitioner seeks to shift the existing electricity meter, which is standing in a portion tenanted out to the respondent number 5, comma, the latter residing elsewhere, but keeping the tenanted portion under lock and key. Full stop. Next para, such hindrance is affecting the petitioner's interests, comma, since no inspection of the meter can be held, comma, despite the distribution licensee visiting the property. Full stop. Next para, learned counsel for the respondent number 4, comma, also one of the alleged objectors, comma, submits that in the garb of shifting of the electricity meter from the portion which is under occupation of the tenant of the petitioner, comma, the petitioner is apparently seeking to reinstall the meter in a common passage, comma, thereby creating hindrance to the user of such passage by the respondent number 4, comma, who is another co-owner. Full stop, next para. Be that as it may, comma, since learned counsel for the CSC Limited submits that the CSC Limited could not hold any inspection at the premises, comma, it would only be appropriate in the event an inspection of the premises, comma, in particular vis-a-vis whether it is feasible to shift the electricity meter to an alternative location without creating any hindrance to the common passage is required, comma, the full stop the comma, na? Since the private respondent number 5 chooses not to appear despite service, comma, the CSC Limited is directed to hold an inspection at the premises, comma, for the purpose of ascertaining the feasibility of shifting the existing electricity meter at the premises in question at 19/7 Muktaram De Lane, comma, Howrah 711101 PS Batra, to an alternative location within the said premises, comma, without creating any disturbance to the user of any common passage by the private respondent number 4. Full stop. A report in that regard shall be filed on the next returnable date upon circulation of advance copies to the learned advocates for the parties appearing today. Full stop. An advance notice of such inspection shall be given by the CSC Limited to the respondent numbers 4 and 5, comma, directly or through their learned advocates, indicating the place and time of such inspection. Full stop. Such inspection shall be carried out within a fortnight from date. Full stop. The matter shall next be listed on July 18, 2023, when the report shall be filed by the CSL.
Two more things.
Yes.
Two more things.
What things?
Well, let the respondent number 3 be the Bantra police station be directed
Pardon? Respondent 3?
Bantra police station.
Acha, very well.
And to break open the
If
padlock.
any obstruction is faced by the CSC personnel from the private respondents in holding such inspection, comma, it will be open to the CSC personnel to approach respondent number 3, the officer in charge of the Batra police station, for adequate police assistance. Such assistance, comma, on such occasion, comma, shall be given by the respondent number 3 by acting on a server copy of this order at the cost of the petitioner. Full stop. In the event any padlock or other obstacle is put up from any quarter to resist the CSC personnel from having an inspection at the premises and at the existing meter board position, comma, the police personnel shall be at liberty to remove such obstacle, stroke hindrance, stroke padlock, for the limited purpose of giving an inspection to the CSC personnel. Full stop. Next para. But this will be giving possession to you.
But it will be in my possession only.
Tenancy is still there. Eviction suit is pending.
Yes, I am not evicting, I am just shifting the common service.
After breaking open the padlock, what will happen to the property?
So you can again put padlock.
And the key will be with?
In lordship. That's why I am shifting the main service, because CSC authority cannot take meter reading.
Character line at Kudu. However, comma, it is made clear that in the garb of the above direction, comma, the petitioner, comma, during pendency of the eviction suit pending at his behest, comma, shall not be at liberty to take possession of the tenanted portion, comma, which is admittedly in the legal occupation of the respondent number 5 at present. Full stop. After breaking open the padlock, comma, the respondent number 3 shall re-affix a lock on the entrance of the said tenanted portion and retain the key with itself. Full stop. In the event the respondent number 5 seeks the said seeks the key to the said lock in future, comma, the respondent number 3 shall hand over the said key to the respondent number 5, comma, without any prejudice to the rights and contentions of any of the parties to the pending eviction suit between the petitioner and the private respondent number 5. Full stop. Such handing over of key shall, comma, needless to say, comma, be subject to the outcome of the civil suit between the parties.
Grateful.
Grateful.
Deeply.
Troubling, my lord, with respect to item 31 in today's list, my lord, we had taken leave day before yesterday. It's a very urgent matter. I'm led by Mr. S.N. Mukherjee, my lord. In case lordship has any fixed matters at 2, my lord, kindly spare 5 minutes.
2 PM ki ache? No, come back at 2.
My lord, item number.
My
lord, in that case, my lord, I have 29. My lord, I have also extreme urgency.
What is the extreme urgency?
It's a blacklisting tender matter. My other side is also
Yesterday,
there.
Lordship, the
I am.
office was closed. They are served through email. In the morning, it was forwarded to me. It's about 300 and what pages petition. Also, I could not even.
What is the urgency?
There is no such urgency. The
Yes, my lord,
order
there
of
is-
What is the urgency?
I have been debarred, my lord. He was the provision of the tender clause.
Wait for some.
My lord, item number.
Come back at 2, lordship. I'll
Your item at 2, Mr. Shah.
My lord,
item 31.
my lord.
Lordship, kindly take up the matter witness because our case.
No, whenever it will come up in the list.
My lord, item number 25, 26 and 27, my lord, I am praying for not today, my lord.
Why?
My lord, I am led by Mr. Arijit Chakraborty.
Oh, the next few matters?
Next.
Achha, board dekhiye dekho 20, you are appearing in all the matters?
Yes, my lord, 25, 26, 27.
Mr. Ghosh, you are also appearing in this
Well,
matter?
I'm in item 28. Mr. Banerjee is online.
Malats, I am
If your lordship is
appearing in
taking up
28
other 2
minutes.
PM matters, then if your lordship takes it up.
With 25 to 27, not today. On the prayer of the petitioner, the matters are adjourned for the matter is adjourned for the day. Separate orders in all 3.
Item
This is yours is item
28.
28. What are you asking for? After this 2 PM matter, I'll be taking up those matters. Your matter in normal course. I'll continue.
Lordship, in respect
Are you
of
okay,
item number
Mr.
230,
Banerjee?
Malats, my
30.
first submission would have been,
on
it should have been,
27th June,
it
Lordship,
would
your
need to be
Lordship was
filed
pleased to
before
direct
the
me to
circuit.
serve the election commissioner.
But I think
But
Mr. Banerjee is
within-
trying to
Mr.
say
Banerjee, yes, Mr. Banerjee.
we can't.
Malats, I'm only saying this. My first objection would have been it should be filed before the circuit bench, which is in session at the present moment, and it's not.
Your Jalpaiguri matter.
NGT Calcutta.
Malats, it's not NGT Cal, but it concerns Andaman,
Yes.
and Malats are aware of the appellate side rules,
Eastern-
which would and the Andaman
Well, it'll be
court
before.
is in session.
We have considered the tribunal is in Calcutta. The Eastern.
So that will be one of the arguable points then when we come back.
Yes.
So, Mr. Banerjee, that will be one of your arguments at the time of call.
Only thing
Yes,
is,
Malats.
I have a 2 PM. That is why I'm a bit.
You will get
worried.
5 minutes in the other matter.
Extra 5 minutes. never-
That 2 PM fixed matter will be called on first.
When I-
Your
I-
other matter is in which court?
Justice Rao is fixed a suit actually.
It's a suit.
2 PM is fixed, yes.
So if you are not there, if time is paid for, then I'll grant adjournment.
Malats, if my learned friend is not appearing, Malats, what purpose does it serve for me to be present? Because I am obviously very afraid. It's a very important matter for us.
Showing your
It's a
client,
very,
Mr.
very
Banerjee,
important.
you are diligent. Apart from showing your client, you are a diligent counsel, which you are in any event.
No, Malats, are being very kind, Malats, are being very kind.
That's why I mentioned it. Because if I'm stuck somehow.
28 তাহলে board এ দেখিয়ে দেবো 28 টা call করে then I'll grant time. 28 Mr. Banerjee, then I'll make it not today then.
But my lords, my submission would then become infructuous because I think the entire circuit bench argument will not, because I think that's today's the last day.
Mr. Banerjee, in due course, normal course. I'm not taking it up today then. Just
Yes,
not
in normal course, let it come, Malats, I'll take.
normal
Yes,
course.
yes.
At 2 o'clock on Monday, then he can come.
I'm not recording any order. Let it be not today then, because now it's 1:18. So 2 PM, if you are there, I'll not call it. I'm making it not today. All the parties are there represented.
I think they're all.
Mr. Banerjee and you are the main parties.
Yes.
Yes.
So not today on that. ওটা not today থাকবে. লিস্টে থাকবে সোমবার.
Monday monthly list, it might be 1,005.
Malaj, my learned friend will have to take the risk. There's not, Malaj, my
No,
learned
Mr.
friends
Ghosh,
can't have his cake and eat it too.
With glee, I'm informing you, it may be more than that.
If some time can be.
যেটা মেনশন করলে যেটা 2 PM
Milords,
দুটোর সময় যদি মেনশন করে তখন দেখো
Lordship, Lordship, in respect of authority, Lordship, your Lordship were pleased to serve the respondent number 2, the election commissioner, and the matter will be heard on 30th June. Lordship, that is what.
A hungry judge is an angry judge. As
Milords, with your kind permission, Milords, may I have your leave to mention item?
Parle, but in a paraphrased manner.
It was directed that the matter shall be positively taken up for hearing on June 30th.
Often tell lies. I'm a human being. I said that I'd positively take it up.
Lordship,
Did I say that?
Lordship,
Why did I say that?
this is election matter, Lordship. The assistant professors. I have served them the copy.
No, you will indicate in your letter that it shall be positively taken up. That does not bind the court.
This is
Read it out.
service copy, server copy, Lordship. This is.
Read it out. You are directed to indicate to the other side that this will be positively taken up. You have indicated, you have complied. Not a direction in the court.
This is election matter, Lordship.
Election matter, election is over probably, half over.
They have
What
been
election
appointed-
matter?
They have been appointed.
Item 230.
230, Lordship.
Well done. On Monday, I'll take it up at the top. Fairly at the
My
top.
lord, may I just renew my prayer, my lord?
No, not your prayer. I've
Only
on
till
similar
my-
ground.
Milords, may I mention, may I have my lords' leave to mention item 29, Milords? Milords, I'm appearing for the petitioner in item 29, Lordship. Milords, this is a tender matter, Milords, and Milords, the petitioner has been blacklisted in this matter, Milords. The urgency in
Two fixed matters at 2 PM. After that,
Yes.
I'll continue in due course. If I can take up your matter, I'll take up your matter. Otherwise, on Monday.
Milords, may I then request that if the matter is taken up on Monday, if it doesn't reach today, would my lords consider having it on top of the board, my lords? I've been blacklisted for 5 years, my lords, and there
Ma'am,
is some grave.
I'm refusing others on the similar ground because of the pressure on the list. I'm sorry, but your matter is fairly up on the list. So let us
Milords,
wait.
it's item 29. I'll wait, my lords. I'll wait.
Very well, very well. Thank you so much.
I'm grateful, my lords. I'm grateful. Deeply grateful.
date, 219.
I'll extend on Monday, Mr.
In the
Halder.
meantime, they will install the transformer.
Should have mentioned earlier, Mr.
My lord,
Not at
I
this stage.
tried in the morning, but
Why didn't you mention on Monday? I would have fixed it as to sir.
my lord, adjourn at least for 7 days.
No, not like this.
My lord, it will be otherwise they will.
Mr.
do.
Halder, this is a very bad. You give the slip, I can keep it as to be mentioned, to be for extension on Monday, but at the best that.
At least 2 days adjournment.
No, not like I don't pass orders like this, Mr. Halda, out of the turn without any intimation to the other side. No.
So today is the last day, whichever is earlier.
Maybe, Mr. I'm
Well,
sorry.
It can be 7 days.
My lord,
7 days.
Similar prayer, same
No,
answer.
no, I mentioned the matter in the morning 32 and
Oh, that I'll
33.
take up,
Lordship
please.
wanted me to come back at 2.
কোনটা ফিক্স করছি টুপি তাহলে ওনারটা এরপরে আরেকটা আছে তো না এরপরে এটাই ওনারটাই after this matter I have fixed one matter, after that I'll take.
Extension till Monday, my lord.
No.
Till Monday, 3
No.
days. Heaven
No, Mr. Halda, not like this.
Heaven will not fall, my lord. but
Heaven
they-
will fall, heaven will fall.
They will install the transformer.
Item 31.
Yes.
Item 31.
Ramadan.
Yes.
Lord, I'm moving ex parte, my lord. My lord, my client, my lord, is a
I
manufacturer.
have not been served, but my lord, I appear for the Kolkata Port Trust.
Oh. So then,
My lord, I said I'm moving, my lord, ex parte, my lord,
Right,
because
right.
my lord, of my lord, the urgency.
yes.
My lord, my client, my lord, is manufactures cement. Now, my lord, it has to, my lord, it requires clinker, my lord, for production. So, my lord, on the basis of, my lord, coastal trade, we, my lord, were to get clinker. So we had, my lord, an arrangement with the Port Trust, my lord, for priority in berthing. And, my lord, we mentioned, my lord, the amount of clinker, my lord, that we would, my lord, import for a 3-year period. And to get that priority, my lord, a minimum guarantee, my lord, was, my lord, provided for. This was a 3-year arrangement starting from 2019. Now, my lord, in the meantime, COVID, my lord, intervened. That resulted in, my lord, the entire arrangement having to be reworked. And I was given time, my lord, till 2024, 30th June 2024, to bring in this amount of clinker, a minimum guarantee with regard to, my lord, this clinker. Now, my lord, to, my lord, secure, my lord, this minimum guarantee, I had also, my lord, given a bank guarantee, my lord, to the port authorities. Now, prior to, my lord, expiry of, my lord, the period, which was 30th of June 2024, my lord, we realized, my lord, that COVID had had such an impact that, my lord, it was not possible at all. So, my lord, we intimated them that from February 2021, my lord, that we could not, my lord, continue, my lord, with, my lord, bringing, my lord, a clinker in and wanted to opt out. We also gave, they, my lord, made a further offer, which we were not in a position to accept. And, my lord, in December 2021, we said, sorry, we cannot do this. And we want out. Whatever proportionate amount that you feel is due and payable, we'd be willing to pay that amount.
Was there such an option in the agreement itself?
Yes, proportionality. Now, my lord, in fact, the agreement, my lord, was a piece of paper, my lord, 1 page. It wasn't that formal. But, my lord, what happened was, my lord, they went ahead and invoked it, my lord, for over 20 crores. My lord, we moved, my lord, a writ petition in which, my lord, we obtained an interim order and ultimately the writ petition was allowed. I just want to show you because that is, my lord, where, my lord, then what happens, my lord, this is a consequence of that. Kindly take
Got
that.
an injunction regarding the bank guarantee?
Yes, my lord. And, my lord, that order, my lord, has now been accepted by the parties.
All right.
Because, my lord, it was done, my lord, for the entire amount. And, my lord, I'll also be, my lord, hopefully, my lord, the suggestion that I'll make before your lordship, my lord, would I hope, my lord,
we accepted, my lord, as a reasonable suggestion. Now, my lord, kindly take the order at page 82. At page 82, my lord.
Yes.
My lord, yes, the date of the order, my lord, is 22nd February 2023. Now, my lord, kindly have a look at a few, my lord, provisions, my lord, a few findings, my lord, in the order. Paragraph 7 at page 85.
Yes.
The petitioners faced several difficulties after the onset of the pandemic, which included scrapping of the vessel provided by Seaport Logistics. So, my lord, a vessel had been chartered, my lord, which would, my lord, bring this clinker. My lord, situation was such, the vessel had to be scrapped. Then, my lord, petitioner number 1 was forced to charter another vessel for carrying cement clinker. There was also a decline in cement demand and a rise in freight rates pursuant to lockdowns caused by the pandemic. The petitioner number 1 made several representations to the respondents indicating the unforeseen conditions and requested the respondents for time till September to resume coastal movements. Petitioner number 1 availed of the priority berthing for the last time, kindly note, in February 2021. The respondent number 4 thereafter issued a letter to the petitioner number 1 on 8th December stating that the respondents had extended the period for fulfillment of MGT up to 30th June and a further request for extending the timeline could not be acceded to. Now, my lord, kindly take paragraph 12. My lord, page 87. The special equities in the case arising out of at least 2 factors. First, the respondents have not suffered any loss on account of the petitioner number 1 not availing of berthing services provided by the respondents too. My lord, I had priority in berthing. My lord, I didn't block a berth. In case I came, I would be, my lord, given berth.
But if we did not avail of that, that was not utilized. I mean.
Yes, my lord, others moved in, my lord, and my lord, whoever berth. Priority granted to petitioner number 1 with regard to berthing of vessel carrying cement clinkers did not mean that respondent authorities would be under an obligation to give a dock for the vessels of so-and-so. It only meant that if there was more than 1 vessel arriving at the dock at the same point of time, the petitioner's vessel would get priority in calling and berthing. In the event more than 1 MGT provider was present at the dock, the senior most vessel, according to the MGT provider, would get priority. Hence, by making a demand of 20 crores without suffering any loss would amount to the respondent authorities making a windfall gain and unjust enrichment. The privilege of priority berthing was in any event availed of by the petitioner number 1 for the last time in February 2021. Now, my lord, ultimately, 1 minute. Kindly take, my lord, the last, my lord, page of that order, which is at page 91. 90, my lord. I want to show from 90.
Yes.
Para 20, my lord. We had an interim order. For the above reasons, this court is inclined to confirm the interim orders and quash the impugned notice of demand dated 22nd July 2022 and September 9, 2022, together with the subsequent letters issued by the respondents on so-and-so. This judgment, now my lord, kindly note this, shall not preclude the respondent authorities from demanding a justifiable amount of penalty from the petitioner number 1. It is made clear that the petitioner number 1 shall be liable for penalty on account of shortfall which is to be calculated from and on the basis of the letters and MOU between the parties, including the last understanding arrived at between the parties. The petitioner shall pay the calculated amount to the respondents within the framework of the correspondence or within any agreed timeframes and on such terms. Now, my lord, we had, my lord, February 21 as the cutoff date. So, my lord, if I had, my lord, there was a shortfall with up to February 2021, we were, my lord, willing to, my lord, pay for that. Now, after this order of February, a letter comes, my lord, after 5 months on 19th June 2023. Kindly come to page 92.
Yes.
This shows, my lord, acceptance, my lord, of the order. Pursuant to the, kindly see the letter, pursuant to the Honorable Order of the Honorable High Court dated 22nd, above referred writ petition was disposed of with a directive which is as follows. Then, my lord, that portion which I read, my lord, is quoted. Then in terms of the said order, HDC have recalculated its claim considering MGT period for 5 years from so-and-so and your MGT withdrawal from 1st January in terms of your letter dated 31st December, same is shown in the table. And on that basis, shortfall amount kindly see 9 crores 48,62,287. I'm directed to inform you to deposit the above stated amount of 9 crores 48 lakhs so-and-so at HDC. Now kindly note the number of days. Within 3 days from date of issuance of this letter. So on 19 June, my lord, they write, say within 3 days you do it. Page 93 is our response. Straight away, my lord, 21st June. We, my lord, narrate the facts. My lord, para 5, we set out the judgment. And my lord, kindly now, my lord, the relevant portions of the judgment. And then, my lord, after clause 4 of para 5, therefore, in terms of the judgment of the Honorable High Court, if any demand is to be raised, it cannot include any period for which no loss has been suffered. The judicial have been raised since the Honorable High Court has already held that no loss was suffered by the post February 21. No calculation can be legally made for any period post so-and-so. However, your claim of 9 so-and-so appears to include penalty calculated for a period after February, namely for the months of March 20 to December. This is unjust and unfair in terms of the judge, the claim without suffering any loss, etc. Accordingly, we request you to recalculate your claim till so-and-so in terms of the judgment delivered, etc. Now, my lord, to that, on 26th, my lord, they write saying, no, this is not the case. And then on 90, at page 98, we are informed by the bank, my lord, that, my lord, there's an invocation on 26th itself when they are writing. Now, there are two, my lord, representations. My lord, I am now, my lord, why I say, my lord, this is not, my fundamental point is, this calculation, my lord, is not in terms of the judgment, my lord, which was, my lord, passed. Now, why do I say so? My lord, first is, my lord, it had to be, my lord, taking into account, my lord, all, my lord, letters, my lord, which had been exchanged. 2 letters I wish to point out to your lordship. Kindly take page 71. This is a representation of 6th of August 2022. And here, my lord, we had at paragraph 3, my lord, kindly come to para 3. As per the calculation, port has reckoned the volume of cargo handled in second tenure as so-and-so instead of so-and-so, which needs to be verified and corrected. Then para 4, by applying the correction suggested in para 1, 2, and 3 above, calculation furnished to us in your letter dated 22nd July would stand corrected as under. Then, my lord, it stands corrected to 9 crore 25. Then para 5, as the above calculation is made up to the period of December 21, we are not agreeable to the above penalty calculation. If the above methodology is followed for the period up to February 2021, up to last voyage done by us, the maximum amount payable by us would be rupees 4 crore 25, etc. So we point this out in this letter. Then kindly come to page 92, my lord. I'm sorry, page 92, my lord, I have already indicated. So this was, my lord, this 4 crores odd. And unfortunately, my lord, I'm told this, yes, my lord, this letter, my lord, was drafted, my lord, this petition was drafted in a hurry. And my lord, so my lord, the complete letter is not there. My lord, I have, the last 2 pages are missing, my lord. I have, my lord, I have the, now, my lord, kindly take, my lord, page, there's another page, my lord, page 69. Where we have said, my lord, cutoff date should be February 30th March 2022. Kindly turn over, my lord, the page, my lord, to page 70. My lord, penultimate paragraph, my lord, starting middle of the page. Now, in view of the above difficulties and due to force majeure beyond the control of either party's contract could not be performed as originally, we request your forbearance with us until normalcy. We would make efforts to continue through HD on in order to achieve a win-win situation. We request you to drop in case our above requests could not be acceded to and proceeded with levy of penalty for shortfall. We fervently request your good selves to consider 28th February as cutoff date, so and so, for the period prior to force majeure occurred being the month in which the last.
So
Accordingly,
you insist upon that February 2021 being
correct,
cut
and
off?
it's 4 crores. They've demanded 9 crores odd. My lord, I'm willing to pay that 4 crores odd, my lord, straight away within a week. My lord, they can, have the payment. It need not come out of my bank account. My lord, I'll pay within a week. So this is what I submitted, that as per the order.
They have already invoked the bank guarantee.
They have. They say, on 26th they have. But it has not been paid out. That information, I have till this morning. And I must tell your lordships, the guarantee,
yes,
also expires. I had extended it till 30th June. They come, and do it. Now they have, of course, invoked it. So if your lordship wants, there's no need for extension. But if your lordships feel, that it needs to be extended, I'm also, willing to do that. And 4 crores,
you have made the bank also a party.
Yes.
So what sort of an injunction you can expect now? That the bank won't give effect to that invocation?
Yes. Or, they should not, insist on this. This is, what I'm praying for. And 4 crores, or, 4 crores, whatever it works out to, 24 crores, 4 crores, 25 lakhs, 21,912. I'll pay, within a week. And, another point I wish to make before your lordship, and that was also the finding with regard to the first invocation, that it's not in terms of the guarantee. Kindly have a look at the guarantee, page 50. Page 50. Lordship has that, my lord. Kindly take line 33, my lord. The lines are, my lord, indicated on the left-hand side. If at the end of the period 30th June being implemented, it is found that company has failed to fulfill the minimum guaranteed throughput commitment, the shortfall of the indicated value, so they have to indicate, will be made by the company within a period of 30 days. So, my lord, 30 days time, my lord, when, my lord, value is indicated. Value, my lord, in this particular case, my lord, is indicated, my lord, on 19th of June 2023. That's page 92.
So at least it should have been 1st of June or 31st of May.
Correct. So, my lord, I have 30 days. Then it says, in case company defaults in making payment towards a shortfall in respect, KOPT shall have the liberty to the extent of shortfall only. So, my lord, after the indicated value, I was to get, my lord, 30 days time. The letter says 3 days. And then, my lord, without giving, so it's not even in terms of, my lord, the guarantee on the face of it.
Very good. So, Mr. Shah, would you like to add in?
Well, I have not been served, but my lord, from what I recollect, and my lord, what my learned friend, my lord, just shows me from the previous petition, my lord, first of all, my lord, the invocation was for a sum of, my lord, demand was for 20 crores and not. The shortfall demand was in excess of 20 crores. Now, my lord, after that, my lord, we, my lord, have recalculated at 9 crores 48 odd lakhs.
But even then, it's beyond the period of February 2021,
no, my lord,
when the last doc.
My lord,
so that
whether my lord, it is in terms of the order or not, my lord, we say it is in terms of the order. I have to, of course, my lord, look into the records.
That's arguably, yes.
My lord, I cannot, my lord, immediately make a comment on that. But, my lord, what is important is that the port has recalculated it. My lord, reduced it from, my lord, in excess of 20 crores to, my lord, 9 crores 48 lakhs. And, my lord, then made a demand. Now, my lord, my learned friend says that, my lord, you have to give me 30 days after you, my lord, make the demand. My lord, the demand is, my lord, what they approach the writ court. My lord, the writ court says recalculate it and give it. But, my lord, the question is, my lord, here, my lord, today the bank guarantee expires. Well, after the bank guarantee expires, my lord, where do I find my recourse?
So that can be extended by them. I can direct that, but you cannot. That invocation won't be given effect for a period for which I'll direct them to extend.
But today, in that case, my lord, today my learned friends, my lord, it has been invoked. Now, my lord, the bank may or may not, in terms of your lordship's order.
So the bank has been implemented also.
Well, I'll just, my lord,
it's an extreme case. I mean, extreme stage, but even then.
No, my lord, I'll just make this submission. My lord, my lord, might, my lord, be practical in these circumstances. My lord, the invocation is done. My lord, so far as the invocation is concerned, my lord, that is already, my lord, a fait accompli today. My lord, now whether the bank will make payment or not, that is a different matter. Now, my lord, if your lordship, my lord, directs, my lord, an extension, and my lord, for any reason the extension is not given, my lord, in that case, the invocation is still a valid invocation. So, my lord, that will not stand in the way.
So we can restrain the bank from disbursing that account pursuant to the invocation. Although it's an apparently illegal order, but Mr. Shah, that for equity justifies many illegal things.
I have, my lord, repeatedly been rebuffed by this court and by the Supreme Court on, my lord, special equities, which I thought were very, very strong in my favor. But, my lord, be that as it may, my lord, there is now an order of court. Well, I, my lord, cannot overlook that. But, my lord, the only thing is, my learned friend, my lord, now say they'll pay 4 crores. My demand is for 9 crores 48.
Yes.
My lord, I have already invoked the bank guarantee. Now, my lord, if your lordship, my lord, kindly directs that, my lord, the invocation is, my lord, a valid invocation, the bank is only, my lord, restrained from paying. My lord, because the question then will be, my lord, as to whether, my lord, there is in fact a need to, my lord, extend the bank guarantee further, because my learned friends may or may not do that. My lord, I don't have any control over that. My lord, I will of course come back to you before your lordship, my lord, with the calculations. My lord, I say that, my lord, we have made a calculation. The other thing that can be done,
yes,
is, my lord, the total bank guarantee is for a much larger sum of rupees. My lord, this 9 crores 48, my lord, can be kept apart. Kept apart, not paid to me immediately. Kept apart. But, my lord, that will not, my lord, then, my lord, need, my lord, an extension of the bank guarantee. My lord, further deliberations on, my lord, whether the bank guarantee, my lord, then it only becomes a question of payment.
That becomes a taxation on the bank also. I mean, in a sense, the bank will retain that. Where? In a special account.
Yes, the bank regularly does that. My lord,
Does that,
it keeps it in a separate account, because, my lord, otherwise what will happen is, my lord, the contention that will next follow, as I can, my lord, well envisage, is that, my lord, the guarantee has been invoked, the court has stated the invocation of the guarantee, now the guarantee is, my lord, lapsed.
You have invoked the entire bank guarantee.
But I am saying,
yes,
I am saying that, my lord, kindly, my lord, keep it apart for 9 crores 48. My lord, what is the demand?
What about the rest?
Well, the rest,
bank guarantee involves, I mean, the bank guarantees of how much? 2 to 20 something. 20 crore. There cannot be a partial invocation. You have invoked the entire bank guarantee.
No, but that's right. Well, I have, my lord, my demand. My lord, I have, of course, don't have the
Your demand is restricted to this.
That's right. My lord, now if this is paid, my lord, I have no other claim on the bank guarantee. I have, of course, reduced my claim already. I have, my lord, taken into account the judgment of the court.
So bank guarantee invocation, then if this amount is kept aside in their account by their bank, if that be so, then the bank guarantee invocation can be recalled or set aside.
That's right.
And this will be subject to the fate
Ultimately,
of this.
Whatever your lordship directs, my lord,
yes,
with the greatest respect, my lord, perhaps, my lord, your lordship, my lord, sitting in this writ jurisdiction cannot, my lord, enter into an estimation.
No, that cannot be.
So, my lord, today I have, my lord, rightly or wrongly made a demand. I have escalated it down.
It's on the principles, Mr. Shah, whether you can go beyond the observations of the court. The court observed certain things that the cutoff date has to be because they docked up to that period. Although we may argue that those were tentative findings for that stage, but even then the court specifically observed that to be calculated from and on the basis of the letters and MOU between the parties. So letters contain what Mr. Mukherjee placed.
I don't have, my lord, the entire, my lord, letter.
No, you don't have, obviously.
I will have to make submissions, but, my lord, my instructions are that we have calculated it as per the order.
Yes, yes.
And that is, my lord, the amount payable. If your lordships feel later, at a later point of time, it should not be 9 crores, it should be 4 crores. Well, then of course,
we will have to consider that.
But, my lord, for the time being, my lord, unless
you come ready with the calculations also on the next date, I'll make that clear in my order.
But, in the meantime, my lord, let this money be kept apart. Let this, my lord, 9 crores 48 be kept apart. Let the invocation happen for the sum of 9 crores 48. My lord, let them keep.
Can that be, Mr. Shah, under the law? Can that be done? I mean, invocation partially. Can the court direct that invocation will be only to the extent of this? Either it has to be a total invocation
your
or not.
Can direct that, my lord. I shall, my lord, whatever is the invoked amount, I shall, my lord, within 48 hours, my lord, give them back the balance. Because I have accepted that my claim cannot exceed 9 crores 48.
No,
I can
then
do
you
that.
you keep the 9 crore and not.
And rest I return. Within 48 hours, I can return.
That tantamount to the same thing. I mean,
Right. Well, I was just
Mukherjee
trying
knows
to-
that he'll get back the rest.
I was just trying to, my lord, be a little more fair than I should have been. I was saying that let the bank retain this money, but your lordship is right. My lord, there cannot be a partial invocation.
Invocation cannot be partial. Either
That's
I
right.
have to set aside the invocation because it cannot be. I mean, kept in a limbo. I mean,
Right. Well, I can do one of two things. Well, your lordship can say that let the money be, my lord, deposited into my account, or my lord, let me be allowed to encash the bank guarantee. But my lord, I will immediately pay back. That is one option. The second option is, my lord, today, so far as the invocation is concerned, invocation for the entire amount with a direction on the bank to immediately, my lord, debit my account, that sport trust account, for the balance after keeping aside this 9 crores 48. These can be, my lord, the two things, because, my lord, I accept that, my lord, my demand cannot, my lord, now go beyond 9 crores 48.
the rest of the invocation, Mr. Shah, at this stage, in any event goes because you
right.
cannot claim that amount.
That's right.
So entire invocation, let the entire invocation be set aside, subject to the bank retaining this amount of rupees 9 crores something in some other
If the
account.
invocation is set aside, then, my lord, I will have to re-invoke. My lord, that, my lord, I may not be able to do because the guarantee expires today. My lord,
Achha, can that be resolved if Mr. Shah, the invocation is stayed or revoked or whatever, and they are directed to furnish fresh bank guarantee for a particular period to cover this? I mean, at least to the tune of rupees 9 crore something.
No, my lord, today that could have been done. Perhaps, my lord, had my learned friends approached your lordship a little earlier, because, my lord, they had, my lord, notice of the fact that, my lord, I was demanding 20 crores earlier.
So as of today, Mr. Shah, your rest of the balance amount of the invocation, the bank guarantee, that you are not entitled to that at this stage.
No, I'm not even
So,
claiming that.
very well. So you have invoked the bank guarantee, the entire thing will be credited to you.
Yes.
But for instead of that, the invocation goes, they will be directed, and these are just options. They will be directed to furnish a fresh bank guarantee by tomorrow to the tune of rupees 9 crore and not whatever is your entire claim. So that will be there till say for a particular period for 1 year. Suppose
that will create a little difficulty. My lord,
Why?
may I just
Why?
suggest
Yes.
this?
Yes.
My lord, may I just suggest this? That, my lord, so far as, my lord, the direction is, my lord, so far as the invocation is concerned, let the invocation, my lord, be for the entire amount, but the bank will disburse to me only 9 crores 48. Now, my lord, if my learned friend is
that is
ultimately
a contradiction in terms, Mr. Shah. The bank, at the same time, if it is invoked, Mr. Shah, the bank doesn't have that option. Even the court doesn't have that option to ask the bank not to do it. Either the entire invocation has to be set aside, or I can direct that amount, something has to be done regarding that 9 crore, independent of that invocation. Either if the invocation goes through, then Mr. Shah, the entire amount has to be credited to you.
my lord, may I suggest this in that case?
Yes.
My lord, let them, my lord, furnish.
Hmm.
My lord, furnish, my lord, to us, my lord, a security, my lord, whatever, my lord, is tangible, encashable security for 9 crores 48. My lord, pending that, my lord, let the bank not, my lord, disburse money. The invocation remains there. The invocation, my lord, is an invocation for the entire amount. My lord,
What do you exactly mean by invocation, Mr. Shah?
My invocation is a demand on
comprises
the
of-
bank to make payment.
Yes, the invocation, if that is honored, Mr. Shah, that has to be honored as a whole.
Well, I'm just saying
It has
this.
to be credited to your
No,
account.
no, my lord,
So then the invocation has to be stayed.
my lord, what I am
The bank has to be
suggesting,
restrained from giving effect to that invocation
my lord,
as a whole.
the difficulty is, my lord, today, I, my lord, cannot take the chance of the bank guarantee expiring. My lord, next, my lord, the settling of the terms of the guarantee. My lord, what will be the terms of the guarantee? What will be the amount of the guarantee? That will be a
Your maximum claim is 9 crore something.
That's right. My lord, let them deposit, my lord, that money in court. Let them deposit that money in court. Lordship will, my lord, stay the bank guarantee entirely.
Yes, Mr. Mukherjee, what do you say
Yes,
to
my
that?
lord, I, my lord, make two submissions. My lord, the invocation has happened, and my lord, the bank's letter shows that the invocation is only for 9 crores 48 lakh 62,000.
Well, I don't have the paper, so I
My
didn't
lord,
know that. But if that is the case, then my
that
lord,
is all. So, my lord, what I am suggesting to my lord, I am giving better than security. My lord, kindly, my lord, direct the bank, my lord, not to pay, or my lord, this invocation will remain. My lord, till my lord, your lordship hears
Mr.
out the
Shah
matter.
was saying,
Yes, invocation remains, but no payment out by the bank. I will pay 4,25,000, my lord, out of this 9 crore 48 with 4 crores 25 lakhs, my lord,
We
within.
will not complicate matters on that. 4 crore you need not pay right now. So 9 crore, whatever, they'll not disburse for the time being. But you will have to secure that amount somehow.
My lord, the guarantee is a security because if it's injunction.
Bank guarantee remains.
Is there.
Invocation remains,
Yes.
right.
And if your lordship wants me to, my lord, I say no invocation is necessary because they've invoked within time. Your lordship, but if your lordships want me to extend it, I'll extend it as I have during the course of the previous.
The invocation is now we know is for 9 crores 48. My lord, my learned friend admits that, my lord, at least 4 crores 25 is due. My lord, your lordship will kindly, my lord, allow invocation for the entire amount to go through. But my lord, bank will, my lord, disburse 4 crores 25 lakhs. My lord, that, my lord,
to you.
Yes. And my lord, so far as the balance is concerned, the bank may not disburse it. My lord, your lordship will hear it on the returnable date and my lord, pass appropriate.
Fair enough. Fair enough. I'll do that. Mr. Shorkar has something to it. That is more important than what Mr. Mukherjee says. It's always. Mr. Shorkar. Yes, Mr.
Immediately.
Learned Senior Counsel, not the Advocate General, Mr. Mukherjee, Learned Senior Counsel in this matter.
Yes, my lord, in fact, my lord, if your lordships, my lord, look at, my lord, the history, my lord, of, my lord, reported judgments, even in private matters, my lord, it was provided, my lord. But my lord, I am not
That
one
is,
for it.
I'm not a believer in that because you're appearing in your independent capacity.
No, no, correct, my lord.
If the learned Advocate General in that capacity appears in these matters, Mr. Mukherjee, it will be you suffer in the other matters, in the public interest litigations. Learned Senior Counsel appearing for the petitioner makes out a strong prima facie case as regards the invocation of bank guarantee to the tune of rupees 9, 48, 62, 287.87 by the respondent stroke Kolkata Port Trust may be vitiated, being in contravention of the agreement between the parties and the order passed by the coordinate bench, by our coordinate bench on February 22, 2023 in WPA 21965 of 2022. First up, it is argued that in the said judgment, the learned single judge considered the fact that the petitioners last docked in the concerned port belonging to the Kolkata Port Trust in the month of February, 2021, and thereafter did not do so. First up, in view of the privilege conferred on the petitioner by agreement having not been invoked and or utilized thereafter, the Kolkata Port Trust, it was observed, would be unjustly enriched in the event the petitioner was directed to make good the loss for the subsequent period. Full stop. However, ultimately no final decision was taken by the court on the amount payable, and it was directed that the respondent authorities would not be precluded from demanding a justifiable amount of penalty from the petitioner number 1. First stop, it was further made clear that the petitioner number 1 shall be liable for penalty on account of the shortfall which is to be calculated from and on the basis of the letters and MOU between the parties, including the last understanding arrived at between the parties. Full stop. Next para. It was further observed that the petitioners shall pay the calculated amount to the respondent authorities within the framework of the correspondence or within any agreed time frames and on such terms thereof. Full stop. Next para. Subsequently, a claim to the tune as indicated above was raised by the Kolkata Port Trust. First up, it is argued by the petitioners that not only is the same in contravention of the order to the extent that a period much after February 2021 was taken into account for such calculation, there was also a clause in the agreement between the parties to the effect that 30 days notice was to be given to the petitioner prior to invoking the said claim, said bank guarantee. First up, next para, since it is contended that the bank guarantee has invoked to the tune of the claim now made by the Kolkata Port Trust, vide its communication dated June 19, 2023, within bracket annexure P13 at page 92 of the writ petition, bracket closed, comma, the petitioners have claimed protection with regard to such amount only. Full stop. Next para. Upon hearing learned senior counsel appearing for the parties, comma, it appears that the petitioners have made out a strong prima facie case for the writ petition to be heard on its merits. Full stop. As such, comma, for the present, comma, the petitioners are directed to pay an amount of pay the admitted amount of rupees 4, 25, 21, 912 to the Kolkata Port Trust within a week from date. Full stop. Next para. The respondent bank, that is respondent number 7 within bracket ICICI Bank Limited, bracket closed, shall be restrained from disbursing the amount invoked by way of the bank guarantee by the Kolkata Port Trust to the said respondent, to the Kolkata Port Trust till September 15, 2023 or until further order, comma, whichever is earlier. Full stop. Next para. However, comma, the bank shall also keep the balance out of rupees 9, 48, 62, 287.87, after deducting the amount of rupees 4, 25, 21, 912, in a separate account for the time being, which will be subject to the result of the present writ petition. Full stop. Next para. The above restraint order on the bank shall operate unconditionally for a week from date. Full stop. In the event the petitioners deposit the amount to the tune of rupees 4, 25, 21, 912 within the said period with the petitioners, with the Kolkata Port Trust, and intimate the payment of the same with appropriate documents to the bank, the interim order shall continue up to September 15, 2023 or until further order, whichever is earlier. Full stop. In the event of default by the petitioners to pay such amount to the Kolkata Port Trust and to furnish appropriate documents to the respondent number 7 bank within a week, however, the interim restraint order on the bank shall stand automatically vacated and the bank will be at liberty to disburse the entire amount of rupees 9, 48, 62, 287.87 to the Kolkata Port Trust. Full stop. Next para. The respondent shall file their affidavits in opposition within 3 weeks. Within 3 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. The matter, the writ petition shall be listed for hearing on August 8, 2023.
Only one thing, my lord, your lordship has said that the bank will hold the balance. My lord, the bank will hold the balance, my lord, if they make the payment. My lord, because otherwise the bank will, my lord, not, because your lordship has not said that for a period of 1 week the bank will hold the entire amount, and then, my lord, less, my lord, 4 crores 25 lakhs.
No, I'll make another observation probably that the invocation is not stayed for the time. No, that will create complications.
Well, only problem is, my lord,
for 1 week it will be unconditional. If within 1 week they pay that 4 crore something, then Mr. Shah,
no, I have followed. Well, I only think, my lord, if I've heard your lordship correctly, perhaps, my lord, your lordship has said that the bank will hold 5 crores and after, my lord, deducting 4 crores. But, my lord, the bank, if, my lord, the bank today releases, my lord, 4 crores 25 right away before they make payment, then my lord, there will be no scope for my lord, invoking the entire amount of the guarantee as in my lord of 9 crores 48. Well, kindly, my lord, when your lordship is
Very
correcting
well,
it, kindly bear this in mind.
Yes, yes, thank you. Yes, I'll definitely.
And my lord, it is now the Shama Prasad Mukherjee Port Trust, SMMPT.
Kolkata Port Trust.
My lord, what's in a name?
No, everything is your name. When
My
court order
learned
is-
friend is an authority on trademarks and he says, what's in a name?
কলকাতা পোর্ট ট্রাস্ট শ্যামা প্রসাদ মুখার্জি কস্ট টাইটেল থেকে করে দিয়ে
My lord, there was a PIL. My lord, port is being named Shama Prasad Mukherjee. There
Is
a-
that?
And my lord, on against that, because there is a dock named Netaji Subhash. So Netaji Subhash becomes inferior to my lord Shama Prasad Mukherjee. My lord, and it was entertained. My lord,
That is the future of India, Mr. Mukherjee. We are heading that way.
My lord, we serve them a copy.
Very well.
That can be recorded.
Just that can be.
Yes. চল
32,
32 এটা কি আরেকটা যেটা রাজস্ব যত হ্যাঁ yes
I'm being led by Mr. Shah.
এদিকে চলে এসো।
this is unfair two matters at a stretch
Well, this was a certain bonus.
you got 5 crores there anyway yes
Well, this is not a tender matter. I'll just tell you lordship a few dates.
Mr. Banerjee is appearing for the other side three very good.
But I'll just give you lordship a few dates. I'll try to make it as brief as possible.
Mr. Dotto, please just put on the microphone just goes off
Well, a tender floated for automatic block signaling systems. And this happened on 16th of February 2020. The dates are a little important.
these are railways
Yes. Railway signaling equipment tender floated for supply of automatic block signaling systems. Well, this is on 16th February 2023.
2023 yes
February. Now, my lord, the petitioner before your lordship submitted its bid on 24th March 2023. Now, my lord, there was no dispute raised with regard to its eligibility. My lord, then, my lord, in June 2023, my lord, there was a request made to the petitioner and my lord, the other bidders to extend the bid validity till 31st July 2023. Well, even at the time when this request to extend the bid validity is made, well, I have my lord submitted my bid in March. My lord, in June, after 3 months, they don't say that you are not eligible. Now, my lord, I furnish all documents to show that I am eligible in every respect. Now, my lord, thereafter, my lord, what happens is, my lord, on 24th June, 16th June, they asked me to extend the bid validity to July. On 24th June, well, I receive a letter of rejection, which your lordship will find at page 305. I'll take your lordship there. Very cryptic letter. My lord does not really say anything. My lord, this is the letter by which says that you are not eligible. Now, my lord, one very interesting thing happens. I have, my lord, filed a supplementary affidavit. My lord, not filed, prepared a supplementary affidavit to bring that on record. My lord, the authority, my lord, who is, my lord, really in charge of, my lord, the ordering of the signaling systems. My lord, he is directed, my lord, he is under an order of transfer, my lord, on the 22nd of June. My lord, 22nd of June, he receives an order of transfer. 24th of June, my lord, my bid is rejected along with the bid of another, my lord, entity. My lord, this has a very significant effect. Now, my lord, there is a provision in the tender for reverse auction. If there are minimum 3 bidders, then, my lord, irrespective of who bids how much, there will be a reverse auction. So, my lord, out of 4 bidders, 2 are eliminated through this process. So, my lord, the reverse auction does not happen. The possibility of the reverse auction is eliminated. And, my lord, on the 24th itself, my lord, after waiting for so long, my lord, the financial bid is opened. I, of course, do not know, my lord, what is the fate, but the fact is that, my lord, I have been eliminated very unceremoniously. Now, my lord, if your lordship will kindly straight away first have a look at, my lord, the letter of rejection at page 305. Well, that should be at the end of towards the end of the first volume.
yes
Where it says, my lord, this is a communication made on 24th June in respect of my bid submitted on 24th March. But then says, your techno-commercial bid against tender number such and
24th
such.
April
Well, lord, this is 26th June. Its email is 26th June.
Achha.
Well, lord, the date is, my lord, I'm sorry, the email is 24th June, not 26th June. 24th June, well, 2023, 305.
305 is the letter is dated 24th of April 2023 in my copy.
Yes, that is something otherwise.
Yes.
Well, I think only your lordship, only there are two identical matters.
Oh,
Your lordship may be looking at the other one. Well, I don't think we'll have to trouble your lordship with
no,
the main matter separately. 305, my lord, if your lordship will kindly have a look at.
Yes, 24th June. Email.
I'm grateful. I'm so very sorry, my lord.
Email. No, it's
well, your techno-commercial bid against tender number such and such, which was due on 24th March 2023, has been found technically unsuitable due to the following reasons. Rejected on technical and financial eligibility criteria, bid capacity, and improper information. Now, my lord, since they said nothing, my lord, we went running to them saying that what have you found against us? What is the reason for which you have now, my lord, rejected us? My lord, we are not given anything in writing, but my lord, orally, what we were informed, my lord, I have tried to reproduce that in paragraph 15. Well, that's at page 8.
Yes.
Well, if your lordship will kindly see page 9, well, these are the three grounds that they've indicated to us. Of course, orally. The Chartered Accountant's certificate dated 13th March 2023 submitted by the petitioner number 1, evincing the annual contractual turnover for the previous 3-4 years did not meet the requirements of the tender document. Copy of the said certificate is annexed here to marked F. I shall show you, lordship, that. That's the first ground. That you do not meet the financial eligibility criteria. The certificate of no relative being an employee of Southeastern Railway furnished by the petitioner number 1 was required to be furnished in respect of all zonal railways across India. I submitted a certificate saying that no employee member is a part of the Southeastern Railway organization. They say it should have been for the entire pan-India, but this is not even a requirement of the tender. Third is, petitioner number 1 has not provided documentary evidence of having completed similar work costing not less than the amount equivalent to 60% of the advertised value of the tender. Now, these things, let me just show you, lordship, immediately why, this is completely without basis, and this is a perverse exercise, to avoid, the reverse auction process and to, hurry up the tender process because of, certain exigencies that have now intervened. If your lordship will kindly see, page 77 once. This is the eligibility criteria.
Yes.
The tenderer must have successfully completed. Then your lordship will kindly straight away come to Roman 3 because that is where I have applied. One similar work costing not less than the amount equal to 60% of the advertised value of the tender. Now, the advertised value of the tender, your lordship will find from the NIT, page 32. The advertised value of the tender is 1 crore 6 lakhs. 106 crores. 106 crores. 106 crores. So, my lord, 60% of that is about, my lord, 64 crores and odd. So I should have, my lord, done a similar work of about 64 crores of rupees. Now, my lord, will kindly see, my lord, the certificate that I of course, my lord, submit all certificates to prove this fact. Now, my lord, kindly see the certification which I received in this regard, my lord, at page 679. This is from RVNL. My lord, which is also a railway company, by the way. 679.
Yes.
My lord, RVNL. My lord,
102.08.
Yes. Now, my lord, kindly see, my lord, name of the work. My lord, this is important because my lord, I should have to show you lordship similar work.
Yes.
My lord, kindly see construction of roadway, major minor bridges, track linking, etc. Then full stop. Outdoor S&T, signaling and telecommunication works. And then, my lord, will find a few lines later, and indoor S&T works, signaling and telecommunication work. Now, well, if your lordship will kindly see, my lord, the name of the agency, my lord, this was, my lord, by a joint venture company of which I was a party. My lord, I am, my lord, Kalindi. My lord, I am a part of the joint venture. Then, my lord, kindly see the original contract value is 145 crores. Value of signaling and telecommunication works is, my lord, 89 crores. And, my lord, then they say value of S&T works executed payment till date is 102 crores. Now, my lord, there was a corrigendum issued to this. My lord, that your lordship will find at page 677. RVNL issued a corrigendum. The work remains the same. Now, my lord, kindly see original contract value is 145 crores. That remains the same. Value of S&T works is 89 crores, 15.7 lakhs, 15,499. Value of S&T works executed and payment made till date is 68.46 crores.
This was done by a joint venture of which you were a.
Yes, no, but now, my lord, I should show you, lordship, from the joint venture agreement that the entire scope of the telecommunication signaling work was mine. There's
Did
no
you
doubt about that.
produce that document with them? No.
Well,
Could not have.
No. Well, and well, so far as this is concerned, my lord, I have, my lord, produced this, my lord, document. Then, my lord, will kindly see. So far as this is concerned,
you produce this corrigendum also.
Yes. Now, my lord, kindly see the note, my lord, at page 678.
Yes.
My lord, this is what, my lord, really removes all doubt. As per the joint venture agreement, the entire indoor S&T from such and such works are in the scope of Kalindi Rail Nirman Limited.
Yes.
And outdoor works physically completed and commissioned GMR Kalindi, etc.
You are Mr. Kalindi.
So, my lord, this is Kalindi. My lord, it has done this work. So, my lord, now it is, my lord, beyond 60, more than
64. Yes.
Now, my lord, let me also show your lordship, since your lordship is doing 678, 690. Well, lord,
was this document produced, given to them?
Yes. Now, my lord, this is, my lord, clarification that was provided, my lord, by, my lord, the RVNL earlier, my lord, to my lord, Northeastern Railway. If your lordship sees, my lord, the head, Northeastern Railway.
Yes.
My lord, the same, my lord, problems were perceived. Northeastern Railway, my lord, sought the same clarifications. Same clarification provided by, my lord, RVNL, accepted.
Regarding your joint venture?
Yes. Now, my lord, kindly see at page 690, payment made 68.46 crores.
Yes.
And, my lord, that is accepted. And, my lord, my lord, order is LOI is issued in my favor. My lord, 2 LOIs are issued in my favor that your lordship will find, my lord, at, my lord, page, my lord, 696. In respect of this work, after being satisfied that, my lord, I have, my lord, done work in excess of 60 crores of rupees, my lord, this is the LOI that is issued in my favor by the Northeastern Railway. So, my lord, the railways, my lord, they are the same entity. It is not as if Southeastern Railway is one entity, Northeastern is another entity, South Central is another. My lord, they are all a part of, my lord, the railway board, and the railways are, my lord, the same. Indian Railways, that's what we call them. Now, my lord, so far as this is concerned, my lord, this is eligible. Now, my lord, let me show you, lordship, what, my lord, they had, my lord, tried to do on earlier occasions, where, my lord, participations were through joint venture. But if your lordship will kindly see now the standard general conditions of contract at page 181. My lord, these are the standard general conditions of contract, my lord, which, my lord, sometimes supplement, sometimes, my lord, clarify, my lord, the terms of the tender. Now, my lord, if your lordship sees, my lord, page 198, which is a part of, my lord, this, my lord, standard general terms. Well, your lordship will find at the end, at the bottom of the page, the same eligibility criteria. If your lordship turns the page at 199, Roman 3, one similar work costing not less than the amount equivalent to 60% of the advertised value.
Same.
Now, my lord, if your lordship now turns to, my lord, page 203. Now, my lord, these are documents to be submitted by the tenderer, clause 14. Now, my lord, kindly see, my lord, at page 204, my lord, one set of documents to be filed by sole proprietorship, other documents by HF, by partnership firm, by joint venture, and then by company. Now, my lord, we are a company. Now, my lord, the company's documentation, if your lordship now sees, my lord, kindly see Roman 4 of E. All other documents in para 10 of tender form second sheet. Now, my lord, what is para 10? Tender form second sheet. Kindly have a look at page 197. At 197, your lordship will find tender form second sheet. Now, at 198, your lordship will kindly see.
That eligibility criteria.
That's right. Now, these are the documents which I have to submit. I have to only show I have done, the tenderer has done. The language is very important. That is 10.1a. The tenderer must have successfully completed. The tenderer must have successfully
Tenderer
completed.
is you, that is the company.
Yes, I'm the company.
So you have completed that internal, that S&T, the part
That's
of
right.
the job.
Yes. More than 60 crores. And that is accepted by Northeastern Railway, and tender is awarded. They also had similar routes. They sought clarification. I gave clarification. Done.
Only one point is arguable then, Mr. Shah, whether a portion of the work, if that was done by you, although that concerns the exact similar work, whether that can be considered to be a work within the contemplation of the tender document.
Yes, yes. Because they have not raised any dispute. They have only said that you have not done it of the value. Now, I'll tell you, lordship, what is the contention that they're raising? Now, if your lordship sees, I have shown you, lordship, what is the requirement for companies. At page 197, that is required. Now, if your lordship will kindly see page 203 once again. At 204, your lordship will find D, joint venture. In case of a joint venture, all documents as mentioned in para 17 of tender form, second sheet, will have to be furnished. Now, my lord, that does not apply to me. But, my lord, kindly see what is the requirement. My lord, kindly see page 206 once. Clause 17 is at the bottom of 206. What they are saying essentially, at 17.15, if your lordship can kindly have a look at 17.15 at page 210. At 17.15.1,
yes,
kindly come towards the bottom of the page, portion in italics, B. Value of a completed work done by a member in an earlier JV shall be reckoned only to the extent of the concerned member's share in that JV for the purpose of satisfying his or her compliance to the above mentioned technical eligibility criteria in the tender under consideration. Now, my share in that JV was 29%. This would have applied had a JV been making this bid. But I am bidding as a company. I am only required to satisfy 10.1. The fact is that I have done this signaling work of more than 60 crores of rupees, which is certified by RBNL, by a certificate, then by a corrigendum. Also, similar clarifications provided in the case of Northeastern Railway. Now, this is the first ground on which they purport to now say suddenly, out of the blue, after waiting for more than 3 months, that you don't.
If you are a JV, Mr. Shah, if there are two parties to the joint venture, then for each one of them, if they produced a previous joint venture, their share would be considered.
Right.
So the same principle should be applied to your case also. I mean, in a different.
If I had participated as a joint venture, yes.
Yes.
But when I don't participate as a joint venture, only requirement is 10.1. So I must show or satisfy the authority that I have performed work of this value. And that is exactly the point that was raised by the Northeastern Railway. That is exactly the clarification it provided, and the Northeastern Railway has accepted that. And again, I repeat, between February and June, they had not thought that I was not eligible.
But that does not debut them probably.
No, that's all right. But in
conduct, you may say, yes.
Yes,
now this transfer business came in between, the transfer of that person and all these cloudy things.
Now, the next thing is, my 206 joint venture sheet 17. Now, next thing is the turnover. Now, kindly see page 309 once. Financial eligibility. Same volume, page 309.
Yes.
Let kindly see, I have here, enclose the chartered accountant certificate, annual contractual turnover data for the previous 3 or 4 years. I have said the Indian equivalent of 87,302.88, 84,090.90, and 78,650.83. Average is 83,348.2. They have said that this is in thousand because you have not mentioned lakhs. Now, I annex my balance sheet along with it, which clearly says in lakhs. Kindly see 311. My lord, Central Railway had asked, my lord, in such circumstances for a clarification. My chartered accountant had clarified. But my lord, more important, my lord, all my balance sheets, my lord, have been forwarded 316 onwards. My lord, balance sheet, my lord, this cannot 83,000. My lord, I cannot bid for this project. Now, my lord, today, if this was a confusion, they could have asked me for a similar clarification as has been done by Central Railway in 311. Clarification given, tender awarded to me. Now, my lord, the third thing, page 310, the previous page. Well, this is the certificate I gave. We understand hereby solemnly declare and certify we do not have any of our relative employed in the Southeastern Railway except the names mentioned herein. Well, nil. They say you should have given it for all India.
What is the relative clause once again?
Well, there's no such.
So there is.
Well, there's. Well, if at all, that's at page 73. If at all. Well, apart from this, there's nothing. Well, at page 73, if your lordship sees, well, towards the bottom of the page, clause 5, information regarding employment, partnership, etc. of retired railway employees has to be submitted as per IRGCC 2022 with latest correction slip.
This is something else. This is entirely something else.
But this is not a requirement. Well, they wanted it, they said give it, I gave it for Southeastern. Well, I have no one connected with the railways naturally.
They wanted it means they wanted it by in writing.
No, well, this is
Why did you give it in the first place? I mean,
it
there must be something.
It's just given part of the tender for some reason. It's not part of the.
But I believe, my lord, this is. I believe, my lord, we have scanned the tender documents, my lord, not found anything. But my lord, I believe, my lord, this is a part of standard procedure. So, my lord, this is because they are, my lord, railway contractors, and my lord, they have been participating. So, my lord, this was given, and my lord, this is the third, my lord, reason. Now, my lord, here, my lord, so far as my lord, the balance sheet is concerned, now, my lord, very important. Now, my lord, today, if there is any doubt, my lord, they have a duty to ask for clarification. Kindly have a look at page 193. Well, it's 7E, clarification of bids. To assist in examination, evaluation, and comparison and pre-qualification of the tender, the railway may, at its discretion, ask any bidder for a clarification of his bid. Any clarification submitted by a bidder that is not in response to a request by the railway shall not be entertained or considered. Railway request for clarification in the response of the bidder in this regard shall be in writing. But they have not asked me for any clarification.
This is obviously discretionary by them.
No, that's right. But, my lord, what is important is, my lord, today, my lord, this is, my lord, not something that was there in the previous, my lord, standard terms and conditions. This, my lord, requirement of clarification was introduced now only to, my lord, ensure that there's no arbitrariness.
Central and Northeastern Railway has used.
Now, Central and Northeastern Railway have, my lord, used this, my lord, clarification provision to seek clarifications, satisfy themselves, and then award me the contract upon considering me to be qualified. Now, my lord, this is something that is, my lord, given a go by, and, my lord, given, my lord, the time span, well, they could have asked for this clarification easily. It is not as if they were running against time. That is the important part. So, my lord, these are the three grounds on which, my lord, today they seek to, my lord, disqualify me, and, my lord, disqualify me, and on the same day open the financial bid. My lord, this shows undue haste.
No, that
the other, my lord, the only other point, my lord, is, my lord, the point of reverse auction. Kindly see page 87.
My difference is less than 1%.
Well, page 87, well, requires that, well, ultimately, the award of the tender, well, on consideration of bids will be by reverse auction. Well, this is the guideline for electronic reverse auction. Now, well, kindly see the table or the chart. Number of tenders qualified for award of contract. If it is less than 3, then no reverse auction, nil. If it is between 3 and 6, well, then the bids disallowed from participating in reverse auction shall be the highest bidder in the tabulation of initial price. In case highest bidder scored the same rate, initial price offer revised, received last as per the time logs, IRIPS shall be removed first, etc. My lord, there's a process. Now, my lord, the process will not, my lord, ultimately kick in if the number of, my lord, eligible bidders is less than 3.
What happened to the request to bidders to extend bid validity? If you two go, then that becomes redundant.
That's right, my lord. Now, my lord, the request to extend the bid validity is till July. Now, my lord, in my lord June, suddenly,
Hmm.
my lord, they say that you're not qualified, and on the same day, my lord, they open the financial bid. My lord, that the fact that, my lord, the authority, my lord, the principal authority was under an order of transfer on 22nd, my lord, we have come to know of that, my lord, recently. My lord, we have prepared a supplementary affidavit to that effect. My lord, this is probably, my lord, what created the urgency. And my lord, your lordship had seen the initial rejection that was communicated me was very cryptic. Very cryptic. I, my lord, went, approached them, and then, my lord, this is the clarification that they gave me. And my lord, this is the clarification that I have, my lord, put on record. Because otherwise, my lord, your lordship would have to, my lord, call upon them, my lord, they would have to disclose the reasons, and then, my lord, for that matter, the entire process would have been, my lord. Ultimately, I do not know, my lord, financial bid, they will open, they will, my lord, award the tender, whatever has to happen will happen. But I am now, my lord, very conscious of, my lord, two things. My lord, I have to show to your lordship that there's a perversity which is in play. My lord, it is, my lord, the decision of the authority, no doubt. But, my lord, when the authority has prescribed a, my lord, set of rules by which, my lord, it is expected to abide, my lord, today, if it has to depart from that, it has to give, my lord, valid and bona fide reasons. Now, my lord, the pace at which, my lord, things were going on, the sudden escalation of the situation, the sudden, my lord, communication of, my lord, my rejection, and, my lord, the opening of the financial bid on the same day, and, my lord, bringing it down to, my lord, less than 3 to avoid the reverse action, my lord, shows perversity. I cannot, my lord, otherwise establish perversity. It is, my lord, something that your lordship will have to, my lord, understand from the, my lord.
How do you link the transfer of that person with this? I mean, what is your take on this?
My lord,
I
it
mean,
is
what
like
is
this,
your-
my lord, today, my lord, the gentleman who, my lord, ultimately has a final call, my lord, in determining, my lord, the tender and, my lord, the awarding of the tender. My lord, if he is transferred, he's under transfer order. If he is transferred, then, my lord, he will naturally not have control over the tender process. My lord, so, my lord, there is an attempt to, my lord, hasten things along the way, my lord, to ensure that, my lord, the process is completed, my lord, before the transfer order takes.
That may cut either way. You might have managed the previous one.
No, this is the previous one. I may manage the
So transferred.
subsequent.
The previous one is being transferred now.
No. This gentleman has been in office. Now, my lord, he is under an order of transfer. My lord, so there is no previous one here. My lord, there may be a subsequent one. There may be a presumption that I will be able to manage him. But, my lord, that is a little far-fetched at this moment, at least, because we don't know who the subsequent one is. But, all that I'm saying here, my lord, here is that, my lord, if your lordship sees, my lord, the conduct of Northeastern Railways in the same set of circumstances, the conduct of Central Railways in the same set of circumstances, where, but in respect of identical objections, they have sought clarifications provided, satisfied, tender awarded. Well, then, my lord, there was really no purpose in, my lord, the Southeastern Railway, my lord, departing from that procedure. Now, my lord, your lordship has, my lord, made an observation that this is discretionary. But, my lord, when others have exercised the discretion and for, my lord, just cause, my lord, there would have to be a valid reason for, my lord, this authority not to exercise the discretion. And, my lord, today, when, my lord, it is on record that, my lord, I have performed the work, other authorities of the same railways have accepted it, certified by RVNL. My lord, then, my lord, there can be no question of, my lord, imposing this condition. My lord, there was another matter, my lord, of a similar nature, where, my lord, I was a joint venture bidding. And, my lord, there, this clause, my lord, that operated was clause 17. And there, my lord, I, my lord, lost the matter because the learned judge said that no, here your extent of your participation in the JV, which earlier participated, will have to be taken into account. But, my lord, here we are not participating as a joint venture. That is why I took pains to show your lordship 10.1 for a company, 17 for a joint venture. And, my lord, this is clearly identified, my lord, in the, my lord, general tender conditions. Well, I, my lord, very respectfully say that, my lord, for the time being, if today the award of the financial tender is not stayed, then, my lord, this issue will become infructuous. And, my lord, I also, my lord, very respectfully submit that, my lord, the circumstances, my lord, ultimately
The award of the contract you are saying.
Yes, my lord, because they've opened the financial bid. I don't know, my lord, what is the fate, the result. But, my lord, I say that, my lord, ordinarily, irrespective of whether, my lord, I am higher or lower, I would have been entitled to participate in the reverse auction process at least. Now, my lord, today, if you are trying to jettison the reverse auction process, which is the process, my lord, envisaged under the, my lord, tender terms and conditions, and you're trying to do it, my lord, by eliminating a person who is, my lord, otherwise qualified, has been treated as qualified in respect of same materials by, my lord, other branches of the railway, then, well, that is something that should not be allowed. And, my lord, we have come at the earliest, my lord, so that, my lord, no one can claim any special equity at this juncture. And, my lord, there is no impending urgency to finalize the tender immediately, because, my lord, the tender is floated in February, and, my lord, time extended till July. So, my lord, it is not as if, my lord, heaven will fall on earth, my lord, if today a few days, my lord, is taken up in between. My lord, the other matter is, my lord, identical in facts. My lord, one is, my lord, for Rourkela, one is for Tatanagar. I don't want to separately trouble your lordship, my lord, in the other matter. My lord, these are my submissions.
Thank you. You are for which? You are for the authorities.
Yes.
Mr. Mukherjee, you are for who are you? Who are they?
They have only annexed the financial. From there, it is evident that I'm there. From there, documents.
L1 means you are the only bidder now.
No, there is 1%. I mean, the reverse option I could have completed. In the petition, I find responsible claim to 4 and 5 is the other, the JV, who's also bid is there.
That we have annexed. My lord, all that I say is, my lord, here, my lord, now that the financial bid is open, the difference is less than 1%. Reverse auction is, my lord, something that I'm eligible to participate in and entitled to participate.
There are two competitors, not one only. So reverse auction process has not been sabotaged altogether.
Well,
There
no.
are two participants.
If it is less than 3, then no reverse auction. It is 3 or more than reverse
So let
auction.
me hear the authorities first, then I'll come to him. Yes.
Lord, petitioner, before your lordship, we are saying that
Do you require to annex anything else in your opposition? Otherwise, I'll hear you out finally.
just now, my lord, it can be disposed of. If your lordship kindly sees.
It won't be disposed of just now, but definitely
Because,
not
my lord,
just now.
what I'm saying, my lord, according to
no
their
further hearing then.
no, their document, my lord, if your lordship kindly sees that their document they have submitted, the credential part that they have merged with, my lord, one Kalindi, that Mrs. GMR Kalindi, and my lord, their share part is, my lord, 29%.
That was for the previous one.
Yes. Now, my lord, if we calculate
They
from
say that's a joint venture. Joint venture is different from a.
I admit it. I admit it for the time being. After taking out the same, now, my lord, if your lordship kindly sees in the joint venture 68 point something crore. Now, according to the shares, it comes to less than 20 crore. That what they have taken.
No, that particular sort of work, indoors, S&T, that was to be done by them only as per that note.
No, my lord. If your lordship are subject to a lordship's kind sanction, my lord, according to their submission, that Kalindi part, they have merged it, 68.46 crore, that is above 60%, according to their view, that we have reached, we are entitled. Now, my lord, kindly see, their share part is, they have taken, that is 29%. Now, my lord, if it is 29% of that.
677 ones?
Yes, please, 77. Yes, yes.
Please see item 6, Mr. Banerjee.
Yes.
Value of S&T works executed and payment made till date 68 point something crore.
Yes.
And please come to the next page, note 10, the note actually. Item 10, the note.
Yes.
As per the joint venture agreement, the entire indoor S&T for which 64 was calculated from such and such section and outdoor signal work for such and such are in the scope of Messrs. Kalindi. So how do you distinguish this?
No, my lord, Mrs. GMR Kalindi.
No, that is Messrs. Kalindi.
Now, my lord, yes. Now,
Messrs. Kalindi. They
Mrs.
coupled
Kalindi.
up with
Yes. Now, my lord, 29% of their share, they have purchased it. They have taken their merger. Now, 29% of this particular, yes, they have indicated. Now, 68 crore.
Yes.
Now, 29% of that particular work. Now, it comes to 20 crore.
How do you get this percentage?
Yes. Now, my lord, if your lordship kindly sees the page, they have annexed it.
Yes.
Yes, that is at page 686. 685, it starts from 685. Responsibilities, that is, my lord, A, leading partner, Mrs. GMR Infrastructure Limited. Thereafter, JB partner, Mrs. Kalindi Nirman, 29%. Now, 60 out of 68 crore, 29%.
Now thereafter, now Texpaco independently has come. Then out of 68 crore, it comes to below 20 crore. Now they're
has merged with Kalindi. There's an order of court. All assets,
Yes.
all liabilities, my lord, now belong
For
to
such reason, I'm saying 29% share they have got.
This was for that particular joint venture. Yes, for
And
that
now
joint,
they have
Mr. Banerjee, it may very well be that the original contract value 677 page. Original contract value is 145, 33, 45 to 66.
Lordship.
Now, out of that,
They-
value of S&T works in the scope of contract was such and
68.
such.
This is not the work completion certificate up to as of now. That was issued in the year 10th March 2022.
That was value and value of S&T works executed and payment made till date.
Lordship. That we
Till
have
that
paid.
date. So already they had done that work.
Done that work.
So that was, if already that work was 68 to the tune of 68, 460 crore, then it exceeded 64.
It comes to, my lord, after calculation, my lord, according to the JV, that 29%. For such reason, they have been rejected. That is our main contention.
Then what is the meaning of this note at page 678?
678.
That note at item 10?
Item 10. As per the joint venture agreement, the entire indoor S&T so-and-so section and outdoor section HD enrich.
This was a part of the, this section was not the entire stretch.
No. Part.
From such and such section and outdoor. So this from such and such section.
Thereafter, Miller Limited and indoor and outdoor works physically completed and commissioned by Mrs. JMR Kalindi TPL Limited. That means both. That is, Miller, at page 685 and 686. That is their credential. This is my humble submission before your lordship. For such reason, they have been rejected.
$686, you place
Lordship,
680.
lordship.
Very well. So why didn't you seek a clarification if there was doubt? It was very clear to you.
But they have submitted, they have annexed, they have placed it.
Very well. Yes.
May I just show you lordship one thing, Malad, just to clarify?
No,
Malad,
I'll
the
take a
joint
composite.
the joint venture agreement, Malad, which my learned friend has shown, shows Malad that the scope of work of Kalindi is the entire signaling.
The Kalindi, it is stated in 10, Mr. Shah, 678.
Right.
As per the joint venture agreement, the entire indoor S&T from JHS BZM section.
Yes.
And outdooring in such and such
That's right.
section are in the scope of Mrs.
That's
Kalindi.
right.
There could be other sections also. We don't know.
But we are concerned with these sections. Well, this is the section that we are concerned with. And Malad, if your lordship sees 686 or Malad 685, Malad, lead partner GMR, responsibilities, earthwork, bridge work,
This work for which you were paid 68.4 crore, that could have encompassed not only this section but also other sections.
Other sections.
No, Malad, so
How
far
do
as
you
the
know
other
that?
sections is concerned, now Malad, what they are saying, that RVNL is saying that Malad, this has been done by Malad.
The entire indoor S&T from JHS BZM section.
Hmm.
For that only, for that section only, you have done the entire thing. So now it may very well be, Mr. Shah, that there were several sections were covered.
Kindly see 684. I think this question will be
684.
Malad, this is the entire scope of work. Malad, kindly
Achha.
see that. Malad, this is the memorandum of understanding for joint venture participation.
Yes.
Malad, package 1, construction of roadbed such and such, track linking such and such, etc. from Jhansi, including Malad, Jhansi to Bhimsen in connecting with doubling. my lord, between Jhansi, Bhimsen stations, Bhimsen North Central Railway.
Jhansi is JHS.
Yes, my lord, Jhansi.
Bhimsen is BHS, BZM.
Yes.
No, BZM was ZM.
There is only one section.
Well, there is, my lord, there is only one section. Well, this is, my lord, kindly see outdoor S&T. Well, kindly let's read this again. Construction of roadbed, major minor bridges, track linking, excluding supply of rails, outdoor S&T works, TSS general, electrical works from Jhansi, including such and such, then indoor S&C work from Jhansi to Bhimsen.
Jhansi to Eric Road and Jhansi to.
So, well, Jhansi to, my lord, Eric Road is one, Jhansi to Bhimsen is the other.
Jhansi to Eric Road, there is no indoor work.
No, that is outdoor, my lord.
Outdoor and S&T is different.
Yes.
And indoor S&T works only from Jhansi to Bhimsen.
Right.
In connection with doubling between Jhansi and whatever.
And then, my lord, your lordship sees page 685. These are my lord, joint venture partners.
Yes.
My lord, GMR is the lead partner responsibilities. My lord, kindly see earthwork, bridge work, supply of cement, etc. My lord, no signaling work. Then, my lord, kindly see the next page. My lord, kindly see the next partner, Tata Projects. My lord, general, ferrous, non-ferrous, TSS items, tools, plants, etc. And my lord, now Kalindi in between.
Yes.
Well, at P-way supply, other than steelways, and then group A, B, C, D, well, these are the 11 A, B, C, D are the signaling items. Well, if they've asked for clarification, I can give it immediately.
11 ABCD.
Yes.
Where do I get that? These are the signaling items.
Well, that, my lord, is not, my lord, here, but
signaling, the word signaling is not mentioned in responsibilities of any of the
that's
three.
right. But, my lord, what is important is that RVNL acknowledges that fact, my lord, in its, my lord, note.
Pardon?
RVNL acknowledges this, my lord, in the note. My lord, now, my lord, schedule. Permanent way linking. Well, this is important. Well, at permanent way linking installation work, permanent way linking supply installation work. Well, way linking is the signaling links. And this is clarified
This
by
is indoor S&T works.
Yes.
So indoor has a specific connotation, Mr. Shah.
No, that is
whether it comes within the ambit of the connotation of the purview of the term.
When the same question was asked, Northeastern Railway,
Let us see Northeastern what they say.
Yes. Kindly have a look at the Northeastern Railway. 695 onwards.
95, very
well. First, kindly see 695B. This was the letter written. Clarification sought. Well, this was by the Central Railway, Northeastern Railway wrote this letter to the verification to RVNL. Messrs. Texmaco Rail Engineering has submitted in the name of Kalindi Rail Milwan the completion certificate naming construction of roadbed, major minor bridges, etc., etc. Well, from Jhansi, including such and such Eric Road, S&T works from Jhansi to Bhimsen, etc. The work advertised by the railway as similar work for engineering component is engineering works, auto, hut, structure, building, whatever. The certificate submitted by the firm needs further clarification as the work and completion certificate is merged with electrical and P-way components and is not giving explicit picture of monetary value of work advertised by railway. Then, my lord, kindly see. No, but ekhane work advertised, so building work, building to supply material. Now, my lord, kindly see 695A. My lord, kindly see similar nature of work, building structure nil, bridge work nil, supply of building material real. Now, my lord, in case of firms, my lord, GMR Kalindi shares are below. GMR infrastructure in JV ratio 51% is for civil works, formation, bridges, supply. Kalindi in the JVO is for permanent waste, signaling and telecommunication. My lord, this is the entire, my lord, linking telecommunication work is that of Kalindi.
Then, my lord, we have to rely upon the tender. What was the amount? Thereafter, the clarification. Thereafter, this particular thing will come.
Mr. Mukherjee also say something.
Each and every
that is also
body
given.
has got an independent essence.
Kindly see now, my lord, page 694.
We are going too far, probably, Mr. Shah, on this. They should not go this far.
No.
For a particular bidder.
No, it is clear. It is very clear, my lord, that my lord, this is
It is clear that it is not clear. That much is only clear, Mr. That it is not clear. It is taking so much time for you to explain even to yourself.
690 again clarified. Again
693.
690.
That is in respect of this, not from railway.
Again clarified.
Yes.
Regarding a different tender, with
Yes,
the terms of which were
different.
different.
No, my lord, this is this is the certificate on which we have relied to show we have done work in excess of 60 crores. And my lord, kindly see again at the bottom of page 690, Kalindi.
These were all produced before them. I mean, given to them.
Yes, yes, all given.
Yeah.
My lord, what I have given is, my lord, the certification that, my lord, I have done the entire signaling work. And, my lord, the value of work, my lord, completed is in excess of, my lord, 68 crores.
Yes, let Mr. Mukherjee say. Yes.
Already your lordship find the serial number 4, original value of contract is 145 crores.
Right.
Value of SMT work in the scope of contract is 89. That is around 61% of 145. 61%. Well, I'll calculate. Now that the lordship takes the JV agreement. JV agreement only provides what is the percentage of share they have. They don't say for the entire signaling work. If at all it is for 89 crores, they will be paid the entire amount. JV agreement is one that kindly takes a JV agreement.
No, it's the work, the worth of the work, basically.
Whatever the worth of the work is, but it is as per the JV agreement, the payment will happen. If the at 61% of the work being signaling work, JV agreement, they should have put a 61% partner, not 29% partner. Why would they have a 61% someone else? Be a majority partner when they are doing the maximum work. Well, we all operate like JV, whatever the percentage, that is the amount of money they will get back. That's the concept of a JV.
Definitely.
Why do a different percentage? Had the signaling work been 61%, in the JV, well, they would have been a 29% partner. Exactly. It makes no logic whatsoever.
I will ask to answer this one.
And whether it is not their case that RBNL has made payment of 68 crores to them. The payment has been made to the chain. Now, the way the share goes is as per the chain, not as per whether the work they have done. That's absolutely correct. And now, if the lordship takes a tender term, I think whether the tender terms are also very clear that whatever their scope of the work, not the JVs.
No.
I'm not
So that is very clear.
17.15.1 also. The lordship takes 10.1 says 198. Well, this is what was relied on as the second sheet. Page 197 is the tender form second sheet, which is applicable to companies. Now, clause 10.1 is at page 198. Your also takes 201. Explanation for paraphrase. Your lordship will find whether there are various explanations given. I'll rely on 1 and 8 to see whether what is the logic. Which is important. Your lordship says substantially completed work is an ongoing work which payment equal to or more than 90% of the present contract value, excluding payment made for adjustment, has been made to the contractor. Not to a contractor was part.
So not only the worth of the work, but the payment actually.
And now that if a lordship, just for example, if a lordship serial number 8 also, the logic is given. In case of a partnership firm, how will it be calculated? In case an existing partnership firm, if any one or more of partners quit the partnership firm, the credentials of the remaining partnership firm shall be reworked out. Quitting partner shall take away his credentials.
Obviously, yes.
Yes, sir. So in this case also, whatever work we have done, there 29% in that JV, that will only be considered, not the entire work, if at all. There is no proof that 68 crores they have been paid. Now, whatever the money gets in the JV, as per the percentage, that money is to be received. So also judgments on it, the lordship also sees that an AFCON, where
2016.
If these are all the documents, then I won't invite affidavits. I'll conclude arguments on this. I have concluded almost.
Will be the how much of interference of constitutional court will take in matters like this for that.
2016, I believe.
2021 to
Oh.
sorry, 2016.
Yes.
818.
Yes. APCON.
You know so much, Mr. Banerjee. I'm really flabbergasted. No, more than me at least. Yes. So your respondent numbers, I forgot your numbers. 3. Thank you.
According to the financial document which they have access, which they ought not to have any access to. But I am the L1. I'm just pointing this out.
Yes.
Well, I have not seen the supplementary affidavit. That's not been served on.
Not been served on you?
Supplementary affidavit. Well, we have made a party. my lord, para 12 to 15. The lordship sees, my lord. The only para interference of a court.
Oh, yes.
Arbitrariness or favor, my lord, in this case, on the face of it, my lord, they were not qualified. And my lord, my answer to clause 7E, my lord, where they said, my lord, bit clarification. My lord, it presupposes there is a doubt. And if there is no doubt on the face of the topic, obviously, well, they are not eligible. Well, at 29% is 19 crores, or not even 20. And the qualification criteria, 60% of the advertised value constitutes 64 crores, 2 lakh 79. So they are far below that. But that's why.
Yes, Mr. Shah, I'll take your reply and conclude this. Of
Well,
Mr.
just,
Mukherjee.
my lord, first of all, my lord, here, my lord, first thing, my lord, when we talk about a joint venture and my lord, the percentage of my lord shares, my lord, we talk about my lord, A, responsibilities, which has been clearly identified. B, my lord, when we talk about payments for work done, my lord, that does not include the profit. What is shared is the profit in that ratio. So, my lord, my learned friend cannot, my lord, presuppose.
Then your basis goes that 60 more than 64 crores.
No, my lord, that is only profit sharing. My lord, the work done, my lord, I'm
was
paid.
the payment made.
That's right. Now, my lord, so far as the payment made is concerned, my lord, today, my lord, all clarified, they have not said that please show that you have been paid. I would have appreciated that because, my lord, when I do the signaling work, my lord, I supply the equipment, I do the installation. My lord, kindly, my lord, consider just for a moment how absurd this argument is. Well, I am supposed to, my lord, perform work of the value of, let us say, 50 crores. Well, I am supposed to supply equipment which is worth 35 crores, to employ labor which is worth 10 crores, and well, do sundry work. Now, well, I will get 29% of that value.
You have agreed to that?
No, but that is the sharing of the profit. Well, whatever is the profit percentage calculation, the work, the profit is shared in that ratio. That does not mean that well, they paid for that.
Those documents are too little or too less, Mr. Shah, probably to ascertain that as one of the partners to that joint venture agreement, you had whether you had got payments of more than
Not
64
the criteria. That's what I want to show you. Kindly see what is the criteria.
That's too
the
vague. The
tenderer must have successfully completed or substantially completed one of those. Now, I've successfully completed. That is the certificate.
But in the explanation, as Mr. Mukherjee showed, that it's clarified that what is the meaning of this successfully completed.
No, my lord,
there has to be a payment link with the payment.
That is substantially completed. My lord, here I have completed the entire signaling work. My lord, kindly see 201, my lord, which is what my learned friend was showing. My lord, how does this even apply to me? My lord, kindly see, my lord, he refers to 10 and then my lord says, my lord, the tenderer must have successfully completed or substantially completed. Now, then he says, what substantially completed means. But my lord, I have completed the work of that my lord value and that is certified. There's no substantial completion. It is certified that this signaling work has been completed. And my lord, I would have still appreciated that one line in clarification sort. My learned friend says, if there's no doubt, why should they seek clarification? Well, if your my lord, lordship feels that there is no doubt, then of course, my lord, that is one way.
If one of the views could plausibly be taken the same principle as an appellate court's intervention.
Yes.
So if it could be one decision could be taken on the basis of the materials which were there, why should they seek a clarification? And why should we not go with that?
I'm grateful. Now, my lord, here, my lord, first, my lord, your lordship has seen that, my lord, the eligible requirement is I must have completed work. They have not said they have substantially completed, furnished proof of substantial complete. What I furnish proof of is completion and payment. My lord, if there is completion, only then there is payment. Otherwise, payment does not come. So, my lord, there's no question of substantial completion here.
Very
so, my lord, if today I have completed the value, my lord, my learned friends need not be concerned about whether I've been paid or not paid. My lord, the requirement is I must have completed work of that value. And my lord, there can be no doubt about that. Of course, my lord, I will have to read things, my lord, with my lord, wearing my lord, blue, white, and green lenses, my lord, if I don't want to see things, my lord, clearly. My lord, that is all. My lord, today, my lord, what I say is, my lord, that today, if it was as clear as that, then, my lord, the others wouldn't have come forward and, my lord, sought clarification. I mean, kindly see, when others have clarified that, my lord, I satisfy the financial requirement, you say that you have said 83,000. You have said that you have not said that you don't have relatives working across the railway all across India. Well, it has to be interpreted in the light of that conduct. I'm grateful, man.
sorry, my lord. Lordship will also consider at page 200, vote for item number 10.1, the second. Yes. Also consider. Well, I think that will answer.
Page 20.
Page 200. Vote for item number 10.1. That is the eligibility criteria. The
Yes.
second vote, the second paragraph. The lordship find payment receipt certificate, payment receipt. It is not this context. The lordship will find what are the documents which are to be given, which include the.
So this is financial eligibility criteria. This is not technical. My lord, let us not confuse technical with financial.
Kindly see class, just the page before, page 198. This is technical criteria. Technical 10.1 and note for 10.1.
The part of the eligibility.
Exactly. It's a part of this.
Financial eligibility criteria starts after that.
The technical.
Well, have they said that you've not? Well, the financial criteria is well, something else. Have they ever said this?
This is average annual turnover.
Average annual turnover.
I'm closing arguments on since the documents annexed to the pleadings to the writ petition are sufficient for the purpose of adjudicating the writ petition on merits, comma, further affidavits are not being invited, full stop. It is, comma, however, comma, deemed that none of the allegations made in the writ petition are admitted by any of the respondents. Full stop. Hearing is concluded. Judgment is reserved in the matter. I'll try to be as fast as possible, Mr. Shah. Definitely before 30th of July, 31st of July. Oh no, the financial, the what may be awarded to them.
I don't know, my lord. It could be any day.
In the interim still, till the judgment comes.
But it could be any day. My lord, now that your lordship has heard the matter, my lord, let them not do anything till your lordship considers it final.
Don't issue a work order, Mr. Banerjee. Work order won't. Yes, to you. You will be prejudiced. Till disposal of till passing of final orders, comma, no work order will be issued in terms of the impugned tender.
Supplementary, my lord, I've served on all.
আচ্ছা আরেকটা প্রথমে একটা দিয়ে সাপ্লিমেন্টারি এফিডেভিট filed today by the petitioners be kept on record. তারপরেই প্রথম সেন্টেন্স। Thank you.
Well, same order, my lord, in the other matter. It's identical.
Very well, yes. Same identical supplementary affidavit you are filing also in that?
Yes,
yes, ma'am.
Separate supplementary affidavit. দুটো supplementary দুটোতে ঢুকবে করে একটু একসঙ্গে করে দিয়ে দেব পরে পরে। Thank you.
Great.
My lords, with your kind permission, lordship, may I mention item 29, my lords?
Yes, 29.
My lord,
Yes, my lords. My lords, may I have your kind permission to mention item 29, lordship? My lords, this is that matter, my lords, which I had mentioned pre-lunch, lordship. This is that matter where blacklisting has happened, my lords, for 5 years. My urgency is, my lords, there's a tender which I want to participate in. It's an NTPC tender, my lords, which closes on.
Please give me half a minute. এর পরের আইটেম কোনটা আমাদের? 20 না কিন্তু ইয়ে নো অরিজিনাল সেট না। এটা যেহেতু পরের ম্যাটার এটা তাহলে this will be taken up Monday at the top.
Mellas, and may I request that Monday it may be kept at top of the board, Mellas, because I'm informed, Mellas, that Monday in the Calcutta High Court, Mellas, monthly list will be taken up. So if Mellas would just direct that it be taken up at the top of the board.
Tuesday fairly at the top, Ms. Panda then. Tuesday, supplementary list. Fairly at the top.
Very well, Mellas, very well.
I have you kindly.
Tuesday fairly at the top of the 29, yes.
Item number 40, my lord.
I'm grateful, Mellas.
My lord, the interim order is expiring today. I'm just humbly praying if it can appear on Mondays under the heading extension of interim order. 40 of today's list.
লিখে নাও, নোট করে নাও। 40 to extension of interim order heading.
Item number 40, I appear for the bank. It could have been disposed of here.
Yes, my lord.
Very well. When I take it up for extension of interim order, if you concede to their prayer, I'll decide.
My lord, I would, your lordship has already indicated an interim order. I would.
আচ্ছা, very
grateful, lord.
এই এটা আগেরটা ঠিক আছে। এটাই আমার নোটস। সাবধানে এটা স্টেপল করে রেখে তো হারিয়ে না যায়। এটা না চলে গেলে আবার রিহিয়ারিং করতে হবে। অরিজিনাল সেট।
ক্যামেরাটা আছে। Original side matters.
we mentioned item number 1.
My lord,
Hindustan
item
Petroleum
number
Corporation
1, my lord, appeared as my instance, my lord.
Yes.
In paragraph 14, my lord. Lordship, my lord, stated that while controverting such submission, learned senior counsel, my lord, I am not
Paragraph
14.
14, yes.
Beginning
While
with my lord,
controverting.
such submission, learned senior counsel, my lord, I am not a senior counsel, my lord. Respondent number 3, supplier, and say, and my lord, second, my lord, in paragraph 17, my lord, learned counsel for the, my lord, it will be, my lord, MSME council, not petitioner number 1 council. MSME council.
Respondent number 1.
Respondent number 1.
Respondent number 1 council.
Thank you very
My
much.
lord, I'm humbly praying for an indulgence subject to my lord's kind consideration, since my learned friend is there appearing for the respondent number 3 today, my lord. Subject to my lord's kind consideration, I'm humbly praying because of some medical issues. There will be 2 or 3 days I might not be here. My lord has granted on last occasion, my lord, for 2 weeks time, my lord, for the order.
No modification.
No, my lord.
Learned counsel, sorry. Learned counsel, you're for respondent number 3.
Yes, my lord.
Learned counsel for respondent number 3, comma, in his usual fairness, comma, points out that in the order dated, in the judgment and order dated June 27, 2023, comma, in paragraph number 14, comma, he was referred to as within double inverted learned senior counsel, double inverted clause, whereas he has not been designated the senior gown. Full stop. Appreciating such fairness, comma, let the order stand modified to the extent that the expression within double inverted senior be deemed to stand deleted. Full stop. Next para. Next para in paragraph number 17, comma, it was erroneously recorded in the first sentence that the that learned counsel for the double inverted with the petitioner number 1 hyphen counsel double inverted clause ... whereas it should have been respondent number 1 hyphen counsel double inverted clause full stop. Next para. Let the order dated June 27, 2023 be deemed to incorporate the said corrections, full stop. However, comma, it is made clear that no physical correction is required to be incorporated in the judgment and order dated June 27, 2023, full stop. Instead, comma, today's order may be deemed to be a part of the order dated June 27, 2023.
Yes.
Item number 2, Haldia municipality versus
It is
Hoshia
my
construction.
instance, my lord.
Extension of interim order.
It is not extension of interim order. May I say this, my lord, the clear picture? Well, there is a MSME award. Now, my lord, they have filed an execution. I challenged under 34. Now, they pointed out, my lord, section 19, there's a precondition of, my lord, entertaining 75% deposit. Now, I say that I have taken out a demurrer application on the ground that the MSME didn't have a jurisdiction at all. And my lord, so far as I try to distinguish between the filing and entertaining, my lord, if I do not deposit 75%, it cannot be entertained. But so far as the filing is concerned, there was a certain time limit given. Now, since my demurrer application is also might be on board, and my lord, the honorable court having jurisdiction may take up the issues. And in the event, my lord, I do not deposit, they would proceed under section 36. So I require sometimes, my lord, in course of that, if at all, my lord, I do not succeed in demurrer, well, some, my lord, 2 months time. My lord.
It was regarding a section 37 appeal.
No, it was with regard to 34. Because they say,
appeal,
yes, now MSME says, my lordship is our section 19 says the entertaining 75%. Now, with all humbleness, subject to, of course, my lord satisfaction, the entertaining is something, my lord, not very similar to filing. Now, my lord, that cannot be, my lord, at a threshold, my lord, I cannot be put out of the court, my lord, but since if I do not deposit, and they have a remedy under section 36. In the event I do not apply for 36(2) also.
Entertaining is at a much preliminary stage.
Yes, but so far as
it won't be taken on board even.
No, but
even for hearing your
yes, of course, I understand. But so far as filing is concerned,
I don't have the determination under.
Well, the lordship for the time, because the time limit that was given to me.
This was a section 9 application.
No, this is 34 application. The time limit that was given to me for deposit the money, that is up to 30th June. And now in default, there is a default clause also. I seek some extension, my lord. in the event, my lord, my demurrer application, if I could not succeed. I am also a state body, my lord, because I was, there's some public money, my lord. And they have themselves admitted in the MSME applications that their jobs are concerned with regard to the civil works.
Yes, what do you say to this?
I'm for the respondent in this matter.
So I'll give the extension for the limit.
The orders are made in my lord's brief. Orders and my lord's brief.
Such period would be, my lord, abuse of the process. My lord.
Why do you say that?
My lord, see the below the last 2 pages, my lord. Below the
Which
award
order?
was made. Award would be below 69 lakhs, my lord. Below this respondent, below the took loan from various lending organizations, my lord, and he's under tremendous pressure, my lord. My lord, see, they have admitted before the
What pressure? Please switch on the microphone.
tremendous pressure.
Switch on the microphone, please.
Lordship, I should not say before your lordship, he said that he desired to suicide. But I should not say this before your lordship, my lord. My lord, see, my lord, before the arbitration authority, my lord, they admitted the amount. They said, my lord, because of paucity of fund in, my lord, August 2000, my lord, 22, say, my lord, that they, because of paucity of fund, my lord, it can't be paid. They have admitted that I am entitled to receive the amount, my lord. See, lordship, my lord, section 19 application, my lord, at page 32, once, my lord.
My lord, MSME cannot have a jurisdiction or it cannot be created. I say that in the event some funds are being given by the
Executive, Mr. Vasu, I'm hearing him.
Lordship, page 33, lordship, see, my lord.
Yes.
That is paragraph 6, my lord. That we have already communicated a letter to the Joint Secretary Urban
Page
Development.
33.
Lordship, page 33, lordship. This is my lord, my application under section 19.
19 application কোনটা এটা? এটা 34 application যেটা। That's annex 19 application টা লাগবে। No, 19 application is annexed here.
No, that is not separately made, my lord. After they filed 34, my lord, I made section 19 application, my lord, and then his lordship, my
কোথায়
lord.
সেটা? এটা তো original 34 টা।
Lord,
I don't
Lord,
find it.
It should be on the record, my lord. Section 19 should be on record.
What
If
was
a
the number
lordship-
given to it?
That is, my lord, IA number GA 1 of 2023.
তাহলে সেটা তো record
May
file.
give for this purpose, my lord, for today, may give my copy, my lord, once. my
No,
lord.
please wait for me. আসেনি সেটা? কেন? পুরো রেকর্ডই তো আসবে। পুরো রেকর্ড আসে না অরিজিন সাইডে? তাহলে you have served, you have got a copy of the IA? Please give me a copy, hand over a copy.
My lord,
No, I'll take
what
his-
he is trying to show.
No, let him show that.
Wait. No,
Just because you have handed over the copy, Mr. Vasu, does not give you a right of it.
I never said so. My lord, lordship,
You are doing it, please take your seat. You have a seat behind you. Please take your seat. Yes, Mr. Jaiswal.
My lord, at
You,
page-
Mr. Jaiswal, I
Yes,
suppose.
lordship.
Yes, what is
My
it?
lord, as page 33, lordship, can you see paragraph 6? That we have already communicated letter to the Joint Secretary Urban Development of Municipal Affairs, Department Government of West Bengal, my lord, such and such address, my lord, for release of balance amount, but till date we have not received the said balance amount of rupees 54,95,065. This is the exact, my lord, principal amount, and my lord, the 69 biggest, my lord, after, my lord, adding interest, my lord. My lord, on receipt of the said balance amount, the agency will be paid.
Have you levied section 30? Have you levied section 36 as it? Enforcement?
Yes, my lord, I filed, my lord, my execution application. That is why, lordship, can you see this order, my lord? This is readily available, my lord. Oh, ওইটা আমাকে দিন না,
Handed up.
যার সাথে আমি দিয়েছি এটা my lord, on 10/4/23, Honorable Justice Sharaf, my lord, directed, my lord will find that the court in such and such, which is a section 34 application filed by Haldia municipality, it appears that the pre-deposit as required under MSME Act has not been made. In light of the same, the petitioner is directed to make the deposit of 75% of the award sum within period of 4 years from the date. In the event
The
non-deposit,
appeal has not been entertained. There is obviously no stay of the award.
my lord,
Have you levied your enforcement? Have you levied, enforcement or execution, whatever you say?
yes, I have,
Section 36 has been filed.
yes, filed, my lord. It has been filed, my
When
lord.
did you file that?
I filed, my lord, well, my lord, this is after, my lord, he filed section 34, thereafter I filed, my lord. And, my lord, this is section 19 of the MSME Act, my lord, says, my lord, pre-deposit is mandatory, my lord.
Cite me the, show me the section once, please.
Yes, sir.
MSME acted to the linguistic to the.
May I please, my lord?
Yes.
Section 19, no application for setting aside any decree, award or other order made either by the council itself or by any institution or center providing alternate dispute resolution services to which a reference is made by the council shall be entertained by any court unless the applicant, not being the supplier, has deposited with it 75% of the amount in terms of the decree award. Lordship, I have, my lord, if Lordship kindly permit
And
me-
show me the limitation period for filing the taking out that is in the Arbitration Act itself.
Lordship, if Lordship permit me, my lord, India Kanun, my lord. May your Lordship permit me to place, my lord, this is the case of, my lord, Honorable Supreme Court, my lord. My lord, see the paragraph 6, last page, my lord.
Give a copy to your learned friend also.
Lordship. See, my lord, last page, my lord, paragraph 6. In view of above discussion and for the reasons stated above, the person appeal, present appeal.
75% is mandatory. There is no dispute regarding that. He's asking for an extension for the time to file, put in that 75%.
My lord, my
Only
decision for
that.
submission-
70, without 75%, they cannot prefer an appeal. That is well settled. You need not cite any judgment for that. The section is very clear.
But Lordship kindly
Section is in negative language. No application shall be entertained.
My lord, in August, they are saying, in August 22, they are saying because of positive fund, we can't pay. My lord, today also same, my lord, same words are, my lord, said before your Lordship, my lord. If time, your Lordship extend, kindly extend.
When was
for
the award
2 months.
passed?
My lord, on 17th August 2022, Lordship. Before the arbitrator, my
Wait,
lord,
let
saying
me hear him on this. Yes, please take your seat. This is all. Anything is yes. Yes, Mr. Basu, how long do you want extension?
My lord, in section 19, my lord, as the language is emptied, my lord, kindly have a, may I permit to read once again? No application which starts with a negative language is mandatory. I do not say so that I only say, my lord, if a lord should look, kindly read it with
In the other
with
order
me.
court.
My
Yes,
lord,
read it the end of the first.
shall be entertained by any other court unless the appellant, not being a supplier, has deposited with it. Now, my lord, my bone of contention is, my lord, neither he could be a buyer, nor I am a supplier, or the vice versa. And the MSME doesn't have a jurisdiction, my lord, to decide on the issues. That is a very, my lord, root of the jurisdiction. And what I say over here, my lord, I only say, my lord, kindly grant me some more time. I am not.
How
my lord,
much?
my lord, 60 days, my lord, at least for the, because my demurrer application also, my lord, I am on instructions, will be on the board before the honorable judge.
Demurrer application cannot be taken on board unless you
No,
cannot be decided
no,
unless your appeal is.
demurrer application with regard to his 36. Because my
Demurrer application cannot be taken. I mean,
no, demurrer applications are subject to corrections.
demurrer application is pending before the 36 court.
Yes, 36. So
how does that have a nexus with this?
No,
Section
my lord,
35.
no, in the event, my lord, if I can get a declaration that is award is a nullity, then, my lord, of course, my lord,
No, that does not take away your right. I mean, section 34 remains. That prerogative of you remains.
No, prerogative. My lord, but in the event, kindly appreciate one thing, my lord.
You
In
cannot
the-
wait indefinitely for
No,
that.
I do not say so, my
So I
lord.
want to
I do not
extend
say
the time
so.
for
No, I do not say so. Then kindly give me a time for at least 4 weeks.
2 days. Within Tuesday, you have to deposit.
My lord, how
You have
could,
got sufficient time, Mr.
my lord,
Basu.
how could I, my
10th
lord?
of April, from 10th of April, you have got time. You cannot take further advantage of your demurrer application before the section.
My lord, even I tell you, lordship, the board is also not functioning. There is no municipal board, no election. The board has got defunct.
Nothing doing.
My lord, for the last 8 months, there was no election. My lord, is entirely, my lord, I am.
That the award holders cannot be.
My lord, but he has a right to proceed under section 36. The law does not prevent him. My lord, kindly appreciate this much. Lordship has himself, my lord, appreciated that who has prevented them, he can proceed 36 in as
1 week, Mr. Basu, 1 week.
My lord, kindly give me 4 weeks as a last time, my lord.
4 weeks as a for
No,
the
no,
last
no,
things.
I'll refuse that.
Now, my lord, may I
You
also
have
say
got
this?
two remedies now. One is section 34, the other is your demurrer application in section 36.
Yes, at least for
Section 36 demurrer is allowed, then you are saved for the time.
yes, that is why my
And
kindly
your section 34 still remains. I mean, it is independent of that demurrer.
demurrer. But so far as in
That
the
right
event
will
the
go.
award
If I don't
goes,
give you that extension, that right will go at base.
yes, in the
Your
event,
section 36 demurrer remains. That has no connection with this.
no, so far as my demurrer to 36, which challenges my lord the very root
Proceed
of the
with that.
award.
Who asked you not to?
No, my lord, in
Proceed
that
with that.
I do proceed. My lord, kindly give me at least some indulgence.
That has no connection with this.
At least, my lord,
I'll give you 1 week.
kindly do not make so. My lord, kindly do not make so.
Learned
At least
counsel
give me-
for the
my lord, give me 4 weeks time. My lord.
petitioner, Haldia municipality
For the last
submits that the municipality has not been functioning for a long time now due to the pending elections, etc. Fullstop, it is submitted that due to unavoidable circumstances, the municipality could not collect the amount of 75% of the awarded sum for the purpose of making a pre-deposit within the contemplation of section 19 of the micro, small and medium enterprises Development Act, 2006. Full stop. Next para. Learned counsel for the respondent vehemently opposes the said prayer and submits that the award holder, that is the respondent here in is suffering indefinitely for the delay occasioned in the petitioner making the pre-deposit. Full stop. It is submitted that in the absence of such deposit, the appeal, the challenge under section 34 of the Arbitration and Conciliation Act 1996 cannot even be entertained. Full stop. Next para. Although learned counsel appearing for the petitioner seeks to cite CIT, the pendency of a demurrer application filed by the present petitioner in connection with the enforcement application taken out by the award holder under section 36 of the 1996 Act in connection with the award, the same does not, in the opinion of this court, have any nexus with the present plea. Full stop. Next para. The remedy of demurrer available to the petitioner, if at all in law, is a distinct and separate remedy from section 30 from a challenge under section 34 of the 1996 Act. Full stop. Next para. Insofar as the present prayer of extension of time is concerned, it is seen that on a previous occasion, that is on April 10, 2023, a coordinate bench, on a similar prayer by the petitioner, had granted 4 weeks time from the said date for the petitioner stroke appellant to make the deposit of rupees 75% for entertaining the challenge under section 34 of the 1996 Act. Full stop. Next para. However, the petitioner failed to do so, and upon a renewal of the same prayer, on May 8, 2023, the learned single judge again extended the time till June 30, 2023. Full stop. On both such occasions, it is noteworthy, the learned single judge observed that in the event of non-deposit, the application shall stand dismissed. Full stop. Next para. Due to the laches of the proposed appellant stroke present petitioner, the award holder cannot suffer indefinitely. Full stop. Since an award has been duly passed in favor of the present respondent, there is no further occasion or cause made out sufficient to grant extension as sought for by the petitioner. Full stop. However, as a last chance, for the ends of justice, the appellant, the time for filing, time for depositing the amount of rupees 70 amount of 75% of the awarded sum, comma, as a precondition for entertaining the appeal of the petitioner is extended till July 10, 2023. Full stop. Next para. It is, comma, however, comma, made clear that in the event the said pre-deposit is not made by the proposed appellant stroke petitioner on or before July 10, 2023, comma, no further extension would be granted, and the challenge under section 34 of the 1996 Act would be deemed not to be entertained. Full stop. No rest to none.
One small request. I'm told that the election will be over on 13th, but at least up to 20th. But there is no administrator also, Malad.
Move with your section 36.
No.
I mean, your demurrer.
That I do, Malad. 13th is the date of election, the result. My lord had said 10th. At least, Malad, 3-4 days more beyond 13th.
No.
Malad, the 13th is the date of declaration. For 7 days, Malad, heaven will not fall. Malad, kindly do that.
Heaven may fall. How do you know?
Heaven
may fall for this person.
Kindly.
Not for you, not for me, Mr. Vasu. For this person, it may fall.
For 7 days.
This is already closed probably. Heaven may fall for this person.
For 7 days more.
Notion of heaven is very relative. It may fall for this person. No.
Deeply grateful.
Thank you. Next matter.
New motion, section 11, item number 3.
Yes, Mr. Shen, what is that?
Application under section 11.
Served on the other side. You're for the other side.
My learned friend on the last.
Take an instruction.
Yes, the only instruction is that there is no denial of the fact there is an arbitration clause. So I'm not on that. But the scope of dispute is ideally, I would say, it is very limited. If your lordships only sees paragraphs 25, 26, and 27, that is the crux of the dispute. If this can go before a mediation center for 2 months by keeping this pending, I tell you, avoidable cost. This what will happen? Let me submit it.
Let it submit in your reply. You will make your argument.
Yes, I'll obviously
will not have a further chance of reply.
Then I'll do that.
No, you don't have.
No. Let us.
Yes,
No,
yes.
only thing is that why not I'm not responding to this proposal of mediation, not generally, because what has happened, there is an internal mechanism under the contract which they have invoked. Show cause notices have been issued 4 times. Twice it has been closed.
That is for conciliation, internal.
No, show cause internal, if suppose they can, if there is any grievance, yes, it is by their authority.
Their authority.
They are issuing a show cause notice for foreclosure. 4 times it has been issued, and there is a time limit given under their own contract. If a show cause notice is issued, how much time they will take to bring to its logical conclusion. So, my lord, even the 3rd show cause notice, I have given a reply 1 year back. No steps taken. Then a 4th show cause notice has been issued. I have given a reply, but the moment I issued a section 21 notice, they give a reply that I am going to hold a hearing and foreclose. So, my lord, this mediation, I can respond to this by saying that even before an arbitrator who is appointed, before filing of statement of claim, if my learned friend comes up with a proposal, we can try for a mediation and conciliation there. That would so, my lord, just before going to a mediation will not help.
You don't agree that is sufficient, Mr.
Your so, my lord,
yes.
And the arbitration.
Where is the arbitration clause?
Yes, arbitration clause, page 34. I have also, in my section 21 notice, relied upon the Parkins judgment and said that dispute cannot now be referred to the vice chairman and principal secretary of the department.
This is the Parkins disease.
Yes.
Yes, very well.
Yes.
So it has to be an independent arbiter.
Yes, it has to be.
What is the approximate valuation of the dispute? I mean,
It is actually, my lord, my principal dispute is payment of a 2nd installment. Because the payment is not being made, I cannot go ahead with my obligations under the contract.
I'll appoint an
Also,
advocate.
this is a service contract. First of all, this is a service contract, and obviously
everything the arbitrator
yes, so
can
this
decide
is
now.
Only one thing, lordship. Before
Senior person,
before
claim is substantial.
then that has be lordship. They'll kindly have a retired judge, your lordship, retired judge of this.
That I above
because
5
otherwise. If it is above 5 crores, a retired judge of this court.
Choose a judge.
I leave it entirely to your lordship. Except
That is the
obviously,
difficult part.
except obviously the nominee by them, any
I have
other.
not given
Yes,
nomination.
You nominated as the retired judge.
Yes.
Who did you nominate? I'll have to exclude him or her.
Yes, Ms. Devi Prasad.
Oh, Justice Devi Prasad De.
What is the difficulty?
I don't.
Lordship, any other.
Because they have.
That is the problem. Every time I always advise not to nominate. It's better. Otherwise, the person is excluded.
So what I was only suggesting this.
You have a choice of
can
judges.
happen. This can happen, but considerable costs and expenses can be avoided because only this part is to be
Justice
seen.
Devi Prasad is very costly.
No, I am not on the person. I am only on the mechanism. If
My
they
learned
can
friend is
go to
suggesting
a mediation, if you can go to a
If the
mediation.
mediation was possible, it would have been done by.
But
Instead
that
of
was-
issuing
that was-
4 show cause notices,
that
you would
was-
have done
that
that.
was- that-
This is just a ploy of your
As
client
as
to
a matter
solve
of
the
fact,
proceeding.
as a matter of fact, the claimant had the option to foreclose it. That is already there in the court. So that they didn't do. They are also waiting for 4 years. It is already there in their petition.
Since there is no agreement between there is no consensus between the parties regarding arbitration, the present application under Section 11 of the Arbitration and Conciliation Act 1996 has been taken out. For sub next para, it transpires from clause 9
Yes.
of the Memorandum of Understanding dated August 30, 2017 between the parties that the same clearly contains an arbitration clause which covers the dispute which has arisen at present between the parties. For sub next para, a perusal of the said clause, as rightly pointed out by learned counsel for the petitioner, indicates that the proposed arbitrator therein is an employee of the respondent and, as such, is considered ineligible within the contemplation of Section 12 of the Arbitration and Conciliation Act 1996. First up, next para, hence, an independent arbitrator ought to be appointed. First up, accordingly, the AP number 405 of 2023 is allowed, thereby appointing, just a given name, any judge. Justice Robindranath Samanta will appoint. He has just retired. I'll appoint Justice Robindranath Samanta. He's in the habit of adjudicating still. As appointing Justice Robindranath Samanta, a retired judge of this honorable court, as the sole arbitrator to resolve the dispute between the parties, subject to obtaining his declarations to consent under Section 12 of the 1996 Act.
Court application, item number 4,
And for the
cut
petitioner, my lord.
housing solutions.
Yes. I'm sorry, my lord, yesterday I could not appear and your lordship is actually graciously
Accepted.
giving me
Mr.
a chance.
Kankan is fair enough not to do in,
No, my lord,
in
actually, sir,
absentia.
He's my learned friend, my lord, very close friend of
Yes, Mr. Dutt, what is the matter?
But this is my lord, second round of litigation before this honorable court, my lord.
Only one thing before my learned friend starts, my lord, this issue is now pending before the NCLT, my lord. This
My lord, I will
under
say-
273, my lord.
Let me complete. Let me complete, my
Yes.
lord. My lord, in the year 2015, they have issued a notice to me under section 206 subsection 4, directly 206 subsection 4.
Of what?
Sorry, my, this is of my company act. Your lordship may kindly see my lord, company act, my lord.
Say that.
Sorry, my lord. I'm sorry, my
No,
lord.
it's all right. Yes.
No, my lord.
So then what happened?
Nothing like that. Actually, that issue, my lord, closed. Thereafter, my lord, in October 2021, they again issued me the notice on the same facts, my lord. They issued me the notice under section 206 subsection 4, my lord. So that section has a, my lord, 2 parts. This so actually kindly your lordship may have that book. 206 subsection 4, my lord. So this is my 2 specs, my lord. They can directly actually they must seek the information where 90% of the documents are beyond more than decade, my lord. Whereas, my lord, as per section 125, sorry, they cannot demand a document beyond 8 years, my lord. So that issue is still closed, but I'm just referring to your lordship, my lord. So they have, my lord, asked
064 of the
Yes,
Companies Act
206
2013.
subsection 4 of the Companies Act. My lord, I'm coming to that section after reading one judgment of the second round of litigation. My lord, I will read that.
Let me see the scope of that section first.
No, my lord, that section was not dealing with, actually, because that issue has been decided by His Lordship Justice Manta in this first round of litigation. I'm coming before your Lordship, my lord. So actually, my that 206 subsection 4, my lord,
What have we challenged here?
no, I'm coming. That order also not complied with, and again they jumped without complying that order. What His Lordship had stated that, my lord. So 206 subsection 4, I raised before His Lordship the 2 points that they cannot come to directly 206 subsection 4 because actually because it had 2 points where the affairs of the company is being carried on. So then they can directly jump to 206 subsection 4. But if the company, if the affairs of the company has been carried on, but this is very clearly stated in the proviso of that. Okay, that section. So then they have to come from 206 subsection 1, 2, 3, 4 by recording a reason. Because section 203, section 206 subsection 3, when very mandate said that after recording a reason, so then only he can jump, my lord. Here, my lord, the entire allegations was of more than decade, but which law will not permit them to ask at any point of time, my lord. So, well, actually, so in that reply to that notice, I prayed for certain times to actually search that documents. Where are they? It is not with me because I'm not actually supposed to save that document. They issued me a summon, my lord. Right. So actually, my lord, then I come before you, this Honorable High Court. I'm at page 40, your lordship. This is the order of the Honorable Justice Manta. I am reading, my lord, that order. Yes, please. Page 40, my the writ petitioner is aggrieved by the notice dated 11 October 2021, issued by the respondent number 1 under section 2064 of the Companies Act. So counsel for the petitioner would argue that the notice is defective and contrary to the provisions of section 206 of the Act. It is firstly argued that the decision under section 2064 of the Act cannot be taken without calling for document assigning reason. It is only after recording satisfaction that a proceeding under 206 can be taken out. In respect of subclause 4 of section 206, it is argued that without complying with the subsection 1 of the proceeding under subsection 4 are rather premature. It is also submitted that the notice and inquiry is also without jurisdiction since it involves matters that are more than 8 years old. My lord, that section I will also read before your lordship, my lord. So, my lord, that your lordship, then I'm coming to, my lord, that your lordship, last paragraph. This court is of the view, but that is his summation, my lord. This court is of the view, but that was the directions where the respondent must take a suitable decision on either the representation dated this month, that is a typographical error, the representation, that is the 18 the November 2021, that is, my lord. And the petitioner's argument as contained in the application in course of adjudication, my lord. So where, my lord, the most about that his lordship has reverted the matter back to them to consider my allegations in the petition and do adjudication, my lord, in course of adjudication and passing the final order, my lord. The petitioner shall be entitled to file appropriate reply to the notice in the 206 within the period of 3 weeks, by which manner I filed that reply, your lordship. Upon receipt of such reply, the registrar shall take appropriate steps in the act of 2 and applicable to thereunder and dispose of the said proceeding within a period of over 2 months. Still that, till now, they have not disposed of that proceedings. They might consider my reply. I filed a reply. They have not adjudicated. They have not passed any order. And thereafter, my lord, I filed an application for.
To understand the scope of this adjudication, Mr. Dhatt, what is the scope of any adjudication under section 2064?
2064 is, my lord, because they have
took out they issued a section 2064 notice,
which they were not. Which I have challenged that
you had challenged, you had filed a representation in that was by in the nature of a reply to that.
In the nature of in reply also I challenged that you cannot ask me the documents before
whatever ground, but it was in the nature of a reply to the 206 challenging their jurisdiction, their authority to issue that even.
Yes, ma'am.
That was directed to be decided on by Justice Mantha.
No, but his lordship said that I'm not entering into the merit, and his lordship particularly stated that
no, he's not entering into. Obviously, he could not enter into.
Yes, my lord, that is my
the authority were directed to do what? Look into your representation and decide it.
Look at your representation along with this petition also. The writ application along with the allegation raised.
Along with the arguments as raised in the writ petition.
Writ petition.
Yes.
So, and pass a recent order within 2 months, my lord. So they have rejected now, till not, they have not.
Final order, not reason. Reason was not read.
No, but that might
Too much
because-
reasons is not required in this.
No, but no
I
time.
mean, in an adjudication, whatever quote unquote adjudication on a representation, how far can we go? I mean,
No, but
so
still-
anyway, they did that.
No, they have nothing done. I mean, they have
After that, what happened after this?
I'm
Please let me-
disputing that, my lord.
Please let me complete. My lord, they have-
Disputing the order.
My lord, no, no,
No,
no.
but
We
they
have
have-
said on the basis of the representation, we passed an order, my lord.
No, but that I'm not demanding.
What have they done after this?
Actually, my lord, they have nothing communicated to me, not passed any order, my lord. So till now, my lord. So but they have directly jumped. No, they have directly jumped to section 272 for they have issued a notice for winding up, my lord.
Acha.
Whereas my remedy actually before them, but even if they want to award this order by passing order by
What are you challenging here? 272 maintainability?
Yes, but that notice I'm sending that they cannot directly jump to 272. There's a remedy under 200.
Don't you have any other remedy apart from the writ court?
No, my lord, your lordship, they must pass this order within 2 months. Suppose, my lord, they are saying that still have committed the frauds or certain things are extra, then there is a remedy under section 210 of the Companies Act. They must report to the central government. Central government may appoint SFIO. I am praying for that man SFIO be appointed on me, my lord. So this is the continuous of
What
the,
are you asking for? That quashing of the 272 petition?
Yes, but that notice, they,
What are you asking for?
yes,
Are you asking for that?
270, before
Let me hear
before
what they
completing
have to
this,
say.
my lord.
So
Before-
that is your case. They have not complied with this order of Justice Mantha, and therefore they could not file 272, which is the next step.
Yeah, but directly jumped.
Let us hear them. Yes, Mr. Kankani, yes.
My lord, kindly comes to page, my lord, 47, my lord. What has he challenged actually, my lord? Page 47. My lord, that order which was passed by Justice Mantha has been complied with. They were given a reason. Now, this is a notice, my lord, if your lordship kindly sees. Notice under second proviso of subsection 3 of section 272, my lord. Now, my lord, this is a provision, my lord, under which this company has been recommended for winding up. Now, my lord, may I draw your lordship's kind attention to 273, my lord. And they're contesting there, my lord. Now, this is just an attempt, my lord, to stall that proceeding, my lord. 273, my lord, may I place powers of tribunal? The tribunal may, on receipt of a petition for winding up under section 272, pass the following orders, namely dismiss it or with or without cause. So, my lord, on merits, they can submit all points, they can argue everything, my lord. My lord, it is not the case that the notice is without jurisdiction, my lord. That notice this notice at page 47 is within the jurisdiction of the, my lord, office of the registrar of regional director, my lord. And my lord, he is trying to mix two issues, my lord, which have no connection, no nexus, my lord. This is the notice, my lord. May I place this notice before lordship now at page 47, my lord. Whereas in his inquiry report, the ROC has inter alia reported that, my lord, then there are the findings against him, my lord. And if your lordship kindly sees, my lord, my learned friend is very much troubled that we have asked for documents which is more than 10 years, 12 years old. If your lordship kindly comes to page 48, my lord, the last 3 paragraphs onwards, my lord. Further, upon perusal of the financial statement filed by the subject company for the financial year 16-17 to 19-20, it has been observed that the ROC, it has been observed by the ROC that the subject company has given loans to Messrs. Shri BD Ispat Private Limited. However, on perusal of the books of Messrs. Shri BD Ispat Private Limited, it has been observed that the company has not disclosed any borrowing loan taken from the subject company during the financial year such and such. Hence, it is evident that the directors of the company have given false material particulars regarding the loans given, knowing them to be material in the financial statements of the company for the above mentioned financial years. In view of the above, ROC has concluded that it is evident that the main motive behind formation of the company was to provide accommodation entries and to siphon off funds to bring back the unaccounted money.
Kankani, I can't understand. This is even prior to presentation of a winding up petition.
This is prior to that, my lord.
Prior to that, because
My
this is
lord.
a show cause where they are entitled to give a representation. Upon hearing their representation, whatever decision is taken, then
My
the
lord.
central government shall obtain, shall grant a sanction. Only then the registrar can present the petition.
My lord, the registrar has presented this notice, this report to the office of the RD, my lord. This is a notice being issued by the regional director, my lord, on the basis of the report of the
So
registrar.
he just has to go under section 272(3),
My lord.
second proviso. This is provided further that the central government shall not accord its sanction unless the company has been given a reasonable opportunity of making representation.
My lord.
So he has that opportunity of making the representation now.
This notice was sent 1 year back, my lord, in June 2022.
What was done after that?
Well, after that, my lord, as far
petition has been filed.
writ petition has been filed after, my lord, now. And the matter is already proceeding before the NCLT. Only the reason is, my lord, the attempt by the petitioner is to.
No, Mr. Kankani, after
My lord.
that winding up petition was filed.
Yes, it has been filed and they're contesting that.
After government gave the sanction.
No.
Yes,
Please
yes,
don't
my
do
lord.
No, this was consent.
Pre-filing,
Pre-filing.
my lord. This is a show cause notice.
After the, what was the follow-up of this?
Follow-up of this was, my lord, this proceeding was filed before the learned NCLT, my lord.
No, they were given that opportunity.
Yes, this is a show cause, my lord. If your lordship kindly sees,
Give a copy to your learned friend also.
my lord, he is, I will, please take this.
That much I know, your lordship. It is
My
fine.
lord, kindly see page 49. We are asking him for an answer.
Hmm.
Page 49. Now,
What
therefore,
happened
the
after this? They did not give an answer.
my lord, I will have to take instruction on this, whether they have
Answer
given a
is
reply
annexed
to
with
this
that,
or not, my lord.
This is annexed with the answer is also annexed with that, my lord.
Can you
That
please
is
point
not-
out? Can you please point out this in the writ petition?
Next page continuously. Why you stop that? 47 thereafter the page 50 is answer.
My lord, now his answer is, if your lordship kindly takes page 52, the said notice is barred by limitation and bad in law. Well, now all these, my lord, the jurisdiction is not denied, my lord. Whether it is barred by limitation law, my lord, that the appropriate forum is the learned NCLT, which can decide on merit, my lord. It can dismiss the application, my lord, if it finds that there's no merit, my lord. My lord, coming.
NCLT, what is the stage before the NCLT?
My lord, they have taken time, my lord, to file a reply, my lord, there.
That means last month, my petition has been served on.
So take all your points in your reply.
Well, I'm not saying your lordship that.
Where is the occasion of challenging this show cause notice?
But what I'm saying, your lordship, the same things were there, the same allegation which is under 206 subsection 4.
Let the NCLT decide this.
No, your lordship, I'm not saying that. Let them decide, but let them reply. Why not they concluding these things, my lord? This 206, which the Honorable High Court told them to say 206 and 207.
So that they are saying that yes, you replied to this, and not only that, after that sanction was given by the government, after the central government gave the sanction, the quantum of petition was placed.
My reply is not what I'm demanding.
So then I'll direct affidavits in the matter.
Let them say. Let
But
them
saying
comply.
that they have to file affidavits, that will stall your writ petition indefinitely. Definitely, I won't grant any order of stay of all further proceedings in the
Yes, your
NCLT.
lordship,
That I won't give. Why should I?
His lordship has given.
What
me
is
a
the
letter,
utility of filing this writ petition, Mr. Dhatt?
No, my lord.
I will disclose everything,
No,
my
what
lord.
I'm
Kindly
saying-
passes the
I'll
direction. I
give
will
liberty to you to take all these points before the NCLT in your reply.
My lord,
And you can file a supplementary reply also if you want. I'll give that
His
liberty
lordship,
to you.
page 42, my lord. Kindly see. Page 42, where which is his lordship order, my lord, Justice Mantra's order.
Just one.
See, lord paragraph.
Whether that has been violated or not, that has to be considered
No,
on
violated. I'm not saying violated, because my lord, but the right this honorable court has given me to pursue the remedy after getting this decision.
But
that
you
I
are
passed.
misinterpreting this order. This could not have been an elaborate hearing like a suit.
No, my lord, elaborate hearing, but 3-4 days his lordship was heard, my lord. My learned friend was there also. It was not that at the end of that day, his lordship said that, okay, I'm not entering it into petition, but these things will be considered. But these were 3 days continuously heard by his
So
lordship.
this adjudication was not made.
Nothing made, my lord. Not communicated.
But according to you,
That
this was not made. What about the justice?
No, my lord, I'm disputing this. Kindly allows me to put an affidavit, my lord. I'll confront him with
There is
this.
the order, my lord, that order not communicated, your lordship. They made have
Kindly
I'll
records
direct the
this.
affidavits.
Kindly, my lord, kindly records, my lord, this submission of his. My lord, I'll come back.
I'll
Yes,
record
my
your
lord.
dispute also.
My lord, my lord.
Learned counsel for the petitioner alleges that in contravention of an order dated December 8, 2021, passed by a coordinate bench in connection with WPO 1183 of 2021, WPO 1184 2021 and WPO 1186 of 2021, whereby the respondent authorities were directed to pass a final order, upon giving an opportunity of filing reply to the petitioner to the notice under section 206 within bracket 4 of the Companies Act, 2013, no such adjudication stroke decision was taken by the respondent authorities. Full stop. However, thereafter, the respondent authorities directly resorted to issuing a show cause notice under the second proviso to subsection 3 of section 272 of the 2013 Act. Full stop. Next para, it is argued that such action on the part of the respondent authorities was palpably illegal and jumped the steps stipulated in the statute. Full stop. That apart, the order being in the action being in contravention of the coordinate bench direction, comma, is vitiated in law. Next para, learned counsel appearing for the respondent authorities controverts such submissions and submits that the order of the coordinate bench was complied with duly by taking a decision thereon. Thereafter, comma, the respondent authorities, comma, that is the registrar of companies, comma, in pursuance of section 272 of the 2013 Act, comma, presented a petition for winding up of the petitioner company. For such purpose, comma, a show cause notice was initially issued under the second proviso to section 272 within bracket 3 of the said act, and after getting due sanction, comma, the winding up petition was presented. It is further argued that the said winding up petition is at present sub judice before the NCLT. Next para, it is sought to be argued that the petitioner is trying to stall such proceedings. Next para, the plinth of the arguments of the petitioner in the present matter is alleged non-compliance of the order of the coordinate bench in not giving an opportunity, in not deciding on the reply of the petitioner to the notice issued under section 206 within bracket 4 of the Companies Act 2013. Although there is some justification in the argument of the petitioner that direct action under 272 was arguably not maintainable in the absence of all provisions under section 206 having been exhausted prior to the same, comma, the said point can very well be raised before the NCLT itself. Next para, however, comma, since factual disputes have been raised by the parties, comma, the respondents are directed to file their affidavit in opposition within a fortnight from date. Reply, if any, shall be filed by a week thereafter. The matter shall be listed in the monthly list of August 2023 for hearing. Next para, it is made clear that it will be open to the petitioner to take all points taken in the writ petition before the NCLT in the pending winding up proceedings. In his reply, it is further recorded that nothing in this order shall prevent the NCLT from proceeding duly in accordance with law with the winding up petition at present pending before it in the light of the observations made herein.
Highly grateful, my lord.
Thank
Highly
you very
grateful.
much. Take all your points and
Yes,
come
my-
back.
That I know, but that's why I will not pray for any stay. my lord.
After that, Siddharth, come back and not press this application.
Yes, your lordship. That I will, actually for that reason I have not pressed for any stay, my lord. I have not prayed for. I know that. my lord.
Infant